Lad, may I have your lordship's leave, lad, to move this petition, lad, regarding lad, whole block at Deucham, lad, without following any procedure of law, lad. They are going to lad, initiate lad, work lad,
They are?
lad, this authorities, lad, whole India, lad.
Yes.
Lad, they will start work by January, lad. That lad, the chief secretary of the state lad, has visited the place. Lad, we have seen the records now from the lad, the clearance has been given lad, without following any procedure.
How are you affected?
We are the trade unions, we are given triple 1 year back. And after this, we have again reminded them that we have given a letter 1 year back, follow this procedure and initiate.
What is the procedure that is not being followed?
Public consultation not done, mining plan not approved.
You have a right to say anything.
Yes, we are the trade unions.
Yes.
We have right. Our workers are doing work around the places.
Yes.
Mining work. If the mining work started, then this petition will be infractuous, without following procedure of law.
I cannot follow, but nevertheless, since you say it is very urgent, day after tomorrow, serve.
My lord, it is my lordship. My lord,
Microphone, please. I cannot hear.
My lord, I am praying for leave, my lord. It is urgent, my lord. The SDO is adamant, my lord, to demolish our my lord construction. Hearing has been made, my lord, on 16 January, my lord. It is adamant. He is not, my lord. The one
Hearing has been done, but then no order has been passed.
Order has been, they give me only these sometimes 15 days.
15 days, you file it in the department. In case any date is fixed, then let me know. File it in the department.
My lord, only say he given the time, my lord.
You file it in the department, yes.
My lord, may I be permitted to mention this, my lord, urgency is that in this matter, it is in the list of your lordship. This is a bunch of my lord petitioners. My lord, the one tender notice has been given in the year 2021. My lord, for the purpose of election work regarding my lord, the police to stay there, the SSC and the other person. My lord, 3 crores and 5 lakhs rupees is already my lord incurred by these contractors. No payment has been initiated. Though executive engineer and the superintendent of police of the Purulia Mala district written to the inspector general to sanction the approved as per the approved plan, everything has been gone. Mala completion has been done since 21 till
election.
Yes, Mala. Since 21 in the election.
21 election.
Yes, Mala.
Payment.
Yes, Mala.
Is it regarding electrical? No, not electrical.
There are dining and kitchen, Mala.
Dining and kitchen. I am taking up electrical matters. And I've been 29th, they are appearing in the list. Very well, next Monday, let it appear. Let me see. Give self notice.
Appear in your lordship please as malad motion. Let it be malad as upgraded. Malad.
Where is it? Which?
Malad, it is 186. Malad, I am praying malad 186, 187, 188, 189, and thereafter malad 191 to 196. All are in your lordship's list.
Will you wait till I pass orders in those matters and see what happens? Because they
fix the matter
on 29th. ওই মামলাগুলো কবে আছে? Are you of those matters? 29th, isn't it?
Let it appear on 29th along with those matters.
Very well. 29th it will appear.
Malad, another matter, Malad, is not in the election matter, but in this matter, Malad, 2 crores rupees of petitioner. Malad, same thing, Malad, the DM has permitted the petitioner to work. In the DM sheet, it has been reported. All the work has been done. Malad, it has been. Malad, it is item number 201 of your lordship. Let it be
201, please wait. Please wait.
May I have my lord's kind leave to move a very urgent motion, my lord? What has happened, my lord? I have been your lordship has heard this matter. I am operating a parking space. The contract is going to expire on 23rd. My application for renewal had been dismissed, my lord, by an order which suffers from non-application of mine. I shall be dispossessed on 24th. May I pray for your lordship's kind leave, my lord?
Day after tomorrow, serve notice.
Lordship.
My lord.
Hearing on repetition part of the matter on 24th of February of 2025. Like final application for additional lot in this application, yeah, it's not the repetition.
In the application bundle.
Application for addition of particular in the pending repetition. No?
Yes, but you want this to be added on the day of the matter will be taken up.
Including the it's not.
Application list. In the meantime, you want that to be.
Then I have not let it be not taken up along with your lordship is the matter on 24th of February.
All right, 24th is a Friday of February.
The guys of giving instruction, Lord, they are discarding class. That's why we file application, Lord, we are not doing hearing, they are not hard class, and they are doing all the things. That's why, Lord, we file this application, Lord, with some in the meantime, let it be added in the list on 24th when the lost will be hearing the matters.
24th is a long way to come. 24th of February is a long way to. You serve, there is no difficulty, and it will appear in the list automatically because CIS system will take the can. If it is here, it will appear in the list. There is no use of filing.
Your Lordship, I am mentioning this matter, Your Lordship. This was filed with the leave of the coordinate bench, Your Lordship. Now the matter lies before Your Lordship's determination. Your Lordship, the respondent authorities are
What do you
taking.
want?
Your Lordship, it is listed on 24th, but on 24th, Your Lordship, they are taking the possession of the land. So the leave was granted, and Your Lordship, any day before 24th, it may be taken up.
Leave was granted by which?
Leave was
bench?
by Justice Anirudh Roy, Your Lordship, Honorable Justice. His determination lies with Your Lordship's court right now.
Yes.
Filed, Your Lordship.
Land
We will
matter.
serve. Yes, it's WPA, Your Lordship, land matter.
Yes. When will possession be taken, you said?
On 24th at 11:30 a.m., Your Lordship.
Day after tomorrow it will appear, you serve.
Lordship.
My lord, may I have a lordship's kind leave to mention? My lord,
এটা না group 1 বলে লিখবেন. Group 1.
my lord, may I have a lordship's kind leave to mention one matter for urgent hearing, urgent motion of Honorable Justice Anirudh Roy, my lord. This matter is filed on Thursday, my lord, and thereafter I served upon the learned advocate for the government pleader, my lord, and my lord, certainly on Friday that the matter will appear on 27th, my lord. But my lord, certainly on Friday, late afternoon, my lord, the petitioner received a notice from the executive magistrate subdivision, Kharagpur subdivision, my lord, that the hearing will be held on 22nd, my lord. But my lord, if my lord before 22nd, my matter is not heard by your lordship, my lord, the matter will be.
But then you will be given an opportunity of hearing, isn't it?
My lord,
The hearing notice has been given to you.
my lord, notice
don't
has been
you
given to
attend the
the
hearing?
petitioner, my lord, that the hearing will be held on 22nd, my lord. My lord, I apprehend, my lord, if my lord 22nd, but God forbid, my lord, if anything happened against
What
me,
will
my lord.
happen?
My lord, the unauthorized construction against me, my lord. The allegation is that, my lord, I have constructed an allegation construction, my lord, which is unauthorized and in accordance with the according to the concerning authority, my lord.
Public premises
My lord,
unauthorized
PWD road, my
occupation.
lord. PWD road,
PWD road.
my lord, my lord. They are saying, my lord, but my lord, according to me, my lord, in accordance with, I have done all the construction, my lord, in accordance with law, my lord. But my lord, they are saying that, my lord, my authority, my.
Assuming hearing is taken place, a hearing does not mean dismantling of your structure, isn't it? Time will be given to you for dismantling, provided the authority comes to a conclusion that this is unauthorized, made over the PWD land.
My lord.
Otherwise, where is the urgency?
I am apprehending, my lord. If say 22nd, my lord, hearing.
You attend the hearing, then come.
My lord, if anything happened, my lord, on that day, my lord,
Anything
my
happens,
matter will
here.
infructuous, my lord. My
Your
matter.
matter will not become infructuous. Immediately, you'll get a fresh cause of action. And you cannot, the court cannot stop the authority from hearing your case, isn't it?
No, my lord. Before that, my lord, if your lordship kindly.
What? The court will say you cannot, you don't hear.
No, my lord. That
Then
is.
what?
My lord, if
What,
my matter.
what type of protection do you want prior to that?
If
No
my.
protection. Think it over. Yes. Yes. What do you want to mention?
Lordship, I wish to mention three matters.
For what?
Burning urgency. I am seeking release, Your Lordship,
Release. For what?
because the matters are very urgent and there is no immediate possibility of them being heard.
What is the urgency?
Urgency is this: all the petitioners are small entrepreneurs from Durgapur. Their monies are held up. Their security deposits are held up. They are being hounded by the creditors. They are besieging their home.
making life impossible for them.
Yes. And who is holding back your money?
Durgapur Municipal Corporation.
Durgapur Municipal Corporation. You filed it under the residuary bench,
Lordship,
not against the corporation.
not against the corporation.
Why Group 5? Where is the difficulty? Why did you not approach Group 5?
Because Principal Secretary Urban Development Department is going to release the funds.
So what? A Principal Secretary Urban Department is not amenable in Group 5.
And two of the matters pertain to a company.
No, company I'll see. First one you said you have got allegation against the corporation.
Corporation. In
So
one
why are
matter.
you not there in the Group 5 determination and in the residuary determination? Which item is yours? Give me the item number.
Item number 1355.
1355, the one that you mentioned.
The one that I mentioned. I wish to
1
mention
minute.
two.
1 minute. 1355. Kya che? Release for want of determination. The matter relates to Group 5. Released. Yes.
And the other two matters, 544 and 545, they are against a government company, not against any corporation. Here, the remaining security deposit of the petitioners is held up for no good reason. Work is
Yes.
completed, defects liability period over. They are just sitting tight on the money.
Yes. What is so urgency about it?
As I said, Your Lordship, they have not been paid. They are small entrepreneurs, and their creditors are hounding them. Their employees
There
are
are so
hounding
many matters of the same nature. 1355 is released from the list. Yes.
My lord. It is running in the monthly list of 743 item number.
Why did you not mention when upgradation was taken up? Today it will not be upgraded. Come next one.
My lord.
You please come next month.
My lord, this is item number 1891 of the monthly list. My lord.
You want upgradation?
My lord, the
Please
urgent-
don't mention.
For inclusion, my
My lord, the pressing urgencies, my lord, senior citizens are suffering because the squatter is carrying on a sweet shop from their premises. My lord, we've written to every authority. They've said that they will take action, but nothing has happened. My lord, a burner is being burned for 12 to 16 hours a day. We've written to every authority, my lord, for the past month. This is going on. We've written everywhere, my lord. What takes up any time.
No, why are you not going before the civil court? Anything you'll come before the writ court.
Yes, by your lordship, my lord, the reason we are coming here because we have written to the fire services department, we've written to every concerned state authority, my lord, because the people who are carrying out the business, my lord, they have no license. Lordship knows, my lord, the fire services, they have to be mandatorily taken. No license has been taken, they've been squatting.
They are squatting.
They've been squatting, they've been running the particular sweet shop for 12 hours a day. There's a burner for which the senior.
And since when this is being run? Since December.
Lord, it's filed, it's item number 1891 of your lordship's month.
Please come next month.
On the 17th, but it has not appeared in the list. Immediate motive is expiring on 24th of January.
Yes, give. Serve notice.
My lord,
Give.
sir, I am
Expiring. Expired. Then come up with application.
The maintenance tribunal matter your lordship was hearing, my lord.
Yes, but then if you want extension of interim order after its expiry, then an application is to be followed. Otherwise, orally it cannot be done. Come up with application. You file an application, it will appear. No difficulty. No. Disposal. So you want 31st of March. Very well. Give. Please give.
May I seek my lord's kind indulgence?
1 minute. Yes, madam.
Application for
Come next month. Yes.
That on 5/11/24, a person claiming to be an authorized.
I am not concerned with the merits of the matter. What you want, please?
There is no electric supply on the flat of the petitioner, my lord. It's been almost 2 months since the electric supply has been cut off, my lord.
By whom?
by the CSC.
Yes, you non-payment of bills,
My lord, the problem is that
tampering.
paid, my lord, when the meter has been changed, yet still the electric supply has denied to restore the electricity.
Restore electricity. Yes, give.
May I seek?
No, please come next month.
May I seek my?
My lord,
Please come next month. Somebody standing in front, do not hand over slips from behind.
May I seek?
There is a lady standing in front of you. Please maintain some dignity.
M-
Yes,
May
ma'am.
I seek?
May I be permitted for upgradation? It is in WPA number 28954 of 24. It has appeared in the monthly list of 316. Kindly praying for upgradation, and its urgency is the petitioner is very poor person, and he has been and he has received a huge amount of electricity bill. Kindly praying for upgradation.
Sorry.
May I seek my?
permitted to make.
For upgradation, my lord, tender matter, my lord. Contract has been terminated, my lord. Petitioner deprived of near about 75 lakhs, my lord.
Tender has been terminated. What remains?
My lord, for payment of the amount, rest of the amount. payment of
Please
the-
wait.
My lord, original.
May I permit to mention one urgent matter from the list of Honorable Justice Aniruddha Rai, my lord, Group 1 matter. Very urgent matter, because my lord, without any authority on law, the PAE authority, my lord, started construction of a deep well upon my land, my lord, which is my own personal land, without notice, without requisition.
Who is constructing the tube well?
My lord, the PHE department.
PHE.
Assistant
give.
May I seek?
Serve notice. Serve notice upon your other side.
May I seek my lord's very kind indulgence to mention one original side writ petition?
Please wait.
May I mention one matter, let it be applied in the list as per the-
No, no. Please wait.
Application, despite order passed by your lordship January 24, my payment is withheld, my lord. I am, my lord, don't run condition, my lord.
I am not including now. Please wait.
This has been hard many times. The last date was 18th of December. I'm giving the date, and it was 10th of January.
Yes.
On that day, one of our brothers had died. There was one education of I take for time.
I am aware of this matter. It has the assigned matter. Yes, yes, I am aware. Assigned matter আছে অনেকগুলো হিয়ারিং এর জন্য। ফ্রাইডে দিয়ে দেবেন। ফ্রাইডে 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 স্লিপ লাগবে না। Sleep not required.
Extremely urgent matter which cannot wait till tomorrow or day after tomorrow. I participated in tender, stood H1 bidder. I have time to make the payment till tomorrow. By that time, a notice has been issued saying that they are going to issue a tender notice afresh without explaining why my money, which I can pay till tomorrow, they are not going to accept. I am the H1 bidder. I have prepared the repetition.
Who is the
corporation? Metal Scrap and Trading Corporation.
metal scrap? Where you will give? 2 o'clock it will appear.
Tomorrow, I'll serve and come.
Acha, tomorrow.
My lord, may I be permitted, my lord, for extension of interim order? It is expiring on 31st.
Give.
Lordship, may I be permitted to?
Notice.
My lord, order was also.
But the
My lord, may I
notice
mention one? Lordship, may I be? My lord,
To file this matter and move it on any day of your lordship, of your ladyship's convenience, it is a very critical matter. The Wildlife Protection Act, very new amendments, dictates that I register my possessions of wild birds, which I have by way of transfer or by way of birth of progeny, etc. Now, some of my or many of my applications have been rejected in complete gross violation of the orders of the requirements of the law. In fact, I have not been given the orders. No reasons for rejection are there. Problem is, unless it is heard and some orders are passed or it is considered, tomorrow I stand the risk that my whole lot will be confiscated by the police and the wildlife department, and criminal proceedings will be initiated against me. There is a huge risk. I will satisfy your ladyship that there was no lapse on my part. At least it needs to be heard.
A day after tomorrow.
Yes, very well.
Lordship, may I be permitted to mention for urgent motion, this is pertaining to the eight-wheeler matter against the railway authorities. Lordship had passed an order for the railway authorities to consider and come back within 8 weeks. They have passed an order in January completely unreasoned order. We have proved our bona fide by closing down our shops. This is pertaining to the Diagnostic period and the extension. However, now the railway authorities are trying to dismantle my shop and stop me from functioning.
No, because they are conducting fresh auction.
Lordship, we are willing to make the payment of the license fee as well, but this needs to be heard.
Why? Court has passed order
Court has passed order.
directing them to consider.
Yes, 8 weeks time was granted.
Right. Now
They
they
come
have
back after 10 weeks.
very well. But in the meantime, an auction process is being conducted.
It has been conducted, but the ladyship had passed an order asking them to consider the period of Diagnostic because this is in the Asansol division.
Very well. They have considered and rejected your prayer.
They have passed an unreasoned order.
Whatever your prayer has been rejected.
Yes.
And they participated in the fresh tender.
We are willing to participate in the
Then-
fresh tender, but they are asking us to dismantle.
It has to be. This is the system. You have to dismantle and then only they will do it. This is the
If
system.
Lordship
Nothing
could
to it.
kindly hears this
No,
once and
sorry.
pass it.
Sorry.
My
Yes.
lord, may I
permitted
mention
to
one
mention
extension of
item number 93 of today's list, Lordship, for withdrawal, Lordship.
Withdrawal, why?
Lordship, some defects are there in the application that those are to be corrected with a leave to file afresh, Lordship.
Which item?
Item number 93, Lordship.
Today's list?
Today's
Are you the on record?
no, Lordship, I am being led by...
Bring your advocate on record.
May I mention, my lord, extension of interim order
Expiring on?
interim on 24th, my lord.
Give.
May be permitted.
Serve notice.
May be permitted to mention, my lord. May be permitted to mention, my lord, petitioner before your lordship is a scheduled tribe communicated.
What do you want?
Member.
What do you want?
My lord, I want, my lord, he made a complaint, my lord, to the district.
What do you want? Upgradation,
Upgradation, because my lord, last
Please
Saturday,
do not
my lord,
mention.
his egress and ingress has been blocked under the SCST Prevention of Atrocities Act. My lord, I made complaint to the district magistrate. District magistrate directed the local authority to inquire. Nothing has been done. Last Saturday, they blocked my egress and ingress. I am in a very hard condition.
Listen, you're blocking ingress and egress. Civil court is there. You are invoking the SCST Act
yes.
only for this purpose. No, sir. Please try some other bench.
I will satisfy
Try
your
some
lordship.
other bench. Civil court is functioning. Go over there. No, sorry.
My lord, kindly upgrade it, my lord.
May I be allowed to move to urgent writ application on 26th of December 2024? I have given by the law of for organizing a religious program from 22nd of January to 23rd of January. Now, pursuant to that, my lord, I have received no objections from all the state authorities. Now, what has happened in this last Friday? In the evening, my lord, I have been served with a notice saying that your permission to use the land has been, my lord, cancelled. My lord, I have invited about 10,000 people. No, I have already
10,000 people.
10,000 people.
What?
There is a most to be organized by my organization, my lord. It's a Christian religious.
And permission was granted.
Permission was granted by first, my lord. First permission was granted by the Haldia Port Dock Authority. Thereafter, my lord, SGO has.
And you are holding it in the port to land.
But it is, they have this helipad that I have obtained permission to use their
Helipad
for a period of 2 days. That is, and the program was supposed to start from 22nd of January till 23rd of January for 2 days. So on 24th of December, they have given me permission.
Very well. Give.
Tomorrow,
Yes, tomorrow urgent motion.
My lord, may I be permitted to mention?
Please don't mention. Come next month.
My lord, may I be permitted to?
Upgradation and inclusion. Come next one, please. Please come next one. Today we are already on 20th. Come next one. Correction give.
My lord, may I be permitted to mention for inclusion, my lord?
Come next month.
Lordship, may I permitted to mention for withdrawal, Lordship, as the relief paid in the petition has been already given by the respondent number 2, District Magistrate, Lordship.
Advocate on record?
Yes, Lordship.
Which item?
Item number 1606 of monthly list, Lordship.
Tomorrow 1606 for withdrawal.
Lordship,
Yes.
kindly for one mention, Lordship, which unauthorized construction at PWD Road, Lordship. Unauthorized construction at PWD Road, Lordship.
Yes,
and
what
pay
is-
for upgradation.
No, please.
My lord, for upgradation, this was previously mentioned before your lordship, and your lordship was pleased to direct to be upgraded, my lord. But
Then
it has
do not mention.
It has not been upgraded.
It will be upgraded, do not mention.
My lord, may I be permitted to mention, my lord, one group one?
Somebody senior to you is standing by your side. Yes, Mr. Haq.
My lord, in the month of December, I mentioned this matter for upgradation. My lord, your lordship was pleased to allow the
Upgradation, it will come. The list is being published. Please wait. Yes.
alignment.
No, next month, please come. Yes.
I mentioning this matter, my lord. State motion, my lord.
Upgradation inclusion.
State motion, my lord. Pension
Upgradation inclusion.
inclusion.
Don't mention for inclusion. Don't mention.
Unmarried pension.
Come next month, please.
Lord, may I permit to mention the determination of justice?
Come next
Aniruddha?
month.
The urgent determination of my Lord Justice Aniruddha Rai.
Yes, please.
The urgency is the demolition work has been passed by the DM. I have challenged the determination of the jurisdiction of the DM. My Lord, currently the matter is running in the item number.
When will the demolition take place?
Last week, my Lord. I have filed.
When will the demolition take place?
The order has been
Date
passed
has been fixed for demolition.
within a week, my Lord.
Within a week?
Within a week.
Very well. Group 1 matter. Serve notice.
Yes, yes. Item number 83.
Yes.
May I be permitted to mention one group one matter, my lord? The difficulty is, my lord, my property surrounded by boundary wall, my lord. On 15th, my lord, PWD authorities representative came to my lord property, marked the boundary wall for demolition of the same for expansion of Howrah Amta Road, my lord. Without any notice, without any intimation, my lord. They said it will be, my lord, demolished well within 4 days, my lord. Though 4 days has been passed, my lord, I am apprehending, my lord, it will be probably demolished, my lord, within this week, my lord. That's my property, my lord, surrounded by boundary wall. It's my personal property.
Yes. So why are you here? Why not before the civil court? Where is the difficulty? Your private right is being infringed by a government authority. Why not before the civil court? Why over here?
My lord,
Can you see the pressure upon the reed benches?
my lord, PW is the D is the, my lord, state authority, my lord.
The state authority is against the
PLRO
state.
is-
The
PLRO is also
civil
there.
law will not apply against the state authorities.
That is, my lord, West Bengal Unauthorized Occupant Act 1962, my lord, they have taken up this.
Yes.
Yes, my lord, and I think, my lord, subject to correction, there is a bar of taking any matter from the civil.
There is a bar. Your civil right is being infringed and there is a bar.
Subject to correction, just because he's not, I'm just.
Are you aware in this matter? Are you then why make submission? There are so many councils over here. You'll interfere and make submission in each and every matter. You do not know what the facts of the case is. Then this is not the way you perform in court, right? So is your date given for?
No, nothing given.
No date has been
Date has
mentioned.
been mentioned, my lord.
So when do you apprehend? They'll come any day and
My lord, they can come any day, my lord. That is the difficulty, my lord. I have filed it on 16th, my lord.
yes.
Subsequently, I have made the representation before the authority as well, my lord. I will, my lord, I will file the supplementary affidavit to that effect, my lord.
You prepare your supplementary and if they
Already
come, then
prepared,
mention.
already prepared, my lord.
If they come, then you please mention.
Great.
Not now.
My Lord, water line has been disconnected.
Yes.
Water line has been.
Why?
My Lord,
Who has disconnected?
my Lord, landlord disconnected due.
Landlord disconnected water line and the reed court will interfere.
My Lord, due to dispute regarding the landlord and the promoter, my Lord, tenant, my Lord, water line has been disconnected.
Yes. And the reed court will interfere.
My Lord, for disputed disposal, my Lord, if your lordship does not give any protection, my Lord, for my client will go. He will
Your client will go to the civil court.
No, it will take time.
Your lordship, the petitioner is challenged the
Years. Yes.
Your lordship, the petitioner is challenged the order passed by the Information Commission under the Right to Information Act that the matter is very urgent, mentioning for upgradation. My lord.
Please come next month.
My lord, it is urgent, my lord, the petitioner made objection memo before the electricity authority, my lord, not to draw the electric connection and upon the home street land of the petitioner. But the writ petition filed before your lordship, my lord, item number 445, my lord.
Let it remain over there.
The authority, my lord, saying that no court order, draw the line. Yesterday, going to
Without court order, they could not stop the connection over my home street land, my lord. So I pray before you.
No, I cannot upgrade. Yes.
And I am for matter, my lord, for non-prosecution.
Give.
Item number 325, my lord, for arbitration, my lord.
No, please come next month.
My lord, urgent, my lord, very urgent, my lord. Because
Why?
my lord, petitioner is senior citizen, all his land have been vested, that was cancelled, state appeal preferred, that was, my lord, dismissed. Then, my lord, prayed for correction. This honorable court directed for correction. My lord, RO has directed that that civil court has no power. Thereafter, the preferred appeal was allowed after 15 years in 2012. My lord, all the lands, my lord, for 40 years.
What do you want? Correction of record of rights?
My lord, I am only praying for, my lord, for selling right, my lord. My lord, all the declared.
Selling right is your land, you go and sell. Who is stopping you?
Oh, my lord, the vesting, there is a
Vested
vesting.
land.
Only vesting, my
Vesting land, go before LRTT. Why before the High Court?
that has already been done. File is not available, that is not corrected.
I cannot understand. File is not available. Where file? Which file?
Vesting file, my lord.
The vesting court is there. There is a separate court. Why here?
That has already been done. Several orders passed, my lord. Kindly only grant my lord, selling right, my lord.
Group 1 matter?
725.
Group 1?
No, my lord. No, this is residuary.
How come it is within residuary determination?
Residuary, my lord, the registration, district registration officer, I have prayed before the district registration officer for granting sale right, my lord.
Please wait.
My lord,
Yes.
kindly, any day, my lord.
Of application for
All the
senior citizen, my lord.
For disconnection, matter is appearing in the list.
Yes.
It is appearing in the book of list under heading electricity matter.
No special preference in electricity matters. It will be taken up. When it will be disconnected?
The notice already disconnected. 2 times.
Already disconnected?
Not yet been disconnected. We put a notice for disconnection.
Yes.
Matter is appearing in the list, but unfortunately not in the.
It will be taken up. Please wait. Yes.
My lord.
Kindly not to mention one matter for upgradation, my lord. This matter, my lord, relates to Assisted Reproductive Technology Act, my lord. Here the petitioners, my lord, because of the age restriction put in the act, my lord,
Yes.
against the IBS. My lord,
You mentioned it last week.
number of times, my lord, was mentioned.
It has been directed to be upgraded.
No, my lord, my lord had directed to come again, my lord, next week. My lord, was not upgraded.
We will give.
But it is appearing in the monthly list.
Yes, it will be upgraded. দেরি করবেন না, এটা দিয়ে দেবেন তো?
Marriage is carrying on his duty without to be being over the age for carrying on these duties, my lord. This matter has not been included in the list even once, my lord, since its filing, my lord.
When was it filed?
Filed in 2023, my lord. He's carrying on his ministerial functions as a Muslim marriage register without having, after having attained the age of superannuation, my lord.
Who are you?
I am he is the Muslim marriage for the Shia community, my lord, and I am for the Sunni sect, my lord.
Yes.
He has represented to the public in general that he is the only Muslim marriage register for both Shia and Sunni sect.
So you want his registration to be cancelled, license?
For the age of.
Over is it? Please wait.
My lord, I'm mentioning for non-prosecution, my lord.
Non-prosecution, give.
My lord, I'm introduced to mention for upgradation, my lord.
No, please excuse.
My lord, kindly, this is a more extremely urgent, my lord. I have gifted a plot of land for Anganwadi project because there is no Anganwadi project in the locality. And thereafter, my lord, the government is doing another place, they are constructing the Anganwadi project. That's why.
So your place, they are not making construction?
Yes, my lord.
Where is the difficulty?
I do not know, my lord, they are constructing elsewhere, but with permission, I have gifted property to the government for the office of the Anganwadi project, my lord.
How are you aggrieved? You are no way aggrieved. You have already gifted the property.
Yes, my lord.
Then what remains? You do not have any right.
Then, my lord, release the property, not required, they release the property.
You cannot do it in this way.
Well,
Yes,
give it
please.
to-
No, this is
No.
I am for establishing applicant. I applied for the settlement of dues.
What is your prayer here now?
Settlement of dues. My client is ready to settle the matter, but bank is doing some. Bank says, please give me the whole.
And nothing. Yes.
Urgent writ petition, challenging the acts of the registrar of companies. The issue in the writ petition is complaint lodged by an outsider.
What do you want?
Only it's appearing as item 1838 in your lordship's monthlies. May it be taken up any day this week.
No, sorry.
my lord, without giving me an opportunity to deal with the charges, my lord, the ROC has initiated proceedings under section 206 of the
I
Companies Act.
took up mentioning for upgradation on the first Monday of the month. Please come. I'll upgrade.
Milord, for inclusion matter.
No, don't.
May
Yes.
I permit to mention one group 9 matter for inclusion in the list?
No.
It has been
May I permitted to mention for upgradation?
No, no upgradation, no inclusions.
for restoration.
No.
For inclusion the matter.
No.
May I permitted to mention for inclusion original side matter, your lordship?
Yes.
May I have my lord's kind leave to mention item number 513, my lord. This is a matter, my lord, where the tender was,
Inclusion, upgradation.
my lord, obviously after upgradation.
No,
my lord,
sorry.
This is the matter I have already mentioned before your lordship.
Scheme is there. Your lordship, it's another matter, passed an order for this project to pay your lordship. You can pay now, your lordship. If there's a liability, give respondents and for us, your lordship. This is the state educational institute, state funded educational institute. So your lordship, in one matter, your lordship passed an order and your lordship they pay. And your lordship, similar matter covered by your lordship.
Very well, give. Serve notice. Yes.
Original side, my lord.
Yes.
My lord, 65 years old citizen, my lord. Writ
What do you
petition.
want?
But I want the writ petition to be included, my lord. My bank
For
account,
hearing.
my lord, hearing matter. Affidavits, my lord, very small issue, my lord, in violation of section 45 ZB, my lord. My bank account have been lien has been marked upon my bank account. I'm neither the borrower, neither the guarantor, my lord. My lord, the plea, my lord, which the bank is taking is that some other bank under mistake has transferred some funds to my bank account, whereas that funds have been transferred by one of my debtors. My lord, there are ledger accounts. My lord, I have approached the Reserve Bank of India under section 33 of the RBI Act.
I will give
Great
serve
fit.
notice to the other
Your
side.
lordship, my urgency for the inclusion is that my petitioner's cargo has been illegally restrained by the respondent authorities on the pretext of arbitrary bill raised by them. Now, my petitioner complained of these things to the respondents' higher officials, but a committee has
Your
been
matter
formed.
is already there in the list.
No, your lordship, it's
You
not
want
firm inclusion.
inclusion?
Your
Come next month.
Lordship, I am in custody for more than 30 years, Lordship. I have prayed for several representation before the concerned authorities for premature release, Lordship, but none of this has been considered, Lordship.
Come next one, please.
My lord, I have just forgotten one thing. I have filed the case in here in this High Court, but it is not coming up for hearing.
Yes, next month, please come. Call the list, please.
But I'm for the petitioner, my lord. This is affidavit service, my lord.
No, this is, my lord. I am appealing for the
No, very short matter, my lord. During COVID, my lord, under ECLGS scheme, the company was provided with a loan. Now there was terms and condition. It was also a terms and condition that if prepayment has been made prior to its maturity, then my lord, no extra prepayment charges will be deducted. Now, my lord, despite being payment made, my lord may just kindly come to first the clause which I am saying about. Your lordship, kindly come to page number 36.
Are all the parties appearing?
My lord, in this matter, I am appearing for the respondent number 4 and 5, my lord. I was told that we have not received the.
My lord, affidavit service I have given.
Somebody says he has not received. Give a copy.
Price
Respondent 4 and 5.
Tomorrow, my lord.
4 and 5.
4 and 5, my lord.
Madam,
Reserve
main relief.
Bank. Indian Bank.
No, I am for Indian Bank.
You are for the Indian Bank.
My lord, main relief is sought against respondent number 1, 2, 3.
My lord, in the meantime.
Now, my lord, may kindly come to page 36, 1. My lord, very short matter, my lord.
Let me see the service ones. How it has been served upon the Reserve Bank.
Now, first time they said that annexes were not there. Then we again supplied. Then again they are saying that we have not been served. But even if they have, my lord, we have served, but their role is very limited to this REIT application. Your lordship, kindly see the services.
I see it has been served.
My lord. This is third occasion, my lord, RBI is.
Reserve Bank directly.
What did you serve? 22nd of December. What did you serve? The entire writ petition?
Entire, my lord, along with annexure, because they were complaining that annexures were not there when first service was submitted.
Your lordship, kindly take up the matter.
This is third occasion.
I have not received the copy of the.
Who has not given you the copy? Do you have the power to appear?
Bank with service.
No, they have been possibly they have served on the bank, my lord. I have not received, my lord. We have received the instruction, but we have not received the copy of
It is for your client to hand over the copy. It is not for the petitioner to serve copy each and every occasion. How many times will you make
I will take up
photocopies?
for it tomorrow, my lord. I am not aware of the fact, my lord.
No, you have the instructions, you say.
We have received a letter from the Reserve Bank of India that engaging us, man.
Engaging in this matter is being running in the list for quite some time.
Kindly see, my lord, on all occasions, it has been adjourned only on the ground that RBI has not
4
been
and
served.
5, what is your name?
My Molay Kumar Sil.
I can see your appearance. What is the matter?
My lord, I have seen. My lord, kindly come to page number 36, my lord. Very short matter. Page
36. Yes.
An ECGLC scheme, I was provided a loan. Now there was a, my lord, kindly come to page 36, just bullet point number 4.
Yes.
My lord is getting no prepayment penalty shall, however, be charged by the MLIs in case of early repayment. Now, my lord, may kindly come to page number 41. Now, this is the application for which I have applied. How your lordship is getting the loan I have applied. Now, my lord, may kindly come to page number 53.
You are Swastika Steel.
My lord, Swastika Steel.
Application for loan.
That loan.
Yes.
My lord, prepayment charge, your lordship, just kindly come to page 53 in very short, my lord.
Yes.
Kindly see just at there 4,92,632 your lordship is getting.
Yes.
At this portion, my lord, kindly see the heading under which the payment is deducted.
Debit.
Prepayment charges.
Prepayment charges.
And this was not supposed to be deducted. Now I made complaint before the ombudsman. Kindly see page number 54. There were several illegal deductions were there. Everything was done, but this heading was not cleared and this remained unpaid. Your lordship, kindly come to page 54. This is my application before the bank. Page number
when
50.
was your due date of repayment?
But it is within time. That is why prepayment, my lord.
When was the due date? Tell me.
But NOC was given. It was within the time I have paid prior to time. So
give me the date within which the payment could have been made. This is May 2021 is the prepayment.
My lord, I have applied for that benefit on page number 41.
Page 41.
Yes.
Date.
My lord is getting the application form. Now payment schedule is starting from page number 49 onwards. Page number 49 your lordship is getting. And page 53 is the statement of account.
Did you seek for refund?
My lord, page 52. Specific letter, my lord. Page 52. While we going through the statement dated 13th May 2021, we have found that on 13th May 2021, you have debited 4,91,631,080 from your above account. We would request you to please provide us debit advice against the above amount to make proper entry in our accounts. Now, next that particular statement of account to the concerned bank. I have again at page 54, I have written letter to the bank, page 54. I have again written the customer grievance unjustified charges, where Indian Bank has charged in excess. And next page number 55, I have explained all the details.
Any reply to this letter?
My lord, we went to the ombudsman.
Yes.
Ombudsman had decided everything, but this 491 something, which has been deducted on account of repayment charge, has not been solved. And it has been stated that, my lord, kindly come to page 57. What they have done, just change the name of the heading. Kindly see.
Page 57.
Page 57, clause number 4.
Take over
Now,
charges.
same amount which was deducted as prepayment charge has been given the heading takeover charges. And this was never applicable.
What does this takeover charge
Yes,
mean?
my lord, kindly just match the account, page 53. Kindly see. Same amount. It can't be, my lord. And in terms and conditions,
what does this takeover mean?
This is nowhere mentioned in the terms and conditions which they have given.
How are you connected with Axis Bank?
My lord.
How are you connected with Axis?
It is their reply. I am not connected to Axis Bank.
You are no way connected with Axis. All right. Yes.
My lord, the account was transferred to Axis Bank.
Who transferred it?
Party itself.
Party himself? Show me some documents. That the party himself got the account transferred.
Yes, that I can, my lord. Right now, I am not prepared with the document.
All right.
Document is with us. And the account is transferred to Axis Bank.
That means the whole money which you were holding has been transferred to the Axis Bank.
Right,
Nothing
the
has been
account has been
deducted.
transferred. Account,
Nothing has been deducted.
no, the amount which has been deducted, it is, which has been bank ombudsman already done everything, and whatever they have ordered, we have refunded the money. This amount is takeover charges.
What does takeover mean?
Takeover, that the account has been transferred to.
Transferred.
Right.
So this is, you do not have right to hold the money. The petitioner wants the account to be transferred to Axis Bank and you have transferred it.
Yes, my lord.
And the special
And
scheme, it
there were
cannot be
judgments
done.
also, my lord, that takeover charges, bank has entered RBI as per RBI circular. Takeover charges there, and bank has taken the takeover charges.
But I have annexed the entire terms and condition of ECJCS scheme. Kindly let them
Show
show.
me some communication from the petitioner. Are you aware of this?
But I have annexed the entire scheme. Entire scheme I have annexed. Nowhere this charge has been made. It is only when we have said that this amount should be refunded. Now another heading has been given. This cannot be, my lord, same amount. How it can be the same amount, same figure?
Did you ever seek for transferring your account?
My lord, it was transferred, but this is not supposed to be charged because the scheme doesn't say that. It is a special scheme.
Not for the scheme. It is only for.
It is a special scheme, my lord. That is why it was granted in
Did
COVID.
you seek for transfer of your account to the Axis Bank?
Well, it was transferred so that the payment can be made, prepayment can be made. And this charge was never supposed to be deducted by
No,
the.
my lord, actually, when they have transferred the account and the money due with the account holder, that has been paid to the Axis Bank, to the bank.
We'll ask them to show from the scheme because they cannot go beyond the scheme.
Scheme. As per IBI
The loan was
guidelines,
granted
1988.
under the special
Where are the
scheme.
guidelines? Please show me.
My lord, I'll paper is not with me. I'll hand over the paper.
We'll file an affidavit so that he can controvert it. Please
my
come. The petitioner is aggrieved by
The deduction of prepayment charges.
the action on the part of Indian Bank on account of deducting prepayment charges of the prepayment charges what is the name of the scheme, please say?
My lord, may kindly come to page number 24. Emergency Credit Line Guarantee Scheme. Page 24, my lord, heading your lordship will be getting.
Yes, charges under the Emergency Credit Line Guarantee Scheme.
My lord, in short, ECLGS.
Bracket ECLGS. Stop. According to the petitioner, as per the scheme, no prepayment penalty can be charged.
Page 36.
In case of early repayment. Stop. Paragraph. The petitioner submits that the bank has illegally deducted the said amount by way of different nomenclature, namely takeover charges. Stop. Paragraph. Learned advocate representing Indian Bank submits upon instruction that steps have been taken strictly in terms of the RBI guidelines. Paragraph. The respondents are directed to file affidavit in opposition disclosing their stand in connection with the amount which was deducted from the amount of rupees 4,91,631 deducted from the account of the petitioner allegedly on account of takeover charges.
Normally, it has deducted prepayment charges. Page 53. Explanation has been given subsequently takeover charges. But account so it is prepayment charges.
takeover charges / prepayment charges. Within how soon? Affidavit, how soon?
15 days.
Within within 10th of February. Reply, if any, within 21st of February. List for consideration on 4th of March. Affidavit of service taken on record.
Deeply obliged, Lordship.
Thank you.
But in this matter, perhaps the petitioner is not so much interested in. So kindly see the orders. In so many days, he has taken adjournment.
Not coming.
Not coming.
What is the grievance?
On the last occasion, they came, but prior to that, previous occasions, they were not there. And so many dates have 1, 2, 3, 4, 4 dates were there.
Dismissed. Record everybody's appearance.
Get
Are you there?
Yes, madam, for
For
the
the-
respondent.
For the respondent. Enter your appearance.
Yes, yes. madam.
Yes.
না না আপনি আছেন বলে আর সময় নেই
ব্রিফটা দিয়ে দাও
পরেরটা আছে না
ভয়ে পালিয়ে গেছে তোকে দেখে
আপনারটা পরেরটা ওই জন্য সময় নেই।
I'm for the petitioner. There are two developments. One is Mr. Basu's client is possibly in jail. The other is, my lord, the report which was supposed to be filed hasn't come.
Filed by whom?
By the government. I spoke to Mr. Banerjee outside. He said that he's received the instructions, but he could not prepare the report.
What line is it?
Lordship, appearing on behalf of State Respondent led by Mr. HON'BLE, Lordship, kindly give 1 week accommodation.
He said he had just received it.
I can't follow. My client is in jail. পাগল নাকি তুই?
Nah. No, that is the assertion.
That report addressing the issue filed by the addressing
For whom I am appearing?
It was executed.
Mr. Ghosh?
ওটা বাজে লোক আমি appeal করি না।
For registration on authorized reception registration.
রাজীব জেলে গেছে জানি।
তাহলে
আমি রাজীব appeal করছি না।
তোমার ভাইপো তো।
তোর বন্ধু।
Suits are still pending.
Suits are pending.
Suit, my lord, your lord.
Will remain pending.
Yes, yes.
The court in the Diagnostic Act of the Registering Authority can register
If I may,
document nearly 3 years after the date of its presentation.
my lord, if your lordship recalls, my complaint was
Anyway, she wants time.
Next week.
Please come.
Report.
Learned advocate representing the state respondents seeks extension of time for filing the report. So, on such prayer, time to file the report is extended.
Lordship, only 1 week.
বেশি নেই নাকি? ক্ষতি কিছু নেই।
no, no, no. No,
30th of January.
30th of January.
Exception, if any, by 13th of February. List on 26th of February.
my lord, may I request, my lord, if it is possible for an earlier date, my lord? If it
Are
is
you apprehending something?
What more he can apprehend? Let
No,
me disclose.
really nothing can happen.
Then?
But, Lord, this is very expensive, my lord, property, which is
That
why,
way
my
suit
lord,
is pending.
Yes, call the appellate side matters.
ঘরটা বলবে যে আমার পক্ষে লেগেছে
I am for the my lord, respondent in this matter. The applicant, I have filed the application, my lord,
pursuant to leave granted by the Honorable Division Bench, my lord, this is the order of the Honorable Division Bench. My lord, can do the penalty.
Petitioner number 1 and 2, Your Honor.
Sir, I am led by. Excuse me. Sir, please tell me your order.
My lord, the matter had two aspects.
I'm for the writ petitioner, my lord.
But some cash was recovered from a member of the Legislative Assembly. My lord, a zero FIR was registered and then it was transferred to Kolkata. My lord, bail was granted subject to the condition that the passport is to be deposited. Then, my lord, the original matter was quashed by the Jharkhand High Court. Therefore, my lord, this honorable court was moved with a innocuous prayer that return the cash and return the passport. Therefore, my lord, your lordship was pleased to, my lord, direct that you return the cash and the passport. My lord, we had preferred an appeal against that. One thing, my lord, I must bring to your lordship's notice that there was a consent on the part of the state lawyer that we will return it. That is why, my lord, possibly your lordship was pleased to pass that order. But I should bring it to your lordship's notice. Now, my lord, 2 or 3 things, my lord, was required to be brought to your lordship's notice. Number 1 is, my lord, the order of the Jharkhand High Court was pending consideration before the Honorable Supreme Court. Number 1. Number 2.
What order did the Jharkhand High Court pass?
My lord, the zero FIR which was registered
Yes.
in the state of Jharkhand, that was quashed.
That was quashed.
Yes.
All right.
Therefore, the question is that after the zero FIR, when the state police, West Bengal State Police registered, what is the validity of that? Well, those are, my lord, to be decided by the Honorable Supreme Court. The matter is pending over there. Notice has been issued. Notice has been served upon my learned friend's client. The matter is pending consideration. I do not have the latest development with me. Now, these 2 aspects, my lord, has been brought to the notice of the Honorable Appeal Court. The Honorable Appeal Court has been pleased to relegate the matter. I won't say relegate. The Honorable Appeal Court was pleased to stay those portions of the order and directed that you get a clarification from the learned single judge. Therefore, my lord, we have filed an application. My lord, your lordship may kindly fix it, my lord, on the.
What is the clarification that you are seeking?
My lord, clarification in the sense, number 1, my lord, whether, my lord, in view of the division bench's direction that the passport is to be deposited before the learned special judge, whether, my lord, the person concerned should go back to the division bench, because this is a condition which has been imposed by the division bench, which can be relaxed only by the division bench. This is our contention, subject to your lordship's final consideration of the matter. Number 1. And number 2, when the matter is pending before the Supreme Court, my lord, whether, my lord, your lordship would, my lord, also direct return of the cash in view of the Jharkhand High Court's order. Kindly take it up on a day convenient, my lord, so that we can. The division bench matter is also appearing in the list before their lordships today. My lord, kindly fix it on a date so that, my lord, we can
Lord, may I?
inform the Honorable Appeal Court that your lordship will be considering it.
Yes.
May I? My lord, as of now, the decision is expected from your lordship, because the division bench, my lord, has made it very clear that since there was consent given by the learned government plead appearing, it wasn't really an appealable order. And in that sense, the single judge, my lord, there ought to be a clarification sought for before the single judge. Now, my
The
lord,
matter has to be heard afresh. If the consent was there and an order was passed on consent, then the consent is taken away. So the matter has to be heard, because once one of the parties gives consent, the court relies.
Yes, yes, exactly.
Now, if it is said that the no consent is not given, the consent is withdrawn, then the court has to think on merits and then pass an order. So we'll consider the writ petition.
may I, my lord? My lord, I'm not, my lord, at all, my lord, disagreeing with this. But may I just say, my lord, the matter has 2 aspects.
We'll hear.
One aspect
fix
is
up a date.
no, my lord, consent was only for the money aspect, the return of money.
Fix up a date.
My lord, my lord, my passport, my lord, it's a fundamental right, my lord, to have a passport and to, my lord, be able to
We'll
travel.
fix up a date. The order I see was passed in July. We are in January. You have not been able to get hold of your passport.
We have not.
You have got?
No, my lord, we have not.
You have not.
We have not.
So it is appearing as to be mentioned. Let us fix up a date. We'll take it up.
Kindly, my lord.
Please come.
Hmm.
As per the liberty granted by the Honorable Division Bench, comma, the matter has been mentioned before this bench and the same is appearing in the list today under the heading to be mentioned. Stop paragraph. It appears that the matter requires hearing. Stop. Let the same appear in the list on 10th of February 2025 under the heading motion.
But we have filed an application.
It will appear along
as a-
with it. The connected application shall be filed, shall be taken up for consideration on the same date. Take back this order sheet.
Very well.
এই নিচের অর্ডারটা ফেরত দিয়ে দিতে অলরেডি কপি আছে।
I'm grateful, ma'am.
তাহলে ওখানে গিয়ে বলে দিস
Grateful, my lord.
To appear on behalf of the state.
I'm for the private respondent. Very interesting petition.
Yes.
No, আমার সঙ্গে আছে।
Ma'am, in person, Sonal Anand. Yes. ম্যাম এর আগের দিন আপনি বলেছিলেন সবাইকে আজকে ডেটটা সার্ভ করে দিতে, আমি সেটা করে দিয়েছি। এফিডেভিট করাইনি, যদি বলেন তাহলে করিয়ে দেবো। আর ম্যাম আমি এফার্ম করেছি, আরো কয়েকজনকে পার্টি বানাতে চাই।
আপনি কি 2 নম্বরকে সার্ভিস করেছেন?
হ্যাঁ ম্যাম, আমি সবাইকে সার্ভিস করেছি।
Enforcement Directorate, is anybody appearing for ED?
We are
Who are you representing?
We are on the state of West Bengal. We are
Service through the government pleader.
service through the government. Let's see, Millard, in person appearing, what can be?
Joint Directors ED, এদেরকে আপনি সার্ভিস করেছেন?
হ্যাঁ ম্যাম করেছি, আগে যারা যারা ছিল তাদেরকে সার্ভিস করেছি। আর আমি একটা নতুন এফার্ম করেছি, স্যাটারডে করেছি ম্যাম, এখনো ফাইলিং করতে পারিনি।
কি আছে
এখানে ইনকাম ট্যাক্স আছে।
কি আছে?
She wanted to implement some other people as a part.
Documents.
Yes, income tax and other, as I understand.
পার্টি অ্যাড করতে চাইছেন?
হ্যাঁ পার্টি অ্যাড করছি ম্যাম। এখানে হচ্ছে ফাইন্যান্স ডিপার্টমেন্ট, নবান্নকে অ্যাড করেছি, সেন্ট্রাল ব্যুরো।
আপনার পিটিশন, আপনি কাকে অ্যাড করবেন সেটা আপনি ঠিক করবেন, সেটা কোর্ট বলে দেবে না, ঠিক আছে? আপনি যদি মনে করেন যে আপনি পার্টি অ্যাড করবেন, আপনি পার্টি অ্যাড করতে পারেন।
আচ্ছা, থ্যাংক ইউ ম্যাম, থ্যাংক ইউ।
আপনাকে তাহলে সার্ভিস করতে হবে।
ওকে ম্যাম।
এই পিটিশন তো তাহলে আবার এখানে অ্যামেন্ড করার দরকার আছে।
আমি অ্যামেন্ড করিয়ে দেবো ম্যাম।
আপনি কি করে অ্যামেন্ড করিয়ে দেবেন?
না মানে আমি এটা ফাইলিং করাচ্ছি।
আপনি কেন একটা উকিল বাবুর সাহায্য নিচ্ছেন না?
ম্যাম আমি লিগ্যাল সার্ভিসে গেছিলাম, আমি ওখানে আমার অভিজ্ঞতা আমি সেদিন বলেছিলাম যে আমি অনেক বছর ধরে এটা কেস লড়ার চেষ্টা করছি কিন্তু পারিনি, বিভিন্ন রকম ভাবে রুটেড হয়েছে আমার।
Only 52 years my practice. Kindly have a look to the petitions. And Pierre, very interesting.
ওনারা এক্সপিরিয়েন্স আছে, আমি নন এক্সপিরিয়েন্সে কাজ করছি।
আপনাকে একটা মামলা করতে
Ma'am-
গেলে তার নিয়ম অনুযায়ী করতে হবে, আর আপনার পাশে যিনি আছেন উনি একজন সিনিয়র কাউন্সিল, আপনি এইরকম ভাবে কথা বলবেন না কোর্টে, ঠিক আছে?
ওকে ম্যাম।
আপনার যেটা বক্তব্য আপনি কোর্টকে জানাবেন,
ওকে ওকে
আপনি আপনার অপর পক্ষের উকিলের বিরুদ্ধে কোনো কথা বলবেন না। ইয়েস, বলুন কি বলছেন, কি প্রেয়ার দেখবো বলুন।
Is a page 7.
Page 7,
6 onwards.
to act accordingly. এটা আপনাকে তৈরি কে করে দিয়েছে?
ম্যাম আমি হেল্প নিয়ে করেছি।
কার থেকে হেল্প নিয়ে করেছেন? উকিল বাবুর না কোনো মুহুরির?
না ম্যাম, কোনো উকিল বাবুর আমি হেল্প নিয়ে করেছি।
সে উকিল কি হাইকোর্টে প্র্যাকটিস করে?
হ্যাঁ ম্যাম করে।
পেয়ারটা দেখুন, ওরা সুবিধের জন্য বাংলাতেই বলছি, পেয়ারটা দেখুন। উনি চুরি করেছেন, আমার ভাগটা দিলে এভরিথিং।
Reward award the petitioner with suitable amount as per provision of.
ফাইলিং করেছি।
এই পিটিশনটার কিন্তু কোনো রিলিফ আপনি পাবেন বলে আমার প্রেয়ার দেখে মনে হচ্ছে না।
আমি তো ম্যাম ইনভেস্টিগেশনের জন্য অ্যাপ্লাই করেছি ম্যাম। আমি তো
কিসের
শুধু
inve-
ইনভেস্টিগেশন চাই ম্যাম। আপনি লাস্ট পেজ গুলো আমি আপনাকে এখানটায় দেখাই। লাস্ট পেজ আপনি ম্যাম 14 নম্বর পেজ।
ছেলের বাবার এগেইনস্টে গ্রিভান্স, আমাকে কিছু দাও। পিটিশনটা কাইন্ডলি আমি লুক টু দ্য পিটিশন। কি টাইপ অফ পিটিশন?
14 নম্বর পেজে কি আছে?
হ্যাঁ 14 নম্বর পেজে ম্যাম দেখুন, ইনারা থাকেন এখানে, কিন্তু এই সব জায়গাতে ওনাদের প্রপার্টি আছে, আদার স্টেটে প্রপার্টি
থাকতে পারে না?
হ্যাঁ ম্যাম, এখানে ভোটার কার্ড ডকুমেন্ট পুরো আলাদা। এটা যখন ইনভেস্টিগেশন হবে, মানে যখন ইনি কিনেছেন সেখানকার আলাদা স্টেটের ভোটার কার্ড দিয়ে উনি কিনেছেন, ওখানকার ভোটার কার্ড আলাদা। তাহলে একটা মানুষের কটা ভোটার কার্ড হতে পারে ম্যাম? তারপরের পেজ 15 নম্বর পেজ।
We see is the public interest in litigation.
দাঁড়ান, প্লিজ ওয়েট।
15
আপনি
নম্বর পেজ।
কার সম্পত্তিতে ক্লেম চাইছেন এখানে?
এটা আমার রিলেটিভ, আমি ক্লেম চাইছি না ম্যাম, এটা আমি ইনভেস্টিগেশন চাইছি অ্যাজ এ বেনামি সম্পত্তি অ্যাক্ট 1998 এ।
আপনি এখানে প্রেয়ার করেছেন টু অর্ডার দ্য রেসপন্ডেন্ট নাম্বার 2 টু রিওয়ার্ড আর অ্যাওয়ার্ড দ্য পিটিশনার উইথ সুটেবল অ্যামাউন্ট অ্যাজ পার প্রভিশন অফ দি বেনামি প্রপার্টি ট্রানজাকশন অ্যাক্ট। এটা কি ধরনের প্রেয়ার?
ম্যাম আমি বেনামি সম্পত্তির অ্যাক্টে যেটা গভর্নমেন্টের রুল আছে যে বেনামি সম্পত্তি গভর্নমেন্টকে দেওয়ার পরে যে প্রাইজ মানিটা আমার ধার্য হবে সেটাই আমি ইয়ে করেছি।
আপনাকে কেন প্রাইজ মানি দেওয়া হবে?
ব্ল্যাক মানি তো হয়।
কোন কিছুতেই হয়।
এটা এটা
আমার ছেলে।
আচ্ছা, আপনি বলুন 3 নম্বর রেসপন্ডেন্ট কে হয় আপনার? সান অফ লেট জগদীশ ঝা। 3 নম্বর রেসপন্ডেন্ট কে হয়? 4 নম্বর, 5 নম্বর, 6 নম্বর, এদের সাথে আপনার কি সম্পর্ক আছে?
এরা আমার হাজবেন্ডের ফ্যামিলি।
হাজবেন্ডের ফ্যামিলি?
হ্যাঁ।
আপনার হাজবেন্ড আপনার সাথেই থাকেন?
হ্যাঁ আমার সাথেই থাকে।
আচ্ছা, এটা হাজবেন্ডের ফ্যামিলি।
হুম।
56326।
একবার সম্পত্তির লিস্টটা দেখুন ম্যাম।
সম্পত্তিগুলো কার?
সম্পত্তিগুলো হচ্ছে এনাদের 3 জনার, শৈল দেবী ঝা, জীবলাল ঝা, অজয় কুমার ঝা, শ্রীমতী ভারতী ঝা।
আচ্ছা।
শৈল দেবী ঝা হচ্ছে ওনার ওয়াইফ, মিস্টার জীবলাল ঝায়ের ওয়াইফ।
হ্যাঁ।
আচ্ছা ম্যাম, আমি 14 নম্বর প্যারাগ্রাফটা আপনাকে দেখতে বলেছিলাম। 14 নম্বর পেজ ম্যাম।
হ্যাঁ।
14 নম্বর পেজে এটা সাইল ঝায়ের নামে আছে ম্যাম। এনার লিস্টটা দেখুন, এনার ইনকাম কতটা। আমি ইনকাম ট্যাক্স আমার কাছে পেপার আছে, এই যে ইয়ারে আমি এটা দিয়েছি আপনাকে ডকুমেন্ট গুলো সেই ইয়ারে ইনকাম ট্যাক্সের পেপার আছে। এনারা হার্ডলি 5 লাখও 5 বছরে ফাইলিং করেন না। এটা হচ্ছে মানে এটা কয়েকটা শুধুমাত্র সাইল দেবী ঝায়ের। তারপরে পেজটা দেখুন 17 নম্বর, ভারতী ঝা। ভারতী ঝায়ের প্রপার্টি পেপার দেখুন ম্যাম।
কি করে এনারা কি করেন?
এনার কিছুই করেন না, সামান্য কেউ রঙের দোকানে কাজ করে আর বাকিরা সব হাউস ওয়াইফ। একটা হাউস ওয়াইফের এত প্রপার্টি কি করে হয়ে যায়? ভারতী ঝা হাউস ওয়াইফ, উনি ইনকাম ট্যাক্সের পেপার আমার কাছে আছে।
আপনি কি অনুমান করছেন যে টাকা কোথা থেকে আসছে?
হ্যাঁ সব ব্ল্যাক মানি।
কিসের ব্ল্যাক? কিসের ব্যবসা যে ব্ল্যাক হবে?
ম্যাম দেখুন ইনকাম ট্যাক্স।
আপনি বলুন না কোথা থেকে টাকাটা আসছে বলে আপনি অনুমান করছেন?
প্রপার্টিজ ম্যাম। এনারা
থেকে পাচ্ছে
বলছি এনারা প্রপার্টি যে সেলারের কাছ থেকে নিচ্ছেন বা বায়ারের কাছ থেকে বিক্রি করছেন, সেখানে উনি ধরুন গভর্নমেন্টকে যদি রেভিনিউ 2 লাখ, রেজিস্ট্রেশন 2 লাখ টাকা দিচ্ছে, বাকি 8 লাখ টাকা নিজের বাড়িতে নিয়ে যাচ্ছে, সেটা ব্ল্যাক মানি।
কেউ যদি ব্যবসা করে টাকাটা রোজগার করে তাতে ব্ল্যাক মানি কোথায়?
না ম্যাম, যদি এটাই হয় তাহলে তো ইনি তো গভর্নমেন্টকেও দেখাবেন, তাহলে এনার ইনকাম ট্যাক্সে কেন আসবে না? সেটা
ট্যাক্স দিচ্ছে না। আপনার বক্তব্য যে উনি রোজগার করছেন কিন্তু ট্যাক্স দিচ্ছেন না। ট্যাক্স দিয়ে দিলে
করছেন পুরোপুরি।
ট্যাক্স দিয়ে দিলে আপনার কোনো অসুবিধা নেই,
উনি ফুল ট্যাক্স পে করুন,
তাহলে কোনো অসুবিধা নেই। এটাই আপনার বক্তব্য?
আমার ইয়ে হচ্ছে ম্যাম, পুরোটা ইনভেস্টিগেশন করার জন্য আমি অ্যাপ্লাই করেছি। এনার কাছে ব্ল্যাক মানি প্রচুর আছে এবং
ব্ল্যাক মানিটা কোথা থেকে আসছে আপনি
উনি
কি
বলতে পারবেন ম্যাম, সেটা উনিই বলতে পারেন। আমি তো ডকুমেন্ট শো করছি, ইনভেস্টিগেশন করার দায়িত্ব ম্যাম আমার তো না। আমি তো ডকুমেন্ট দিচ্ছি ম্যাম, ওনার কাছে ব্ল্যাক মানি আছে। ইনকাম ট্যাক্স দিচ্ছি যে উনি ইনকাম ট্যাক্স পে করেন না। ম্যাম 17 নম্বর পেজ দেখুন, একটা
এর
হাউস
সাথে নবান্নর কি সম্পর্ক? সে তো ইনকাম ট্যাক্স অথরিটি বুঝবে, নবান্নকে কেন পার্টি করেছেন? স্টেট।
ম্যাম আপনি যাকে ভালো বুঝবেন ইনভেস্টিগেশন করার জন্য আপনি তাকে দিন।
না, আমার ভালো বোঝার ব্যাপার নেই, আপনাকে তো একটা প্রেয়ার করতে হবে কোর্টের কাছে, মামলাটা তো আপনার।
হ্যাঁ ম্যাম,
আপনাকে প্রেয়ার করতে হবে যে আপনি কোর্টের কাছ থেকে কি চাইছেন।
আমি ইনভেস্টিগেশন চাইছি ম্যাম, আমার এইটাই দাবি যে ইনভেস্টিগেশন।
আপনার দরখাস্ত কোথায়? ইনভেস্টিগেশনের কার কাছে দরখাস্ত করেছেন?
আপনি বললে ম্যাম আমি দরখাস্ত,
আমি কাউকে বলবো না, আমার বলার অধিকার নেই।
এর পরের দিন ম্যাম আমি দরখাস্ত দিয়ে দেবো। তাহলে
এই রকম ভাবে তো মামলা করা যায় না। আপনার যা বক্তব্য আপনাকে কোর্টের কাগজের ভেতরে বলতে হবে, মুখে মুখে এইরকম ভাবে বললে তো হবে না।
আমি এফিডেভিট করে দিয়ে দেবো ম্যাম জমা।
আপনার মামলায় আপনি ভালো কোনো উকিল বাবু এনগেজ করুন যাতে আপনাকে ঠিক। আমি কোনো সাজেশন দিতে পারবো না ম্যাডাম।
গেছিলাম ম্যাম, আমি লিগাল হেডের কাছে গেছিলাম, কিন্তু ওনারা আমাকে বললো যে একটা মানে নিজে উকিল বাবুর ইয়ের ফাইলিং করে দিতে আমাকে। কিন্তু আমি এর আগেও আপনাকে বলেছি ম্যাম, আমি 2019 সাল থেকে এই কেসটা লজ করার চেষ্টা করছি, কিন্তু আমি পারিনি। তার মাঝখানে
যে উকিল বাবুর
হ্যারাসমেন্ট হয়ে গেছে।
যে উকিল বাবুর সাহায্য নিয়ে আপনি এই পিটিশন তৈরি করেছেন, তিনি তো আপনাকে একটুও সাহায্য করতে পারেননি।
ম্যাম প্রপার্টি রিলেটেড গুলো একটু নজর বলে খুব ভালো হয়।
আপনি এনফোর্সমেন্ট ডিরেক্টরেটকে কিভাবে সার্ভিস করেছে দেখি। ডিড শি ফাইল আর এফিডেভিট অফ সার্ভিস?
এমন মনে আমি 3টা ভাবে সার্ভিস করেছি, মামলার পরের দিন এসে পৌঁছেছে। আমার এসব ডকুমেন্ট গুলো আছে
ম্যাম।
মোটিভেশনাল পারপাস।
ম্যাম এখানে অরিজিনালটা ঠিক
না, অরিজিনাল আমি দেখবো না। Certain allegations are there against your clients. Yes.
First thing, my lord, she was satisfied. Yes, she has got a substantial legal.
ম্যাম বাংলায় বললে বেশি সুবিধা হয় ম্যাম।
আচ্ছা বেশ, বাংলায় বলছি ভাই, কিছু মনে করবেন না। ওনাকে দেখাতে হবে ওনার একটা এইটুকুই বুঝবেন তো সাবস্টেন্স লিগ্যাল রাইট আছে, পাবলিক লিটিগেশন নয়। উনি দেখুন অদ্ভুত ব্যাপার, যে পিটিশনটা লিখেছেন কেম টু নো অ্যাফার্ম করেছে, লয়ার দিয়ে করেছে, টু মাই নলেজ। আর তাছাড়া আমি যদি কোনো আন্ডার ভ্যালু করে প্রপার্টি কিনেও থাকি, আমাকে তো রেজিস্টার ধরবে। তার জন্য যেটা রেজিস্ট্রি স্ট্যাম্পের ভ্যালু সেটা দেবো। এক্স এন্ড ওয়াই তারা একটা প্রপার্টি যদি কম দামে ট্রানজাকশন করেন, তাহলে ইনকাম ট্যাক্স অথরিটি বলতে পারে যে তুমি ট্যাক্স ফাইল দিতে। পেনাল্টি
ম্যাম এটা ইনকাম ট্যাক্সের পেপার ম্যাম।
পেনাল্টি কিছু নাই, দিয়ে দেবো টাকা ইফ ইট ইজ ফাউন্ড। কিন্তু ওনার রাইটটা কি?
ম্যাম যে ইয়ারে আমি দিয়েছি ডকুমেন্ট গুলো সেই ইয়ারে ইনকাম ট্যাক্সের পেপার। আর গভর্নমেন্টের রুল তো আছে ম্যাম, যেখানে লেখা আছে বেনামি সম্পত্তি গভর্নমেন্টকে দেওয়া যায়, গভর্নমেন্ট সিজ করতে পারে।
এখন তো এবার আমি একটু বলি, ফার্স্ট থিং ওনার আদৌ পিটিশনটা এখানে চলে কিনা, কারণ উনি একজন যার কোনো লিগাল পাইলট যদি মিতাক্ষরাতেও হয়, সোলং আর হাজবেন্ড যতদিন ওনার স্বামী বেঁচে আছেন, উনি কি করে এখানে আসতে পারেন রিট কোর্টে? ইটস নট এ পাবলিক ইন্টারেস্ট লিটিগেশনস। উনি চলে এলেন।
ম্যাম কেসটাকে আমার নষ্ট করার চেষ্টা করছেন।
দাঁড়ান, আপনি এরকম করে এটা তো হাইকোর্ট, এখানে এরকম ভাবে মামলা করা যায় না। আপনাকে কিছু নিয়ম কানুন মেনে তারপর মামলা করতে হবে। আপনি যখন কথা বলছিলেন উনি একবারও ডিস্টার্ব করেননি, উনি যখন কথা বলবেন আপনি ডিস্টার্ব করবেন না।
আমি বুঝতে পারছি, ঠিক আছে, যদি আমি টাকা ওকে দিইনি, ওনার হাজবেন্ডকে, ওনাকে নয়, তো অন্য ছেলেদের দিয়েছি, আর উনি বাবা মাকে দেখেনি না, এসব কথা উঠবেই। আমাকে দেখতে হবে না, কিন্তু আমার স্ত্রী যেন মা, হাজবেন্ড, সেও কোনোদিন দেখে না, তার খালি কথা যে টাকা দাও, পেয়ারি তাই রয়েছে আমাকে। মানে আমার চুরির টাকাটা যদি আদৌ করে থাকি, তার ভাগটা যদি ওনাকে দিয়ে দিই, উনি ব্যাস, আর আমার কিছু দরকার নেই। আরে কি ব্যাপার রে বাবা, এটা মেনটেনেবল না।
ম্যাম এবার আমি একবার বলি ম্যাম। ম্যাম আমাদের উকিলবাবু বললেন যে ওনার মানে যেটা বলে যে আমি দেখি না বা সেবা করি না, যেটা বাংলা অর্থ। তো ম্যাম আমি যদি বলি মিস্টার জীবলাল ঝা সমস্ত সম্পত্তির মালিক, উনি ওনার কথা হিসাবে, তাহলে ওনার কথা হিসাবে মিসেস সেইল দেবী ঝাকে উনি কটা প্রপার্টি দিয়েছেন একবার ম্যাম নোটিস করুন, কটা প্রপার্টি উনি
এখানে
দিয়েছেন।
কিন্তু পারিবারিক সমস্যা মেটানোর জায়গা নয় এটা।
না ম্যাম, উনি 5টা প্রপার্টি দিয়েছেন, কিন্তু ভারতী ঝা যিনি 50 বছর সংসার করলেন, যার সাথে উনি 50টা বছর সংসার করলেন, তিনাকে মানে এতটাই বিশ্বাস করেন উনি 5টা প্রপার্টি দিয়েছেন। আর যে মাত্র 20 বছর এসে সংসারে ঢুকেছে, যে বৌমা, তাকে উনি 4-5 পাতার প্রপার্টি, এটা তো জাস্ট সামান্য ম্যাম, এখনো বাকিটা আমি ডিটেল দিইনি। তাহলে বলুন যে এখানে সেবার স্পেশালটা কি? ওনার
আপনি কাকে কাকে পার্টি করবেন আর কাকে পিটিশন কিভাবে অ্যামেন্ড করবেন, আপনি কি ফাইল করছেন? অ্যাপ্লিকেশন ফর অ্যামেন্ডমেন্ট তো আপনাকে ডিপার্টমেন্টে ফাইল করতে হবে, এখানে তো ফাইল করা যাবে না।
চেক করাবো ম্যাম?
না, এটা সেটেলমেন্ট করার জায়গা নয়।
ম্যাম আমি এটা ফাইলিং করিয়ে দিচ্ছি।
Please come.
Original petition has to be amended.
কি বলবো,
How this can
Cannot be done this manner.
cannot be. And so far, Miller, another thing is that if she is seeking for an investigation, in that event it will go to court number 34. Investigation is part.
Where is the prayer?
Prayer I have seen.
There is no prayer. How can this?
Not only that, Miller, the manner she has made the representation to the EC, this is not the right way.
ম্যাম আমাকে যে লয়ারটা গাইড করেছে, উনি
আপনাকে ঠিক মতন গাইড করতে পারেননি। আমি বারবারই বলছি আপনাকে একজন উকিলবাবুকে সাহায্য নেওয়া উচিত, যিনি এই মামলাগুলো করতে পারেন। আপনি কার সাহায্য নিয়েছেন সেটা আপনি জানেন, কিন্তু যে সাহায্য যিনি আপনাকে করে দিয়েছেন তিনি আপনাকে ঠিক মতন সাহায্য করতে পারেননি, উল্টে আপনার মামলা আরো খারাপ হয়ে গেছে। Please come. How can this writ petition be maintained? I do not know.
Not at all. In person appearing, that is why I have not taken the point.
Difficulty. This is the
That is-
difficulty
that
of
is
the
why I
court
have not
also.
taken the point. But some, Miller, some stature has to be maintained.
Certainly.
This is not.
I don't know what you are filing.
ম্যাম
This is not the right.
Please come.
ম্যাম ইন পার্সন হলে কি আমরা কি মানে এরকম কি কিছু করতে পারবো না?
না, পারবেন না, কখনোই করা যায় না। এখানে উকিলবাবুরা কিসের জন্য আছেন? তাহলে তো সবাই এখানে এসে ইন পার্সন মামলা করতে পারতো, যদি সবাই আইন জেনে যেত। আপনার কিছু অভিযোগ থাকতেই পারে আপনার পরিবারের লোকের সম্বন্ধে, কিন্তু তার মানে এই নয় যে আপনি হাইকোর্টে এসে রিট পিটিশন এইরকম ভাবে ফাইল করতে পারবেন। সেটা হয় না,
আমি
আইন সেটা নয়।
জন্য দিয়েছি ম্যাম, আমি তো শুধু ইনভেস্টিগেশন চাইছি শুধু।
আপনি যে ইনভেস্টিগেশন চেয়েছেন, আপনার প্রেয়ারে একটা কথা লেখা আছে ইনভেস্টিগেশনের ব্যাপারে? আপনি আমাকে দেখান যে একটা প্রেয়ার আছে যেখানে ইনভেস্টিগেশন বলা আছে। আপনি বলুন যে এখানে এই প্রেয়ারটা অ্যালাউ করুন, এখানে ইনভেস্টিগেশন বলা আছে, আমি আপনার পিটিশন অ্যালাউ করে দেবো। আছে? আপনি মুখে এক বলছেন, আপনার কাগজে অন্য রকম লেখা আছে, পাশের উকিলবাবু অন্য একটা কথা বলবে, আপনার মামলাটা কি করে দাঁড়াবে?
ম্যাম ওনারা তো চাই যাতে ফাইলিংটা না হোক। আমি তো আগেও বলেছি 2019 সাল থেকে উনি এভাবেই করছেন, যাতে
আপনি আগে আপনারটা দেখুন, আপনি অপর পক্ষের দেখবেন কেন? আপনি আপনারটা দেখুন যে আপনি কিভাবে মামলা ফাইল করবেন।
হ্যাঁ ম্যাম
এত মামলা ফাইল হচ্ছে, কেউ মামলা করতে পারছে না, সেটা তো হয় না। উকিলবাবু তো একজন নেই। লিখুন তো, the petitioner appears in person and seeks leave to amend the writ petition as she intends to add some more respondents as parties in the instant writ petition. Stop paragraph. Leave granted to the petitioner to file application for amendment seeking addition of the respondents as parties in the writ petition and serve copy of the writ petition along with the application seeking amendment before the non-appearing respondents. Stop paragraph. An application for amendment shall be served upon the learned counsels appearing in court today. Stop. Next. কতদিনে আপনি করতে পারবেন? আমি নেক্সট ডেট ওই অনুযায়ী দেব।
আপনার যদি কিছুদিনের মধ্যে দেন ম্যাম, এক সপ্তাহের মধ্যে।
ফাইল তো আপনাকে ডিপার্টমেন্টে করতে হবে, আপনি সার্ভিস করে আসুন সামনের সোমবার দিন। আমি
করে রেখেছি ম্যাম, আপনি বৃহস্পতিবার দিন সময় দেন না?
বৃহস্পতিবার না, সামনের সোমবার। আপনি বৃহস্পতিবার তো ছুটি আছে, 23 তারিখ। সামনের সোমবার দিন 27 তারিখে আমি দিয়ে দিচ্ছি।
ওকে ম্যাম।
27th.
27 for hearing.
No, application has been filed for amendment. Application filed for amendment. I do not know. Has the wakalatnama been filed by your clients? Please file it in the department. Leave granted to the learned advocate representing the private respondents to file wakalatnama in the department in the course of the day. In course of this day. Jana babu, এই কাগজগুলো service shall be filed on the adjourned date.
Thank you ম্যাম।
My lord, I appear for the petitioner.
Yes.
My lord, the writ petition arises out of, my lord, an impugned letter which relates to, my lord, the willful defaulters action. My lord, in 2 minutes, I'll tell your lordship. This is the second round, my lord, I am approaching this court. My lord, in the first round, my lord, I had challenged the bank's action because it did not conform to the RBI guidelines. My lord, lordship is aware, my lord, in terms of the RBI guidelines, there are 2 stages.
Indian Overseas Bank.
I am for the bank. My lord.
Both the respondents.
Both the respondents.
My lord, as per the RBI guidelines, there are 2 stages for determining a willful defaulter. Well, the first stage is called the identification committee. The second stage is called the review committee. Now, my lord, in this, my lord, in the prior round, since the only document they were relying upon, they did not serve us. This honorable court was pleased to quash the entire proceeding and had asked them to furnish us the document and start de novo the entire proceedings. My lord, kindly have a look at that order first. If lordship is pleased to come to page 87. This is the order dated 1st December 2023. Lord, I take your lordship to the relevant portion of the order. My lord, kindly straight away come to page 92, paragraph 26.
Why are the photocopies so illegible?
I am sorry, your lord. Photocopy illegible?
Yes. Page number 90?
My lord, 92.
92?
Para 26.
Yes.
Moreover, the relevant document and pleadings of the petitioner were never taken into consideration. On such grounds, none of the orders can survive the scrutiny of judicial review. My lord, 2 orders were challenged, both the identification committee and the review committee. Review committee is not exactly an appellate forum, but it's the second forum, my lord, which determines the correctness. Accordingly, WPS so-and-so is allowed on contest, thereby setting aside the orders of, well, kindly see, both the orders were set aside, willful defaulter identification committee and the review committee, whereby the petitioner was held to be a willful defaulter. The first committee, that is the willful defaulter identification committee, shall now proceed on the basis of the show cause notice initially given to the petitioner by furnishing to the petitioner the forensic audit report as well as other documents on which the respondent bank seeks to rely. So, my lord, para 27 is clear that the first committee will first furnish the report and then proceed. And then para 28, upon such copies being furnished and opportunity being given to the petitioner, willful defaulter committee shall revisit the issue and decide on the question as to whether the petitioner can be declared a willful defaulter under the relevant circular. Now, my lord, after this, there is no dispute, my lord. They furnish us the forensic audit report, which which Lordship will find at page 94. This is the covering letter.
Yes.
And after getting this report, we also give a representation, which is also there, my lord, at page 248. But my lord, before that, the impugned circular or the impugned notification for which we have come before your lordship, my lord, kindly straight away come to that. My lord, one committee has been skipped. That is, my lord, our grievance. Kindly come to the impugned notification of 28th December 2024 at page 270, my lord. It should be 270.
270?
270.
Yes.
My lord, I am concerned with, my lord, the second, I am Vijay Botra is the petitioner before your lordship. That is, my lord, in the notice, my lord, serial number 2. We refer to the order of the Honorable High Court dated 1st December on the subject matter. We wish to inform that the review committee in its meeting of 17 December has declared to accord has decided to accord personal hearing opportunity to you. One forum is skipped. Straight away goes to the appellate forum, and
the identification committee did not do anything.
Nothing. No notice for hearing. Well, lordship will kindly come to page 246. In fact, when we had got the letter, we had made a representation. 246, lordship is pleased to come to.
Yes. 246.
Intimation letter to the borrower proprietor on recommending the proposal to review committee for declaring the borrower proprietor as willful defaulter. Straight away, my lord, they have proceeded to the review committee at page 247, paragraph 7. As directed by the Honorable High Court in its order of 1st December, we have furnished a copy of forensic audit report. Identification committee has examined the material on record, has decided to recommend the proposal to review committee. Straight away, one forum skipped. I don't get an opportunity to go to the first forum, which is the identification committee.
Page 247, serial number 6, it mentions the identification committee has issued show cause notice to you.
The show cause notice is the parent show cause notice, which was the subject matter in terms of the order of the High Court. That show cause notice was to be proceeded with by the identification committee by furnishing me the document.
Right.
I don't get the opportunity to go to the identification committee with that document. Straight away, my lord, I get this letter that the identification committee has referred to the review committee. And then when I write to this letter that in terms of the order of the High Court, I am to get an opportunity to appear before both the committees, I get the impugned letter saying that you make a representation before the review committee.
Did you submit your reply to the show cause?
Yes. Show cause reply was submitted earlier itself. And even to this, my lord, we have written a reply, which lordship will find at the next page. 248, 19 December.
247 mentions about the show cause. Why you will not be classified as willful defaulter?
Yes, my lord. Show cause was given. Show cause given earlier. Show cause, my lord, we responded. Then, my lord, when they did not follow the RBI circular, we come up at the first instance. The only grievance was that the document that you are relying upon was not furnished. My lord, the Honorable Court was pleased to set aside both the orders, direct them to revisit the issue after furnishing a document. My lord, in fact, my lord, if lordship wants, my lord, kindly have a look. Show cause it at page 37 and we had given a reply in page 40. That was long ago, my lord, in 2020 during COVID times. On merits also, my lord, I can show your lordship, but that's secondary. All that I am seeking, my lord, this should be set aside. Let the first committee, my lord, give me an opportunity and do it, my lord. I'll make the representation. I cannot be, my lord, deprived of a forum.
No, 248 is a representation already there. Your reply to show cause is already on record.
Already on record. Reply to show cause is already on record, my lord. The representation I made, my lord, after getting the forensic audit report.
Where is that?
248, lordship will see.
248.
Yes.
Very well. 248.
248, 19 December. In that, my lord, at page 256, if my lord is pleased to come to.
Yes. Everything is mentioned.
Yes, 256, my lord, I mentioned.
I have followed.
Today, my lord, the hearing is fixed at 2 o'clock for the review committee.
Review committee.
Committee. Identification committee, no hearing.
My lord, on 30th July 2024, new guidelines, my lord, have been framed by the RBI.
2024.
Yes, 30th July
Court
20.
passed order in 2023.
Yes.
Why will that order not be complied with?
My lord, may I just, my lord?
Please come to page 92 once.
My lord, I have seen that order.
Let us hear it, read it together
Yes,
once.
yes, my lord.
Page 20, paragraph number 28, please read.
Yes, my lord. Upon such copies being furnished and an opportunity of hearing being given to the petitioner.
Whether this has been given or not, I will not go any further.
Willful defaulter. My lord, may I just, my lord, kindly see paragraphs 27 and 28.
Yes.
Insofar as paragraphs 26, 27 and 28 are concerned, the reference is being made to the willful defaulter identification committee.
Yes.
Namely, my lord, the committee which identifies.
Right.
And thereafter, my lord, the reference is being made to the willful defaulter committee without specifying whether it's the identification committee or the review committee. But if your lordship sees,
if you feel that there is any ambiguity in the order, you should have gone there for clarification. I can see over here, or what the court, the impression is, opportunity of hearing being given to the petitioner. The willful defaulter committee, it is silent whether it is identification or the review. But first thing first, identification comes first and then the review. So why not give them an opportunity of hearing by the identification committee and then you proceed in accordance with law?
My lord, it will open a Pandora's box. And I'll tell your lordship why. Kindly take page 246 for a moment.
If that is so, then you ought to have appealed against this order.
No, my lord, they ought to have challenged what I have communicated to them, which they haven't. They accepted. But kindly see page 246 and 47 for a moment, my lord. Kindly, my lord, see for a moment.
Yes.
My lord, page 246, I intimate to them that a proposal has been circulated by the committee, the identification, the first committee, to the review committee. And kindly at 247, my lord, see the last line. Please note that in case no representation submission is received by review committee, so and so, and my lord, kindly see the last line. In line with RBI master guidelines on treatment of willful defaulters and large defaulters dated 30th July 2024, and the decision of the review committee will be final. So I have intimated to them that there are these, and this document has not, this has not been challenged.
Please.
Kindly
the court's order is of sometimes in December 23, if I can correctly. Yes, 1st of December 23. You are relying upon the circular, which is July 2024. Why will the court permit you?
My lord, there is a rule frame. Kindly.
Why will the court permit you? Why not the rule which was prevalent in December 2023 be applied?
Because, my lord, these guidelines have been framed in 2024. Sir. Procedural aspect, my lord. Procedural law.
Procedural aspect wasn't anything there in 2023. There was.
My lord, unless.
Why will you not apply that?
My lord, because may I answer?
No, nothing doing.
In law, may I just answer this in law? Kindly consider, my lord, one answer in law.
No, sorry.
My lord, procedural law, unless, my lord, directed to be retrospective, will operate, my lord. My lord, kindly consider this point, my lord. Kindly, my lord. Just one legal submission and I will stop.
No, please, I will not accept your submission. The petitioners are aggrieved. Petitioner or petitioner, please check. Is aggrieved by the action taken by the bank contrary to the direction passed by the court on 1st December 2023 in WPA 25317 of 2023. In the aforesaid by the said order, the court was pleased to set aside the orders of the willful defaulter identification committee and the review committee, whereby the petitioner was held to be a willful defaulter. Stop. The court directed that the identification committee shall proceed on the basis of the show cause notice given to the petitioner by furnishing the petitioner the forensic audit report as well as the other documents on which the bank seeks to rely in support of the allegation of willful default. Stop. The court further directed that upon copies being furnished and an opportunity of hearing being given to the petitioner, the willful defaulter committee shall revisit the issue and decide the question as to whether the petitioner can be declared to be willful defaulter under the relevant Master Circular of the Reserve Bank of India. Paragraph. The reply to the show cause by the petitioner was already filed before the bank. Stop. The bank has forwarded the petitioner the forensic audit report, but thereafter did not. But thereafter, the willful defaulter identification committee did not grant any opportunity of hearing to the petitioner, but recommended the proposal of identifying the petitioner as willful default to the review committee for declaration as willful defaulter. Stop. Paragraph. Specific contention of the petitioner is that no opportunity was given by the no opportunity of hearing was given to the petitioner by the identification committee. Stop. The matter has been directly recommended to the review committee. Stop. The petitioner has lost one forum. Paragraph. According to the bank, the court video order dated 1st December 2023 did not specify as to which authority will grant an opportunity of hearing to the petitioner. Stop. The court merely directed an opportunity of hearing to be given to the petitioner by the willful defaulter committee. Stop. The bank has directed the review committee to afford an opportunity of hearing to the petitioner. Stop. The same has been done strictly in accordance with the RBI Master Guidelines on treatment of willful defaulters, dated 30th July 2024. Stop. Paragraph. The bank has practically admitted that opportunity of hearing was not given to the petitioner by the identification committee. Stop. Paragraph. The action of the bank in referring to the RBI Master Guidelines dated 30th July 2024 appears to be contrary to the direction passed by the court on 1st December 2023. Stop. The initial action of the bank was taken prior to the RBI Master Guidelines dated 30th July 2024 coming into force. Stop. Paragraph. The bank ought to have acted in terms of the guidelines which were prevailing on the day. Steps for declaration of the petitioner as willful defaulter was taken by the bank. Stop. The guidelines dated 30th July 2024 were not in existence when initial steps were taken against the petitioner and when the order was passed by the court on 1st December 2023. Stop paragraph. In view of the above, directing the petitioner to appear for hearing before the review committee without proper identification by the identification committee does not appear to be in consonance with the direction passed by the court on 1st December 2023. Stop. The action of the bank accordingly cannot be supported in law. Stop. The bank is directed to revisit the issue strictly in terms of the direction passed by the court on 1st December 2023 in WPA 25317 of 2023. Stop. The writ petition stands disposed of.
My lord, the impugned letter of 20th December, my lord, maybe.
Where is it?
My lord, page 270, my lord.
270. The impugned communication of the bank dated 20th of December 2024 accordingly stands set aside.
Deeply obliged.
Grateful, my lord.
My lord, I appear, my lord, for the writ petitioner. And I'm moving upon notice.
I am for the respondent 2 and 3.
1.
2 is Coal India, 2 and 3 is Coal India.
Answering respondent?
Yes, ma'am.
My lord, may I file the affidavit of service? Judge. My lord, there's a challenge, my lord, here, my lord, to, my lord, an order of blacklisting. Now, my lord, a show cause notice, my lord, was issued, my lord, on 12th of March 2024, which is at volume 2, my lord, page 387.
Page 387.
Yes, my lord.
Yes.
Page 387.
Yes.
My lord, it is, my lord, I have, my lord, been one of, my lord, the major suppliers of explosives, my lord, to Coal India and its subsidiaries, my lord, for the purposes of its mining activities. Now, my lord, this show cause notice, my lord, was issued to me on 12th of March 2024. My lord, it relies, my lord, on, my lord, an independent auditor's report, and, my lord, it goes on, my lord, till page 390. Now, my lord, two very important facts, my lord, is to be mentioned here. My lord, first is, my lord, it, my lord, refers to, my lord, action to be taken on the basis of Coal India's purchase manual. Lordship will find that, my lord, at the bottom of page 390, last paragraph. My lord, we were given 21 days, my lord, penultimate paragraph to submit your defense in case it shall be presumed and penal action shall be taken, etc. Now, my lord, we gave a reply, my lord, which is, my lord, on 3rd of May, 2024, my lord, which is in volume 2, pages 395 to 398.
All right.
My lord, we gave our, my lord, entire defense there. Then comes, my lord, the, my lord, impugned order, which is, my lord, at page 399. Kindly have a look at that order.
Yes.
My lord, it's a 2-page order. Coal India Limited had issued an open e-tender dated so-and-so for conclusion of running contracts for supply of bulk explosives to all subsidiaries. Against this tender, you had submitted your offer dated 12th August. So-and-so, your offer document along with shortfall documents was evaluated as per NIT provisions as you submitted local content certificate certified issued by your cost accountants, so-and-so claiming to be so-and-so in your offered product. You were treated as class 1 local supplier and accordingly running contract, RC Miller running contract was concluded with you for supply of bulk explosives. Subsequently, we were in receipt of a complaint written to the Honorable Minister of Coal, Mines and Parliament questioning the authenticity of local content submitted by you against the above tender as well as tender number so-and-so dated so-and-so for supply. As per clause 6B instruction, in case of complaint, CIL may constitute committees with internal and external experts for independent verification of self-declaration auditors. In view of above, Devendra Kumar, Chartered Accountants were engaged by CIL as external experts for independently verifying the local content certificate submitted by you against above tenders. You were informed of the same via a letter dated so-and-so wherein your cooperation was sought. After protracted correspondence and obtaining the necessary documents from you and your cost accountants, the external experts submitted their report on 31st December 2023. From the external experts report, it is evident that NIT terms have not been complied with while submitting the local content certificate against tender number so-and-so, as products other than offered product were also taken into consideration and not all the facilities where offered product was manufactured were taken into consideration. Further, accounting standards were also not complied with by including cost of transport of ammonium nitrate from port to factory premises in direct cost of local domestic material instead of cost of import. Further, budgeted ammonium nitrate price and exchange rate of so-and-so have been considered instead of actual so-and-so and exchange rate during. CIL vide show cause notice dated so-and-so communicated the summary of expert report to you. Against this, you had vide email dated 20th March cited certain reasons and sought 60 days additional time beyond 21 days to furnish reply to show cause. CIL vide the letter dated so-and-so granted you additional time of 30 days. That is still so-and-so to submit your statement of defense against CIL and show cause notice. Subsequently, your reply vide letter dated has been examined and it has been found that charges of willful suppression of facts, furnishing of wrong information and submission of false declarations stand against you. Consequent to the above, the following decision of the CIL are hereby communicated. You are banned for award of any contract order by CIL or its subsidiaries for a period of 2 years from date of issue of this order. However, and this is the maximum period, my lord, 2 years. However, the banning order will not be applicable for the ongoing running contract so-and-so for supply of so-and-so and running contract so-and-so for supply to all subsidiary companies, including NEC. Now, my lord, I have 6 grounds, my lord, to challenge, my lord, this blacklisting, my lord, order. First is, it has not, my lord, dealt with our reply at all. It is, my lord, just says, vide reply has been examined, found that charges of so-and-so, so-and-so, so-and-so. So, my lord, reply actually, my lord, what our stand is, why it is wrong, my lord, there is, my lord, no reasons at all. So, first, it does not deal with our reply. Second, my lord, it gives no, my lord, reasons. Third, my lord, and this is very important, my lord, it does not comply with clause 6 of the purchase manual. Now, my lord, kindly take, my lord, page 401, my lord, where, my lord, which is in volume 2 again. Yes, my lord, kindly come to, my lord, page, my lord, 428. It's 401, it starts, kindly come to 428. My lord, 6.13.2, banning debarment of business. Kindly come to, my lord, just above clause I, middle of the page. Banning of business should be considered in the following cases. Lordships have that, my lord?
Yes.
Now kindly come to page 429, my lord, subclause 6. At the top, my lord, 4th line.
Yes.
Willful suppression of facts or furnishing of wrong information, false declaration. My lord, the others were not, my lord, relied on, so I'm looking at these 3. Now, my lord, kindly come to, my lord, 6.13.4, period of banning. The period of banning should be decided based on the gravity of the offense. Now, my lord, kindly mark the next limb. And the quantum of loss suffered by CIL or the subsidiary companies. Now, my lord, I pause here for a moment. An essential ingredient, my lord, which has to be considered is, my lord, the loss suffered by reason of, my lord, the offense complained of. My lord, here, no loss, my lord, has been suffered. There is no finding, and, my lord, there is no loss. Yet, my lord, maximum period, my lord, of 2 years, my lord, has been, my lord, imposed. There is no allegation also, my lord, in the show cause notice of, my lord, any loss, my lord, having been suffered, let alone, my lord, a finding, my lord, in, my lord, the order, my lord, of. So, my lord, my first ground is, this is contrary, my lord, to, my lord, the, my lord, purchase manual, which is squarely, my lord, referred to in the show cause notice. Second, my lord, and here, my lord, I point out the contradiction. My lord, if I were, my lord, guilty of loss, or, my lord, the severity of this was there, my lord, of, my lord, suppression, manipulation, etc. There was no question, my lord, of, my lord, my existing orders, my lord, I am being asked to complete. Both the, your lordship seen, my lord, the banning order itself, it will not apply, my lord, for another 2 years with regard to, my lord, the running contract, my lord, that I'm operating from 2023. Then, my lord, your lordship will kindly note, no personal hearing. My lord, even when, my lord, the report, my lord, is prepared, my lord, we are given excerpts. We are not given, my lord, the entirety of the report. And fifth, and this is very, my lord, important, my lord, is, my lord, your lordship will find another clause, my lord, here, my lord, of 6.13.58, my lord, page 431.
Yes.
My lord, if it is decided to resort to banning of business of the firm with all subsidiaries, here, my lord, it's CIL and all its subsidiaries, a fresh show cause notice will have to be issued to the firm, giving it reasonable time of 21 days to reply. Thereafter, the usual procedure for banning, etc. Here again, my lord, a second show cause notice, my lord, is to be, my lord, given, which, my lord, has admittedly, my lord, not been done. Because I am being banned, my lord, to dealing with CIL and both its subsidiaries. Now, my lord, kindly come to 6.13.5.11 at page 431. If after issuance of banning order by the subsidiary company stroke CIL, the firm comes up with any appeal or representation seeking withdrawal or any modification of the order, the matter should be decided with the approval of Chairman CIL. Now, my lord, this, my lord, banning order came, my lord, on 2nd of July 2024. Now, my lord, what do? On 18 July, my lord, I ask for review. I point out, my lord, very importantly, my lord, because of the Ukraine war, my lord, no ammonium, my lord, was being imported into India. So, my lord, local content certificate, which is based on estimations, my lord, of, my lord, what the local content will be, because nitrate, my lord, is manufactured, my lord, in India. My lord, ammonium, my lord, is imported, and, my lord, ammonium nitrate together, my lord, is, my lord, what is, my lord, supplied. That is, my lord, part of, my lord, the explosive. I pointed out in that, my lord, even if they are right, my lord, in, my lord, interpretation of my local content certificate, this relevant factor needs to be taken into consideration. 18 July, I gave them that representation. Now, my lord, kindly see what happens. My lord, I write another letter, my lord, which is, my lord, 24th of December of this year, my lord, which is at page 455, my lord, 455. Kindly, my lord, take that letter once.
Yes.
I point out, my lord, that, my lord, because of, my lord, this ban also, this is after, my lord, 18 July, where I point out, my lord, I must show you, kindly give me a moment, my lord, I'm sorry. I should have shown your lordship, my lord, the 18 July letter, because, my lord, this recognizes, my lord, the shortage recognized by the government, my lord, of supply of ammonia. Then, my lord, kindly take, my lord, page 18 July is at page 432. My lord, kindly come, my lord, to page 433. My lord, the heading is, my lord, your lordships will find not fulfilling the 50% local content local content condition. Now, my lord, kindly come to 434. my lord, September 2021 to January 2022, 434 top, my lord. We experience restricted supply of ammonia, including domestic, expressing to supply so-and-so for product meant for CIL. As sample evidence, we are submitting emails from RCF, email correspondence with ammonium nitrate manufacturers. February 2022, Russia-Ukraine war broke out in February, causing severe supply. As a consequent, import prices of ammonium nitrate rose from 45,000 to 71,400 in March. The domestic supply was already constrained and the import price impacted our cost balance, so-and-so. Situation continued. March 22, the fact of the above impact is further reinforced by the Honorable Minister for Parliamentary Affairs, Coal and Mines in his answer to a query in Lok Sabha stating that the domestic production of so-and-so is not sufficient to meet the requirement for manufacture of various kinds of explosives used for coal mining, non-coal mining and infrastructure projects, and therefore explosive manufacturers use a mix of domestic and imported ammonium nitrate for manufacture. Then April 22, to address this extreme ammonium nitrate shortage, Ministry of Coal Government under chairmanship of Sri so-and-so convened a meeting with participants, Department of so-and-so to discuss mitigating measures for above problem. January 22, while the domestic ammonium nitrate supply scarcity continued, recourse to importing ammonium nitrate was also severe constraint due to ban on import after Beirut explosion. Under this severe ammonium nitrate constraint, Southern Coalfields wrote to DPIT emphasizing the detrimental impact on local energy, requesting for easing on constraint on imports from Vizag. This indicates to the continued ammonium nitrate constraint. July 22, meeting was hosted by DPIT, Ministry of Coal under the chairmanship of Additional to review shortage. August 22, refusal of Ministry of to impose anti-dumping duty on imported so-and-so through letter dated is further evidence of continued scarcity. September 22, subsequent to April, another meeting was held Ministry of Coal under chairmanship of so-and-so with participants from so-and-so and explain discuss the continued dominion. Despite all these adverse events, we continued our supply to CIL and played our humble role supporting domestic mining in respect of increasing ammonium nitrate cost and loss of profitability. Company has always stood by. So, my lord, this is factors which were beyond our control, which is pointed out. They take no, my lord, step. Now, my lord, kindly come to the December letter. We're at page 455. My lord, 6 months have gone by. My lord, they do nothing. My lord, we lose a contract worth, my lord, about 200 crores. The lordship will find that with 24 December 2024. Third paragraph. Recently, Singaneri Collieries, my lord, first para refers to my representation, which has not been considered as yet. Recently, Singaneri Collieries Company Limited disqualified us and did not consider our bid solely because of the ban imposed by CI. We had to close our operations at our Ramgundam unit at Telangana and retrench manpower. This resulted in loss of business of 200 crore for a period of 2 years. Imposition of ban halted our supply chain, resulting in closure of manufacturing. This has not only affected, etc. So, my lord, this again, my lord, in spite of this representation, no steps. And then comes, my lord, the last, my lord, document. My lord, why, my lord, there is urgency. My lord, this is 19 December, page 457, my lord. Kindly take, my lord, page 457. 19 December, notice for pre-NIT meeting. Coal India will hold a pre-NIT meeting on 30th of 3 p.m. through video conferencing for discussion of so-and-so and empanelment as reserve RC holder for a period of 2 years, 2027, 2027, or 25 to 27 for supply of cartridge, which is, my lord, P5 explosive, pentadine. Pre-NIT document number so-and-so can be downloaded so-and-so. Interested bidders may submit. Now, my lord, this is, my lord, there are only 3 suppliers, my lord, of this particular product. I've been kept out of 1-200. My lord, Crow, my lord, contract. I have, my lord, no steps are being taken with regard to my review. Now, my lord, they have said for 2025-27, we are going to have a running contract. My lord, here, my lord, the NIT, my lord, this was pre-NIT, is usually within a month, which is, my lord, end of January it will come. And, my lord, the contracts are finalized from April for supplies, my lord, to start from July. My lord, this is the position. So all that I was praying, my lord, was that at this stage, my lord, they may file affidavits, my lord, to this petition. But, my lord, I should be allowed to submit my bid. And there's, my lord, 2 months time within which, my lord, this matter, my lord, can be decided whether this blacklisting is bad or not. Because, my lord, I can't, my lord, in effect, I'm trying to be fair, my lord, if I ask, my lord, for stay of blacklisting, it's really allowing the writ. My lord, if they wish to file.
Why can't they consider your request for review? Because according to their.
Because 6 months, my lord, have passed, my lord, now.
Your application was there prior there too.
Yes, it was, but they have done nothing.
They
They've
have
done,
not done
yes, my lord,
anything.
your lordship's absolutely right, but kindly make it time bound. And my lord, that, my lord, I will, my lord, if the review goes in my favor, my lord, I should not be allowed, my lord, to be disqualified. So let me submit, subject to result of review, my lord, to, my lord, submit, my lord, my bid, my lord, apropos the tender, which will be announced end of, my lord, January. For, my lord, cartridge. And in fact, my lord, your lordship will find that there's no loss, my lord, which has been caused to CIL. And at page 431, your lordship will find, my lord, in the purchase manual itself. My lord, it says, my lord, 6.13.8, my lord, at 431. My lord, why, my lord, this is also in case of shortage of firms, that is less than 3 eligible firms in a particular group, such debarments may also hurt the interest of CIL and its subsidiaries. The only.
Which one you read?
My lord, the last one, 6.13.8.
All right, shortage of.
In case of shortage of firms,
In
less than 3 eligible firms in a particular group, such debarments may also hit the interest of CIL and or its subsidiaries. In such cases, endeavor should be to pragmatically analyze the circumstances, try to reform the firm, and may get a written commitment from the firm that its performance. And here my performance perfect, no loss. My lord, contracts worked out. Those 2 contracts, my lord, the 1 contract in respect of which the banning order has happened. No loss, my lord, has been caused. And my lord, 2 others I'm asked to continue, but I'm banned for the future. And the cartridge, my lord, explosives are pentadine, my lord, which are P5, my lord, explosives. These are for underground mines. My lord, if I'm out, there are only 2 suppliers. And all that I'm saying is, my lord, they've sat over, my lord, request for a review. And my lord, first, my lord, they knocked me out for 200 crores. My lord, I cannot participate because of, my lord, their, my lord, inaction. And now, my lord, they are having, my lord, another tender, my lord, for, my lord, pentadine. My lord, that's, my lord, the interim my lord, as it fell from your lordship. My lord, kindly allow me to participate subject to result, my lord, of review, and the review, my lord, they should, my lord, dispose of within a particular time.
Before I take your lordships to the merits of the case, as your lordship has already pointed it out, post decision, they, my lord, have approached us seeking review of the decision.
They could not have approached prior there too. It has to be post.
Yes, my lord, that they have done, and that was done in the month of July. My lord, today it's January 2025.
Right.
So, my lord,
what were you doing for these months?
My lord, admittedly, my lord, that decision has not been taken. But if your lordship gives a time frame, my lord, that can be, my lord, decided. But, my lord, no stay or no nothing like.
No, prayer is that let them participate subject to the result of the review.
Subject, then, my lord, I have to, my lord, take, my lord, instruction on that.
What instruction will you take? This will be the court's order. What instruction will you take?
My lord, because, my lord, I was instructed to place before your lordship the merits of the case, my lord.
Very first day, merits of the case cannot
My
be
lord, I
placed
could,
by
my
the
lord, show from the documents on record what actually they have done. My lord, kindly comes to page 59.
Suppression of some facts.
I will show it, and that has been, my lord, admitted. And I will show that what advantage, my lord, they have taken. Kindly, my lord, give me, my lord, 5 minutes.
Did it
5
cause,
minutes, my lord.
All right, did it cause any loss to your firm?
I'll show to you. My lord, kindly, my lord, give me, my lord, 5 minutes.
Tell me whether there was any loss or not.
My lord, from the documents on record, let us, my lord, consider as to whether that suffering of loss is required or not. Let me, my lord, place some of the relevant clauses and what they have done.
1 minute.
I will not take more than 5 minutes, my lord.
1 minute. 1 minute. Page 429 has been placed.
My lord.
Page 429.
My lord, before
clause VI.
Before that, my lord, I have to, my lord, fall back upon the tender in which, my lord, they have participated and they have been, my lord, debarred. Before, my lord, I come to, my lord, this purchase.
Debarring, the reason for debarment is suppression of facts, false information given.
False certificate, my lord.
False certificate.
False certificate, my lord, they have
They have relied upon a false certificate,
certificate.
right?
And which, my lord, they have already, my lord, admitted, my lord. That is why, my lord, kindly bear with me 5 minutes, my lord. Let me, my lord, take your lordships to the relevant clauses of the tender and what, my lord, they have done. Then, my lord, I will, my lord, bow down to whatever your lordship would say, my lord. My lord,
No,
kindly
but then, as the prayer for review is pending, you can give them an opportunity of hearing and say whatever you have got to say. Why?
So, my lord, it will be subject to decision of the review. They are consideration.
Certainly.
Not-
If you accept whatever the petitioner has got to say and allow the review,
Yes.
then it is all right. It is in his favor. But if you do not allow, you proceed, then he'll again come up.
My lord.
But let him participate.
I will just
How many bidders are there in the category in which the pre-knit meeting will be held?
Pre-bidding meeting has already been held, my lord. They have not come up within the time. That kindly comes to page page 457, volume
457.
And kindly see when the notification has been issued.
19th of December.
Now kindly see the date on which that pre-bid meeting was held.
30th of December.
30th of December, my lord. They could have moved the my lord, vacation bench if it was so urgent.
So right now there is no scope for any further bidding process or auction or tender, nothing of the sort.
The bidding process, my lord, will be open. That will be in month of February. But so far as the meeting is concerned, that meeting, my lord, has already taken place.
All right.
On that was on 30th of December.
Pre-NIT meeting.
Pre-NIT meeting.
This is for conclusion of the running contracts and empanelment of reserve RC holders for a period of 2 years for supply of cartage and subsidiaries. And somebody who does not participate in this pre-knit meeting, will that party not be entitled to place bids and contracts?
My lord, they will be entitled.
Then what is the use of this?
They will be entitled.
It's no use.
Entitled.
Whenever the bidding process starts, let them bid and you decide the review within a particular time period, say 2 weeks or 3 weeks.
My lord, I have not taken instruction on the subject.
Very well. Please come.
No stay. No question of stay. Only review. This participant would subject to review.
The petitioner is aggrieved by the order banning the petitioner for award of contract / order by CIL or its subsidiaries for a period of 2 years. Communicated to the petitioner with a communication dated 2nd July 2024. Stop. Learned Senior Counsel representing the petitioner refers to the Purchase Manual 2020 published by the Coal India Limited. Stop. The clauses relating to banning / debarment of business, comma, period of banning / debarment, procedure for banning / debarment have been placed before this court. Paragraph. It has been submitted that there is a provision for filing a prayer for appeal or representation seeking withdrawal or modification of the order of banning. The petitioner availed the said opportunity by filing a representation before the chairman of Coal India Limited on 18th of July 2024. The same has not been considered till date. Paragraph. The petitioner has categorically denied that any false declaration was given by the petitioner. Paragraph. It has been submitted that as the order of debarment is also applicable in respect of the subsidiaries of Coal India Limited, accordingly, a further show cause notice ought to have been issued. The same has not been issued. Paragraph. It has further been submitted that the petitioner is the supplier of cartridge explosives and accessories. There are not more than 3 eligible firms in the said group, and accordingly, as per the purchase manual, the clause for debarment ought not to have been invoked. There is a provision to reform the firm, provision to pragmatically analyze the circumstances and thereafter take necessary steps. The same has not been done. Paragraph. Prayer has been made to permit the petitioner to participate in the future bidding process. Paragraph. The submission and prayer of the petitioner. Petitioners have been denied by the learned advocate representing Coal India Limited. It has been submitted that the petitioner deliberately filed false information, supplied false information to obtain the subject tender. Paragraph.
This was my for classification, my lord. No, I would not say that, my lord, what has happened is there were two types of contractor, my lord, who can participate. He submitted his bid as class 1 contractor. Now, if you submit your bids at class 1 contractor, you get a preference. Had he submitted his bid as class 2 contractor, he would not have got that preference.
It has been submitted that the petitioner submitted his bid as class 1 supplier only for obtaining preference.
Local supplier. What to be local supplier? This is not under the policy of government of India.
Local supplier. Local supplier. Class 1 local supplier. Class 1 local supplier. Only for obtaining preference. He does not fall within the said class. Paragraph. Be that as it may, as it appears that the request made by the petitioners seeking review of the order of ban is pending consideration before the chairman for a considerable period of time. Accordingly, without entering into the merits of the instant writ petition, the instant writ petition is disposed of by directing the chairman, Coal India Limited, to decide upon the request made by the petitioners, strictly in accordance with the prevailing guidelines, upon giving the petitioners an opportunity of hearing to place documents in support of their stand at the earliest, but positively within a period of 3 weeks
Within 3 weeks.
from
4
the
weeks,
date
my lord,
of
we can decide within 4 weeks.
at the earliest within a period of 4 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Stop. Paragraph. As the bidding process is on, comma, the petitioners may be permitted to
Bidding
participate.
process, my lord,
If NIT is,
bidding.
if NIT is issued, my lord, in the meantime, I will have liberty to.
अच्छा,
Yes.
কি বললাম? না, if in the meantime any NIT is issued, bidding process is on its জায়গায়, is issued, comma, then the petitioner may be permitted to submit their bid subject to the bid, and the fate of the bid submitted by the petitioner will be subject to the order passed by the chairman in the representation filed seeking review of the order of ban. Stuff. The writ petition stands disposed of.
I'm ready. Obliged, sir. My lord, affidavit of service is taken on record.
Yes,
right?
affidavit of service is taken on record. জানাবাবু, এটাকে ওর ভিতরে রেখে দিতে বলুন না। এই মোটাটা যেটা হয়ে গেল ওইটার ভেতরে রেখে দিন।
This is also,
Yes.
my lord, in respect of book fair. Again, my lord, the state has been made a party to invoke the writ jurisdiction.
Yes. The earlier writ petitions to dismiss because the court was of the opinion that
Yes.
guild is cannot be classified as state under Article 12.
Right, my lord.
But there another point was
Yes.
the petitioner in the earlier writ petition could not satisfy as to whether they fulfill the terms and conditions of the advertisement. So it was an additional ground, the court dismissed the writ petition.
Right.
Here specific stand is that they that the petitioners over here are publishers and they have got their own catalog.
On that, I've got
and-
nothing to say.
Yes.
On that, I've got nothing to say. That is for them. But so far as the maintainability is concerned, my lord, that
Let me
still
see.
remains open.
Let me see,
Even if,
yes.
my lord, they satisfy, not satisfy, whatever. Because it's none of, my lord, the sovereign functions of the state to organize a fair.
So may I address on that, your lordship, I think. Now, my lord, this is not a matter of sovereign function. This is a matter of public event.
I think your learned friend was supposed to take certain instructions
Yes. That's your lordship's last order.
to enable the learned counsel for the guild to obtain proper instruction as to whether the terms and conditions of the present book fair were made known to the petitioners or not.
My lord, they were aware. My lord, kindly have a look at page 51 of the writ petition, my lord. Identical terms and conditions
Kindly have a look at page 51. And it's the form for participation in the open ground.
1 minute, 51
51.
is the renewal notice.
Well, this is the main application, man, by dint of it. But maybe 52, man.
The advertisement.
Yes.
Yes.
It's not the form, man. It's form. It's originated at 51 and maybe 50, my lord.
Yes.
Yes, my lord produces this. My lord, this is the application form by dint of which they were allotted the stall in the earlier book fair, my lord. Kindly have a look at the date, 13 December 2023. But now, yes, ma'am. The flip side of this form contain the terms and conditions, ma'am.
The last year's.
Last year, ma'am. Why I'm saying so, ma'am? This is the last year's application.
So you mean to say there has been no change in the terms and
no change in the terms and
very well. Now, if you have permitted the petitioner to participate in the last year's fair, why will you stop them from participating in this fair?
There is a resolution.
What is so special about the resolution?
Wherein we have resolved specifically to implement the rules and procedure in a much more stricter manner, considering the prevailing situation as of now.
What is the prevailing situation?
The prevailing the situation.
What is the last year also some situation was prevailing, this year also some situation. What is the change? This petitioner claims, I am not aware, the petitioner claims that the petitioner is there in the fair for quite some time and you have permitted. You also admit. In fact, you have brought this document to show that the terms and conditions which were prevailing earlier is still prevailing. Why will they not be permitted to participate this year?
Kindly have a look at the first term and condition, 1A. 1A stipulates that the participation in the fair is open to publishers and to limited number of authorized distributors of books. It is
last year also same thing. The petitioner was there. Why this year you will stop them?
It was the it is now the decision of the organizers, my lord.
Now you are trying to put in something which is not there.
No, my lord, it is there, my lord. It is there, my lord. This year
it was there also earlier.
Yes, my lord, it was there, my lord.
Then
this year, my lord, there is a resolution of the guild, my lord. Kindly have a look at this.
This is where the petitioners come in. That you pick and choose. You are discriminating.
There is no question of discriminating, my lord. They are only a society, my lord. They have disclosed the document. Can you have a look?
Last year also, they had the same status. Their status have not changed.
My lord, this year, my lord, the guild has...
What is so special about this year?
My lord, to implement the rules, my lord, and the regulations.
Come up with fresh rules, then implement. As long as the old rules are there, you have implemented it. What was the use of the rules if you never implemented it?
They have also given an undertaking to abide by the rules and regulations.
Last year also they gave this undertaking. This year also they will give the undertaking. They will abide by all the rules and regulations that you specify. You permit them a stall.
It is the decision of the guild, my lord. My lord, and my lord, because they do not satisfy the criteria. My lord, kindly have a look at the advertisement. Kindly have a look at the advertisement. My lord, that was placed on the last occasion.
You show me the list of stalls in whose favor you are allowing. The list of stalls. Show me. Who are the stalls you have permitted? Are only book stalls over there, or there are other stalls also?
Only book stalls, my lord, and stalls of sponsors. Nothing more.
Sponsors means? Books or what does books or sponsors stalls mean?
Sponsors, like Senko Gold is there.
How are they connected with the book fair?
Since they are the sponsors, they have been allotted space over there.
They are from there. You are collecting the money.
Yes, they are the sponsors of the book.
That means from there you are collecting the money, and for advertisement purpose they are over there.
Yes, they were there, and this year also they have been allotted.
And who are the other stalls? How many food stalls are over there? Food stalls are also publishers. People go there more for the food rather than for the books.
There is only a food court that
yes. How is the food court functioning over there if you are not giving it to anybody else apart from the booksellers and publishers?
Well, that has to be there. Well, toilets, food stalls, that.
No,
has to
no.
be there.
No, no. Service public convenience is different.
For public
There will be so many people gathering. Public convenience is all right. The food stalls are over there. Food stall is also for public convenience.
My lord, so many people, so many children would be also there, my lord.
Certainly, certainly, you are making money over there. How much do you earn from there? How much do you earn? What is the books of accounts of guild?
My lord, kind of. There is no profit, my lord. My lord, for the administrative purposes, my lord, whatever we get, my lord, we spend it in the book fair, my lord. My lord, in addition thereto, my lord, kindly consider one more thing, my lord. My learned senior friend has placed page 53, my lord. There is a specification that they have to produce the catalog, my lord. That was never there in the application. My lord, kindly have a look. Can you use page 55?
Last year was the catalog given.
Yes, ma'am.
And this year they deliberately did not give the
Can
catalog.
you have a look at page 55, my lord? What they have given, my lord? Entry 5 of page 55.
Did you seek for the catalog? They are your old participants. They are not new. From the new one, you could have verified it, cross-verified it, right? They are the old ones. You have their old catalogs. What new catalog will they?
Application was rejected at the threshold, my lord, because of the.
Did you intimate them?
Yeah.
Did you intimate them that this is, you have not given the catalog and that's the reason?
Applicants, my lord, it's not possible, my humble submission, my lord, to intimate each and every applicant, my lord, about.
And it's not possible. Why is it why is it so impossible? You consider yourself to be so big that you cannot make communication with the applicants, those who are there in your fair, and they are your old parties.
My lord, their application, my lord, was an incomplete one, my lord. Since it did not have the catalog, my lord, it was rejected, my lord. My lord, they were also aware, my lord, that the catalog, they had to fund the catalog. Page 53, my lord, is a part of the advertisement. It's an entry 4, my lord. Now, seize, my lord, what they have given, page 55, there is no catalog at all. Only one magazine, latest magazine, my lord.
They have their own catalog. What will you do now?
But they had to produce it along with their application, my lord.
Till last year, the catalog was there with you?
Yes, ma'am.
Till last year?
Yes.
Certainly it was there. All on a sudden, their catalog goes missing.
But every year, my lord, they have to submit, my lord, what new publications come in, my lord. We are not aware of that. My lord, they had to furnish their catalog.
Yes, they furnished the. What did you furnish? The
Losses, we also furnished the catalog,
Catalog.
but that was not by mistake mentioned. Kindly have a look at the both the advertisement last year and this year.
No
This was
difference.
/ or. Losses, kindly have a look at this. Copy it, sir.
Yes.
Kindly have a look at the first 2025 column number 5 Pustak Talika / Protikar Samprotik Shankha. Kindly consider 2024 also. Pustak Talika / Protikar Sharuk Shankha. But we given everything. It's not that the last year from 2011 we are participating in this book fair. I tell your lordships.
Where from did you get this?
The newspaper. This is also from newspaper. That's
This is your
from newspaper.
document.
So once
This
they
is
give
your
one
document.
thing, another newspaper they give another thing. This is Bengali vernacular.
Pustak Talika
/
Yes, oblique.
Good.
It is catalog.
/ does not mean both. Either or. They have furnished that.
No, kindly have a look what they have submitted. Latest magazine.
Yes. Potrika Sampratik Shankha. That is what they have given. Potrika Sampratik Shankha.
English advertisement says one thing, Bengali advertisement says another thing. And that's your losses, not it's a documents to be submitted.
Kindly have a look, certificate and catalog, my lord.
What is this? Give a copy to your learned friend.
Yeah, I have
Give
given
it. What does it say?
Published in the Anandabazar Patrika.
You see, the newspaper publication they are showing.
They have gone through the Anandabazar publication. They have gone through the English
Yes.
one. They have themselves produced this. Now they are coming out with this.
It is your advertisement or not?
It's not so important. You have my all publications or whatever we sell over there. Now, your losses kindly consider little magazine stalls. All of us have visited the book fair since its inception. We have grown much. My lord, little magazine stalls, does they have, my lord, publishers? What do they say, my lord?
People go more to the book fair to have fun, to eat, to spend time,
Yes.
rather than on books.
My lord, we used to sell books of our friends who used to publish, my lord, through
Yes.
small publishers
Yes,
used to
yes.
publish. I personally did it.
Yes.
I'm talking about your losses 1980, 82,
Yes,
83 in my university days. I can give their name also. Why show restrictions you are doing?
Why is Mr. Dotto over here? For what purpose?
Lord, on the maintainability point, because state has got nothing to do. State only gives the support system like
If a
providing
fair, your learned friend just now said more than 1,000 participants and everybody, and it's a big event.
1,050 stalls.
But it
1,050
is organized by a private body.
Absolutely.
There is no dispute on that.
No dispute on that.
If that is there is no dispute on that, my lord, whatever may be the enormity of it, then, my lord, at least a writ petition will not lie. It can lie, provided, my lord, it falls within the sovereign function of the state. Now, sovereign function, as your lordship knows, my lord, are those functions which can only be performed by the state or the government, say tax collection.
Here, the state is giving direct support.
No. State does not give any support. What the state provides is, number one, the area is a public land, no dispute on that. Number two, water supply. Number three is, my lord, temporary public convenience, etc. Fire, etc. Services, motor, fire brigade and all that. This is what is given. But so far as, my lord, organizing the fair is concerned, there the state has got nothing to do. Therefore, my lord, for the purpose of, my lord, invoking the writ jurisdiction, kindly have a look to, my lord, the array of the respondents.
Yes.
Page 1. State of West Bengal, nothing to do with allotment. Secretary Information Cultural, nothing to do with allotment. Fire Services, nothing to do with allotment. 4 is also fire. 5 is Board of Councillors. 6 is councillors. 7 is Commissioner of Police, etc. Now, the grievance is that they have been denied a stall. That stall is allotment is through a process which is done by a private body. Therefore, what I say is, my lord, fundamentally, my lord, the writ jurisdiction, it's not that they don't have remedy. They have remedy. But the remedy is possibly not before the High Court under Article 226. This is my submission. State has got nothing to do with it.
It is just like a private event. You hold it in your house, I hold it in my house. You have your own list of guests and I have my own list of guests. It is as simple as this.
Yes.
But the event has been taken up to such hype.
That is not at the instance of the state.
No, certainly not. The court
Well, I
does not
join and
say
issue
so.
this.
The court does not say so, right? It has been, as I said, it's more hyped rather than the event that is being held, because there are many book stalls and book shops, book sellers. People can go and always get it from there. It's not that. Thing is, These people were there all along, but something.
I have nothing to do with that.
Nothing.
I
I also understand.
Yes.
But there is some issue which is being raised for the first time. Just now, last occasion, one word was mentioned, sensitive. Today it is mentioned the prevailing circumstances. Why these phrases will be used? No reason. Last year also it was the same. This year also there is hardly any change. The advertisements, the forms, everything. Why pick and choose in this manner, which is sending out a very wrong message to the society? Nothing more. Last day, I simply dismissed because the petitioner did not fall within the
qualifying
criteria. Publisher, nothing was shown at least. I don't know whether they have or not. They didn't show it to me. Here it is said that yes, the catalog is there. This is there. This is. Why this pick and choose? Nothing more. The court has got nothing more to it.
No, definitely.
Have
But
you
my
followed?
considered my submission is that, my lord, could a writ petition be maintainable primarily against a private body? They may have been wronged. I have got nothing to say on that. Whether, my lord, to maintain or to invoke the jurisdiction of the High Court, whether, my lord, a party which is not interested in the sense in the subject matter, which is falling for consideration before this court. Organizing the fair is one thing, my lord, they don't question the organizing the fair. They don't question my letting out the ground for the fair. They don't question the fire services, the other services that the state is giving, which is primarily meant for the public, because there'll be public congregation over there, gathering over there, the minimum support system which the state has to give. Which is even
how much charges does the state take for?
I am told there is not such charges as such.
Lord, may I request your lordships, kindly allow me to address this point of the learned advocate?
Suppose tomorrow somebody XYZ prays for this ground, you will permit?
Yes. Say, for example, I'll tell your lordship, Netaji Indoor Stadium. During the winters, almost every day something
or the other event is.
These are all organized by private bodies. One or two is definitely by the state, no doubt about that.
No, that apart,
yes.
The private bodies also come and you all let.
Therefore, it does not become a public event.
No.
Or something organized by the state. Now, difficulty is, Millard, we do not, these kinds of affairs, they all take place in public places. Take, for example, digressing for a moment, demonstrations. Now, for demonstration, public places are used. When permissions are denied, they come before the court grants permission. Mostly permissions are granted which do not come to the court. But, for example, the public convenience is provided by the state. Light, if it goes on during the evening period also, light is provided by the state. If it cannot be said that the state is sponsoring the demonstration or supporting the demonstration, whichever party it may be. Technically, it's not there. Similarly, over here also, in case of fairs, also they need a public place. Because where there is a gathering of lakhs, you can hardly expect it on a private property. So, otherwise, there is no state has nothing to do with it.
Yes. Give me the list of the stall allottees. In whose favor you've allotted the stalls?
That we have to call for.
Tomorrow? No. The pick and choose method that you are adopting.
There's no pick and choose method. That I shall submit. Kindly have a look at the minutes of the meeting.
I am not going to look. It is your minutes. You look through it. The court is not concerned.
Why there has been a sudden change of stance, Madam? I'm addressing lordship on that, Madam.
Yeah, you should say whatever you've got to say. The court will not look at any document.
In September this year, Madam, 2024, Madam, the resolution was adopted, Madam, that no organizations will be allotted any stall, Madam. No, they fall within the ambit of an organization because per se they are neither publisher nor are the bookseller.
They have qualified and they have mentioned that they are booksellers. They have got their.
That is the BARTA. Try to have a look at the registration certificate. First one is that of a society, and the petitioner before your lordship.
Last year, who made the application?
They had made the application. My lord. This resolution was not there, my lord.
Last year, same applicant.
They have made.
Then?
My lord, this year, my lord, it has been decided by the committee, my lord, that only to allow stalls to booksellers and to publishers, my lord, and not to any other organization. Had they come forward with an application, my lord, wherein their mouthpiece, my lord, which is the BARTA, my lord, would have approached your lordship, my lord, we would not have opposed this application, my lord. But my lord, kindly have a look. My lord, it has a registration.
What stopped you from intimating the petitioner, who is the participant for the last 10 years, that look here, I will not take an application from you. You please forward the application from your book house. Why did you not say this? And what stopped you?
If I may put it in my own humble way, my lord, my lord, because the application was an incomplete one according to us, since it did not have the catalog, my lord, the application was.
Your advertisement doesn't require a catalog, so do not make that submission. Your advertisement is very clear that either the last magazine, Potrika, the latest one, or the catalog. The petitioner has submitted the latest magazine, so you cannot stop them.
The advertisement that they have annexed, lordship has seen.
They are also the copy of this has also been given to you.
One is English version.
Right?
Kindly have a look at the first portion. Prokashok, Pusto Bikreta, O Little Magazine. Specifies over there, man.
Yes. So he has all these qualities.
It's just an organization. My lord, the BARTA, which is the mouthpiece, whose registration certificate my lord will find at page.
That is a very good ground that the publishing house also is registered.
Publishing
You
house.
treat the application of the petitioner as the application of the publishing house, and you
we are ready and willing to
take it.
The Bartha is our Bartha. I mean, I take your loss.
Leave it. You take it in the name of the Bartha. You want your books to be there.
All
They are
books,
going to-
whatever we sell.
Whatever you sell, they
Malad,
will publish.
just your losses to
Listen,
I get your losses point.
The easier you get a solution, the better the court's time will be saved. The court has got nothing to do with this. The court has got far more important things to do.
Now I tell you losses. Does it mean or not mean that it will be restricted to Bartha only? Because I tell you losses. Our catalog is still lying with these previous years. Thousands types of books we sell.
Bartha.
Bartha is one of our magazine. My learned friend is going by the registration. If any magazine has to be published or newspaper, that has to be registered with the central government by way of Press and Publishers Act.
Yes.
Malad, that act, I can take your lordships, never defines publishers. But the publisher's name has to be written on the book. I take your lordships because of this is point of law. Kindly have a look at this. Who is the publisher's name? What my learned friend is saying, that's absolutely wrong. See, my lord?
May I take your lordships?
Certainly, this is the reason I was inquiring. Why are you here? You may leave.
Yes, kindly deal with my point.
Publisher.
Kindly see your lordships. Publisher printed Sri Pritam Mukherjee on behalf of Vishwa Hindu Parishad Dakshin Bongo.
Yes.
So this is published by us.
Yes.
As a body. What my learned friend Malad, I have annexed my registration certificate of the news magazine. Apart from these, we have other books.
By the same name.
Same name.
So you are a publisher also.
All publishers.
Why are you saying this
can they
type
say
of
that?
submission? He says that he is a publisher, book publisher also.
Kindly, the printing press is ours, belongs to us.
You
It's
are
not for today's organization.
You are not properly prepared.
This
They
Pritam
are
Mukherjee,
publishers also.
he is also our editor. I have to mention it in every book. under the law.
Apply your own mind and don't listen to whatever comes to your ears.
My lord, yes, my lord, I have understood what lordship.
He
has
says
thought.
that it is a publishing house. Then how do you debar them? Absolutely eligible in terms of the advertisement. And along with that, they have submitted one magazine. Allot this stall. When will you intimate? It's already the recess. When will you intimate? By 4 o'clock, let the court know whether it has been allotted or not. Take back all the books and everything. এটা ওনার ডকুমেন্ট ওনাকে ফেরত দিন। এইগুলো এনার ডকুমেন্ট এনাকে ফেরত দিন।
Well, this matter will be taken up at 4.
I'm keeping the matter at 4.
Yes, they are a publishing house. You are going by books, studying. You are exposing people to so many new ideas. Why keep yourself constricted to narrow-mindedness?
My instructions were that they are not published.
They see this is what they are handing it.
Printed copies, each copies. My lord, your lordships will not find any definition of publisher under any law. We have to retain it under the act. Your lordships.
Also scrutiny as to what they have displayed, and that is the reason why I call for the catalogs.
It's not something new. Every year they are advertising.
That is our prerogative, my lord. As an organizer, my lord, as
You-
what is being displayed, my lord, unless and until we know as to what is being displayed in the fair, my lord.
Last year you knew what were displayed? You knew till last year what were displayed? What new will be displayed this year, will you say?
Is being made, my lord. We will not be, my lord, we will not be aware of that.
My lord, we will intimate them if any addition is there in addition to the last year. Let them do that after the, but not my lord, the stall installation.
Let them supply
Till last year, whatever they had, they will display it. Till last year, whatever they had, and today, by today, they will forward
In addition to that.
this year's publication and everything to you by today. Right? You allot stalls, 4 o'clock.
Tomorrow, my lord.
4 o'clock, when is the fair? The more you delay,
Texas, my lord, kindly do
The-
that today. No, this is okay.
Well, I think it's tomorrow.
The last
the more you delay, a time will come, I'll stop it.
I have to prepare it, my lord.
First matter in the morning.
I have to
No, but
prepare it.
there are other important matters. This matter is of least importance to the
My
court.
lord, my lord, I assure your lordships, there will be no such publication except all religious and text educational. I tell
I
you,
don't
lordships.
know what you will publish.
That's
It's
your
up to
lordships.
you.
My lord, I tell you,
Till last year, what you had.
I tell you, lordships.
Till last
Mostly,
year,
my lord, all publications of Gita.
whatever. Last year you,
Yes, your lordships.
and this year, how many additions?
No addition. My lord, no addition.
There. He
No
doesn't have any
addition.
addition.
Last year.
Whatever they had last year, they'll be publishing it this year also.
No
No
addition.
addition.
Let them proceed on that basis.
No addition.
It's at 4 o'clock.
4 o'clock, yes. Call item 6 also, please.
Yes, my lord. This is my application, my lord.
Yes. What is it?
My lord, the petitioner, my lord, I'm being led by Mr. Bose.
My application, my lord, challenging cancellation of my, challenging the rejection of an application for renewal of registration under the PNDT Act after the 90-day period for the deemed registration to take effect has expired. I obtained a registration in 2005.
Kindly excuse me. I have another copy of catalog I'm handing over to you.
Give it to the learned friend, some who was appearing. Yes. Hmm.
Kindly allow Mr. Chaudhary.
Yes, certainly.
My lord, point is very short, my lord. This is under the, my lord, PNDT Act, Prenatal Diagnostic Technique Act. Under the Act, my lord, rules have been framed. In terms of the rule, my lord, my license gets renewed every 5 years. I have to make the application, and my lord, the rules provide there is a deemed provision that if they don't respond in 90 days, there is a deemed renewal. Now, I have been carrying on this business, my lord, for the last, my lord, 3 decades. All
decades.
Yes.
All right.
And my lord, all the licenses are there. My lord, when this time, my lord, I file the application, 90 days period goes away, I file all the documents, my lord, they ask for some clarification. My lord, we respond to that. And the impugned notice, my lord, they just do not give any reasons. My lord, they say not recommended.
All these correspondence took place between the 90 days period?
No, everything
Or
after
beyond
90.
that?
All beyond that. When my lord already deemed renewal and my lord, they lose their jurisdiction to raise any issue.
Please show me the impugned order.
Well, at page 57, Lordship will please look.
Rejection. Not recommended.
Not recommended, and kindly see, my lord, this is under the reasons for rejection. No reasons have been given.
3rd of January. When did you file your application?
My lord, I'll tell you, Lordship. 24th of October 2024.
Please show me.
Sorry, my lord, 28th of June. My lord, that Lordship will find my renewal application at page 22. I'm sorry, my lord, 28th of June.
Page 22.
Page
renewal
22.
application. Where do I get the date?
My lord, date Lordship will get at page 25. My lord, with the application, my lord, I have to put in the
Fees.
payment. My lord, page 25, my lord, the third last entry, Lordship will find transaction
26th of
time.
June. Yes.
28 June 2024, 16:15 hours, 40 seconds.
Renewal application. All right. And your validity period, your earlier.
My lord, all the earlier applications are there, last being at page 21.
Is valid till?
My Lordship will find at the first paragraph, last sentence, period of 5 years ending on 31st July 2024. So I applied within the validity period, my lord.
21, 20.
And my lord, the
Is, 26th. All right. And page 57 is the, and show me the communications made.
yes, my lord, kindly come to page 26, 24th October, which is beyond the 90-day period. Not really a show cause, but when a notice for appearance and the documents to be produced have been itemized, current last CE license, current last PNDT license, rental or premises ownership related document.
Are you the owner of the premises?
No, my lord, I am a tenant.
You are a tenant. You have a tenancy agreement, valid tenancy agreement.
And my lord, I have been there in this capacity for the last several decades. It's not that something new is there.
No issue with the landlord.
There may be, my lord, I can't say, because on the last occasion, my lord, they had tried to, my lord, declare it as a dilapidated building, and my lord, there was a corporation notice which we challenged, and my lord got it quashed. But my lord, as of now, my lord, I can't say, my lord, it will be speculation. But what is falling from your lordship, my lord, it also came to our mind. But we have not stated that in the writ petition. This is, my lord, purely a compliance of the rules. It's deemed renewal after 90 days. 24th October is, my lord, beyond the 90 days.
And you have your certificate of enlistment.
Yes, all. I am carrying on business, my lord, for the last several decades, my lord, without.
No, there are 3 points. So just trying to ensure whether there is any defect or not. You have your CE, you have your PNDT license was there. The rental or the ownership may be an issue. Very well. Let me.
That is the only issue, my lord, for which, my lord, may I?
The tenancy.
They have failed to produce a single scrap of document at the time of hearing.
All right.
They have given me a gist from the Sasto Bond. Kindly see this one.
page 20. My lord, this is not correct.
Suppose, assuming that there is a issue with the landlord and tenant, why will the state enter into this?
State, my lord, unless and until, my lord, they have produced a single scrap of document with regard to their.
Show me the law requires them to produce this.
The only things, my lord, the law officer has said, my lord,
original
give me a document
original
that you have
license
been there
এখানে
and you are the valid
tenancy license of
Valid or not valid is not for the authority to check. That is between the landlord-tenant dispute.
but
Is there any defect or irregularity on the part of
the
the?
report, my lord, that has been.
All right,
given
let
to
me
the
see.
tally, my lord.
The notice, legal notice related to tenancy. E-file related to such and such, thoroughly different tenancy agreements. She opined that she can be paid. There is a legal complication. Pending before the tribunal. Which tribunal? Now, after getting legal views, called with Mrs. on behalf of Sono, considering as groundless, the authority issued firm rejection. There is a mention of an issue pending before the tribunal. Which tribunal?
That, my lord, only thing, my lord, this was given to me, my lord, and not only that, my lord, hearing, at the time of hearing, my lord, they have been asked to produce at least some document to show, my lord, that they are been there, and some document, but nothing has been produced.
Tell me anything, whether any complaint has been raised by the
Landlord.
Where is it?
That has not been mentioned, but, my lord, so far there are other also, my lord, has been called on that date, on 24th hearing date, my lord. Everyone was there, my lord.
Everyone means who?
Including the petitioner also.
No, no. Apart from the petitioner, who else?
My lord, they are the, my lord, these are the diagnostic centers, my lord.
But we have specifically got it recorded that we have valid papers and, my lord, they did not accept
No,
the
these diagnostic centers are different, nothing to do with the petitioners. Why show this? It is not that. Did the landlord of the petitioner raise any issue? Assuming there is a dispute between the landlord and tenant, there is a separate forum to deal with it. Why will the state enter into a landlord-tenant dispute?
Milord, only things, Milord, that has been Milord, instructed to me, Milord, that is the whole issue, Milord.
I will require a report from your end, right? So that this thing can be kept on record, and this document is also not signed.
I will, but this is only for me, Milord. They are given to
right,
me,
and this is
detail must be given to you, Lord.
too very sketchy. Pending before the tribunal.
I shall,
Which
Lord. I shall come
tribunal?
up with a very
Between
detailed-
whom? What is the issue? Nothing. All right. Tell me one thing. What is your status in that property?
Milord, I have been a tenant. I have stated that in detail.
Show me some document in support of your tenancy.
Page 27 detail I have given. Kindly see. Page 32 is my subtenancy agreement, and in page 27
subtenancy.
Well, the tenant is also my sister concern.
Page 32.
It's the same parties. My lord, it's not a third party as coming.
Oh, 1st of March 24, Messrs. Diagnostics. Partnership firm represented by such and such.
Name of partners are the same, and my lord, the diagnostic is being run in the name of Messrs. Sono Diagnostic. Again, name of partners are same.
No, I see somebody new. Srimati Chitrita De is not there as the diagnostic.
One partner is different.
Well, one partner is different.
Right.
Diagnostic,
Sumitra
but
is
my lord,
there.
this is my lord,
Sushmita
my unit
Niranjan
only.
is
It's
there.
under the name of Sonoscan only. Sono Diagnostic only.
Original license type premises.
Your landlord.
And my lord, I am having a corporation license for the last several decades, which I have also disclosed.
My original license of
And my
registration
certificate of registration is there, page 21.
at this address originally, and every time it is.
And my lord, it's one of the popular, my lord, diagnostic centers, my lord.
It's not a matter of
Yes,
popular
I
or
agree to that.
not popular.
All I
That
am
is
saying is that,
not-
my lord, I have been there, my lord, for long.
Original
No.
Page 18, lordship
21.
is pleased to come.
Page 18.
Registration.
Page 18 is the original registration, lordship will find.
Sono Diagnostic.
190A.
Page
Lord,
19. Sono
clause 2,
Diagnostic.
lordship will find after A, my lord, ultrasound clinic, 190A, Rajbihari Avenue, Kolkata, 7,29,000. And this lordship will find from 2004.
5.
4, 5.
4.
4.
All right. Let me see. Please come. the petitioner claims to have running a diagnostic center stop. A certificate of enlistment has been issued in the name of the petitioner. Where is your certificate of enlistment?
Enlistment is not there, but I can produce it. I have given the certificate of registration under the PNDT Act.
No, but then you have the certificate of enlistment?
Yes, yes, I have. Not in dispute. I shall produce it, my lord.
The petitioner enlistment is certificate of registration under the prenatal diagnostic techniques bracket open regulation and prevention of misuse bracket close act 1994 has been issued in favor of the petitioner by the Deputy Director of Health Services in the year 2004, and the same has been extended from time to time. Not extended, renewed from time to time. Stuff. The renewal was lastly valid till 31st of July 2024. Stop. Application for renewal was made by the petitioner on 28th of June 2024, and the same was not recommended by the authority. And communicated with a communication dated 3rd of January 2025. Stop. The petitioner is aggrieved by the same. Stop. Paragraph. Learned advocate representing the state respondents submits that there is a dispute relating to the tenancy agreement by the petitioner, for which the renewal has not been allowed in favor of the petitioner. Stop. Paragraph. Learned advocate. Now, the state respondents. The respondent number 2 is directed, not 2, 3, Deputy Director of Health Services is directed to file a report by way of affidavit disclosing the reason for not recommending the renewal of the petitioner's registration under the subject act. Stop. Copy of such affidavit shall be prepared and circulated by 31st of January, 2 weeks' time.
I shall.
List the matter on 11th of February. Exception to the report may be filed prior to the adjourned date. Take this back.
Yes. And that unsigned document, that lordship be kept to.
I am keeping it with
In
record.
the meantime, if lordship is pleased to stay that night, because we can't carry on business otherwise.
But then you are not carrying on business for quite some time. Your license has expired in the month of
No, my lord, this
July.
was because there is a deemed renewal, my lord. I was proceeding that.
Assuming deemed renewal for 3 months, you did not.
No, deemed renewal, my lord. I am getting the notice for the first time in October.
Yes.
I respond to that. In January, I come to know not recommended. Prior to January, I did not have an occasion.
Yes, I understand. But then your license expired, registration expired in July. Right? 90 days, assuming, is the deemed renewal period.
Correct.
So from July, August, September, October. After October, you never had any permission, or in between these 90 days, what did you do?
Kindly have a look at the provisions. The rule provide, if I, my lord, apply within time, my lord, it is automatic extension until and unless in 90 days, my lord, they put a stop. So, my lord, every year it is just, all I have to do is before the license
It's a
expires,
formality, just put in.
all I have
and
to
it
do
gets
is I have to
renewed.
put in my application. I did that. And my lord, 90 days expired. In October, I showed your lordship the communication. They only said kindly produce these 3 documents.
Right.
My lord, we come and we produce it. We have recorded in a letter also. And then January, for the first time, my lord, I find that it is not recommended. So, my lord, from July to January, my lord, I am, my lord, just as other years also, my lord, I take it as a continuation.
No, but then as of now, there is a rejection, and can you do it prior there too?
Lordship, I can.
My lord, prima facie lordship will find it is
How
unreasoned.
soon?
My lord, they have to disclose
Today
reason.
is 20th.
10 days, Lordship. Oh, 7 days. But the
Entire services will be stopped. It's a
that has been
diagnostic
stopped for
center.
quite some time. It's
No,
not
because
that-
he is continuing.
No, my lord, that is.
How can it be illegal? Because there is a deemed clause.
Within 7 days, my lord. Because 2-3 days, this week's, my lord, the holidays
Lord,
are there.
one-
No, only holiday is only on Thursday.
Yes,
Only one day holiday.
Lordship.
You already have the instruction.
Yes, I will.
Just tell
ask
them
to- yes,
to give the details and affirm it.
Lordship.
Whatever they give, you put by way of an
Affidavit,
affidavit. You do not have to add anything.
Lordship.
So it won't take much
Yes,
time. You do it
Lordship,
within
yeah,
this
short-
Friday. Within this Friday, it's 24th.
Lordship.
I'll fix it on 29th.
Lordship.
Next week, Wednesday. Please wait. Date again in.
Let a status quo order in the meantime, my lord, till 29.
যেটা 31 বলেছিলাম সেটা 24 করুন। যেটা বললাম 11 তারিখে সেটা 29 করুন।
Grateful, my lord.
29th of January. No status quo also. It is only the PNDT. The other services you can continue because you have got the certificate of enlistment.
My lord, this is a primarily, my lord, an ultrasonography clinic, my lord. My lord, the idea is this, my lord, that now it is clear it is at the instance of the landlord. They first tried it by making a similar, my lord, complaint to the corporation. I'll come up with the judgment, my lord. Now, my lord, this is the second attempt to somehow stall and, my lord, ensure that I leave. My lord, I have twofold submission.
No, I have expressed my mind that the landlord-tenant dispute ought not to come over here. Thereafter, let the landlord fight, let the tenant fight. The authority have got nothing to do.
No, that is, my lord, that lordship will come to a conclusion.
Yes.
Prima facie, my lord, only for the purpose of interim protection, I am only saying this. Prima facie, lordship will find it's an unreasoned order. So on that basis, I am only asking a status quo till 29th, my lord, lordship will decide. It is unreasoned and the rules require them to give them reason.
Shorten the date, my lord, because of this there.
Even if it is for a day, I can understand their predicament. Show me the law once.
My lord, kindly have a look at the rules. Rule 8.2.
Which one to see?
Lord, kindly take rule 8.2.
Renewal of registration. 38.
My lord, in fact, rule 8.3, my lord, I am sorry. If after enquiry and after giving an opportunity of being heard to the applicant and having regard to the advice of the advisory committee, the appropriate authority is satisfied that the applicant has not complied with the requirement of the Act and these rules, it shall, for reasons to be recorded in writing, reject the application for renewal of certificate of registration and communicate such rejection to the applicant as specified in Form C. So, my lord, the reasons are not mentioned at all. 90 days to vote.
Last.
And my lord, 8.6 lordship finds in the event of failure of the appropriate authority to renew the certificate of registration or to communicate rejection of application for renewal of registration within a period of 90 days from the date of receipt of the application for renewal of registration, the certificate of registration shall deem to have been renewed. So, my lord, as on today, my lord, there is a deemed renewal and I am carrying on business bona fide on the basis of deemed renewal. And there is no reason before your lordship, my lord, in writing in compliance with sub-rule 3 of rule 8, that, my lord, why they are rejecting it. Firstly, my lord, it will be a jurisdictional issue whether after 90 days they can at all seek anything. Secondly, assuming the authorities have jurisdiction, my lord, the order is unreasoned. So, my lord, let them come with the reasons, but my lord, let me continue because of the prima facie, my lord, position. And my lord, so far as position in law is, my lord,
Please take down one more line. The as the prayer for renewal of the registration has been rejected without specifying any reasons therefore, comma, and the petitioner claims to have running the said diagnostic center since 2004 without any break. Accordingly, the court is inclined to grant an interim protection to the petitioner. Stop. The respondents are restrained from taking any coercive steps against the petitioner till 31st of January 2025 or until further order, whichever is earlier.
My lord, seeking lordship's leave to my lord. Right, my lord, space in the Calcutta book fair, my lord. Last year, my stall number was 127.
Please, only one matter is going on, and that is the reason you come up with similar applications.
We do have
This
about my
cannot
lord,
be done.
300 books, my lord. My lord, this is,
Maybe. So what can be done?
my lord, no reasons assigned, my lord. I have duly, my lord, filled the form.
It's whether the writ petition will be maintainable.
My lord, writ petition is, my lord, maintainable, my lord. My lord, I'll try to, my lord, satisfy on that
No,
point,
the
my lord.
court is
Kindly
not
keeps it.
interested. Please.
My lord,
You file it
kindly,
in the department, it will be seen what is to be done.
my lord, they are doing, my lord, they are getting, my lord,
from
recurring
issue
aid, my lord, regularly, my lord. This is for the public purpose, my lord. Kindly consider.
It with your lordship. Petitioner is the tenant of the premises since 1978. Surface proceeding is up to 2015. So the position is otherwise. Had it been the fact he has taken tenancy after knowing the Surfacing Act, that the position would have been otherwise. I would have been bound. But by the impugned order, the TM has taken my position. TM's order, my position has been taken.
Why are you not there before the tribunal and why are you here?
Yes. I can come before your lordship. Kindly see this judgment.
Yes.
I am just realizing two judgments. First is 2007, volume 3, Calcutta Law Times, page 362, paragraph 8 to 11. 8, 9, 10, 11. Had I been there before at the time of loan, then position would have been otherwise. My lord is absolutely unjustified. I should go only to the service tribunal. But I was there long prior to that.
Which portion? Paragraphs?
8, 9, 10, 11.
8, 9, 10, 11.
Only distinguishing feature. Whether I was there knowing fully well the pending service proceeding, I am bound by that. But I was not there. I was there long prior to the service proceeding. 40 years before that.
What is the other judgment?
That is 2014, volume 6 SCC, page 1. Paragraphs, my lord, I shall be mentioning the lengthy judgment, 35 pages judgment. I may give the 11 pages, the paragraphs.
Yes.
Page 2 first, can you see the date when I was the tenancy there since 78. Then page 3, 4, 5, 6, 7, 8. Only the head notes, because the lengthy judgment is there. Page 3, clause E, clause GH.
Show me your documents relating to tenancy.
P1, the annexure A, P1 is red receipts. And then page 2, P2 is the trade license.
Why have you implemented respondent number 3 by name? There was no requirement. He is only performing the work of his official duties.
That is subject to lots of sanction that will be deleted.
Yes, his name has to be deleted. That is all right. Who is your landlord?
7.
7. Anybody representing the landlord?
Yes, I am representing the bank.
Landlord?
I am appearing for the statement.
No, none is there in the landlord. I am for the bank.
No, bank is all right. Landlord, nobody is representing.
Landlord refused. He is every service. Had I been there before loan?
When was the loan taken?
So 2015 proceeding started in the service proceeding. And I was there since
Page,
1970.
show me the document relating to loan. Are you aware?
Well, the loan cannot be there. I am not a party in the proceeding, starting the proceeding.
Sir,
The order is at page 27, P5. And representation P6. It's the only point. Had I been there when the loan was taken, I am bound. I am to go to the tribunal. My lord is justified. The distinguishing feature is that I was not there. Long before the service proceeding, I am there. Since 1978. So the only they can do is evict me according to law. And the Honorable Supreme Court has clarified this distinction. Supreme Court judgment clause E, G, H at page 3. Page 6.
Court judgment.
Paragraph.
Date of possession has not been fixed. Date of possession
Has been fixed and it was taken as per.
Possession taken.
Millard, my submission is there. First of all is this that what the facts they have stated herein is not the correct one. That is a disputed fact in the sense that we have sold it after taking the position from the district magistrate's assistants, sold it as it is very basis. We have not touched upon the shop of this petitioner. We have not touched.
So the
As it is where its basis as there, now it is up with the new purchasers. They will decide.
His tenancy right, there is no issue.
No,
with
no, they
regard to
cannot
his
be. That cannot
tenancy
be. That
right.
will go on. That the new landlord will do it, all these things.
What remains?
This fact is distorted one, whatever they submitted.
Till then, my lord has determination, 226.
No, your tenancy, nobody is affecting your tenancy rights.
He has dispossessed me and put a lock over my tenant.
Who has done this?
That is
the bank. As per
The bank is denying.
No.
The bank is denying.
We have that denying here, but fact is that we are dispossessed on the particular date.
You were dispossessed by whom? The bank?
By the order of the district magistrate, that is page 27.
Show me that there is a order for dispossessing you.
No, there is no. I have no order against me directly.
Then?
I am not a party to the proceeding.
And
But with that order, where I am not a party, I have been dispossessed.
The bank denies your dispossession.
Well, that is not a fact.
There's a disputed
If somebody says it can be found out.
Miller.
They have sold it or not, it is not for us to know.
It is absolutely different.
But our tenancy right
When was this done? Give me the date.
I am giving my right.
You tell me when was it sold?
It was sold.
Possession taken and sold. When?
No, position was taken on. The position notice.
Para 4, page 4.
29th June.
7/11.
19 June 2024.
19 June 24.
19 June 24, he took the positions. And
Possession taken.
Taken. As it is where is basis and thereafter it handed over. Now the
Handed
question
over to whom?
to the auction purchasers.
When was it handed over?
My instruction is this, that I am not having the full facts about the date of possession.
Give me the documents that you handed over possession to the auction purchaser.
As it is where is basis.
And when the loan was taken, you were aware that there is a tenant over there? Were you aware? Was it disclosed?
He has disclosed, it was disclosed, it was that
It
tenancy.
was disclosed that the tenant is there.
We are not disputing on the tenancy and derivative basis. And as per the Supreme Court orders, that new tenant will be the tenant of the new landlord, and it will continue as per the law, whatever that is. Number one. Number two is, my question is this: when 13.4 was issued and was pasted on the buildings, he knew all these facts.
He may
This is
know
an
a
oblique
lot of
part. This is an
things.
oblique part to object the restrain the SRPC actions on the part of the borrower. This is only because knowing fully well all these things happening.
No, but the action has already been taken.
No, before that, 13.4 was
Fine,
issued.
please come. The petitioner claims to be a tenant under the private respondent. Step. Allegation is that by the order allegation is that relying on the order passed by the District Magistrate North 24 Parganas on 6th February 2024, the bank has taken possession of the subject property. No, subject property. The secured asset. Secured asset. And dispossess the petitioner therefrom on 19th of June 2024. Step. Specific case of the petitioner is that the petitioner is running her business of selling books from the tenanted shop room in the subject premises for the last 40 years. Stop. Without initiating any proceeding to dispossess the petitioner from the subject premises, from her tenanted premises, comma, the bank has taken over the bank has put a padlock on the tenanted premises of the petitioner without any authority of law. Paragraph. Learned advocate representing the bank denies the submission of the petitioner. Stop. It has been submitted that the tenancy of the petitioner has not been encumbered in any manner. Stop. The bank took over possession of the secured asset in as is, where is basis. Stop. Paragraph. The bank is directed to file a report by way of affidavit, clearly disclosing as to whether the petitioner's tenanted premises has been put under padlock by the bank or not. Stop. The affidavit shall also disclose as to whether the bank was aware that the petitioner was a tenant in the subject premises prior to taking the loan, and whether the certificate of sale issued in favor of the auction purchaser discloses the tenancy of the petitioner or not. Stop. Such affidavit shall be prepared and circulated by 31st of January. 2 weeks.
February 1st week.
February 1st week, 7th of February. Let's list the matter on 24th of February. Exception to the report may be filed by the petitioner prior to the adjourned date.
Millard, one point.
No coercive measure in the meantime. No further coercive measure or encumbrance.
Not for that person, is it?
Presumably, landlord suppress the fact of the existence of tenant at the time of taking loan.
This has been returned. What is left? Affidavit of service. As a two affidavit of service filed by the petitioner be written with the records.
Miller, one submission is that we have not broken the padlock and we have not given the padlock. That is one.
Put that right on the report to be filed.
Much okay.
Kindly no further encumbrance in the meantime.
What is the whatever is done is done.
And no
Bank has
no
sold.
further coercive measure because we are
Bank has already sold.
and we have neither here nor there.
Please call. Who is for the petitioner? What is the matter?
Surfacey,
This is proceeding. Bank.
no. The private, either the borrower or the guarantor has come up before your lordship saying that
Time bar section 17 rejected. Come to the High Court. Kindly come to my lord.
Dismiss for default. Enter your appearances.
already section 17(5).
That is
What the state?
time bar.
I appear for the respondent.
My lord, I beg to appear
And
for
for
the
the
petitioner.
And for the state.
My lord, before I start the matter, I want to mention one thing. My lord, subsequently, I received a sale notice which I have challenged before the concerned DRT, my lord. Because the writ petition has been filed prior to that. The cause of action before this court is
In that case, you go before DRT
that
with
give
all.
me one liberty, because here I raised a point that I made a proposal for one-time settlement. They accepted my proposal, but did not inform me that unless I paid the upfront payment, they will not intimated me regarding acceptance of my proposal. What they did, they returned down my prayer and handed over me on the same date when they rejected my prayer for OTS. That is the point, arbitrary act, my lord, I have challenged before the writ petition. Give me, my lord, that liberty.
No, what liberty do you want?
My lord, what has happened? I have challenged the sale notice before the learned DRT.
Yes.
Here, my lord, in the writ petition, I have challenged the
Sale notice means sale has not taken place as of
My lord,
now.
Please, my lord, property has
yes.
been sold, your lord.
But my lord, I have an instruction on that. Partly it has what they had did initially, they put entire property on auction. Now, lord, the petitioners are the advocates, my lord. During lockdown time, my lord, they did not able to pay that money. Due to that tenure, my lord, they defaulted. Thereafter, my lord, they several time went for one-time settlement. However, my lord, they didn't manage to get their money. What thereafter, my lord, what bank did, bank issued the sale notice. And my lord, I have a specific instruction. Partial property has been sold out, and rest portion are still the petitioners are in possession. Now, my lord, be that as it may, because we have to end of the day, my lord.
Go before the
go before the
DRT.
DRT.
So what
Only, my lord,
leave do you require?
that OTS purpose, if at all the bank is agreed with the OTS amount, we could have, my lord, paid
No, the
them.
bank.
Sold the property, my lord, right has already accrued in favor of
The entire property?
No, my lord. My lord, there
Portion
will be property
thereof.
only. The part of that property, my lord, has been sold, your lord.
The petitioners are still in possession.
Part of that,
Well,
part of the property, because what they did,
The whole thing was yours.
yes, the building, my lord, we are retaining. The vacant land, according to them, they sold out to the new purchaser.
Right. So one-time settlement, they are not agreeing to.
Because, my lord, I got instruction that as we failed twice, they are right now, they are not inclined.
The bank has given.
Thrice is the last, my lord, thrice is the last one, my lord, thrice is the last one, which we have challenged before your lordship. No, my lord, that is why, if at all bank agreed with the OTS,
No,
we could have,
she says they are not agreeable. Please come.
because we have preferred also IR.
Achha.
And my lord,
Yes,
203 and 4 is connecting.
Agent.
203
In view of the
Agent.
subsequent sale notice
Home
issued
loan.
by the bank in respect of the secured asset, comma, the in view of challenging the subsequent sale notice. the petitioner has already approached the petitioners, have already approached the Debts Recovery Tribunal for relief.
Tomorrow is the date fixed for hearing.
Stop. Next. In view of the above, the instant writ petition stands disposed of. Stop. It will be open for the petitioners to raise all issues before the appropriate forum.
Great.
Next one is also same.
Yes, same, my lord. In respect of, my lord, earlier one in respect of home loan, subsequent one is OD loan. In connection with that home.
It is the same thing.
Yes.
এখানে একজন petitioner
Great.
আছে। আমাকে দেখো রে। কি বলবো?
Great, and because of here. Great.
Dismissed.
Yeah, please, your lordship. I am for the petitioner, your lordship.
206.
Yes, your lordship.
Mr. Abhishek, he is on leg.
I cannot hear you.
I'm led by Mr. Abhishek, he is on leg.
Is the microphone working? Is the green light blinking?
No, no.
Press it. There is a push written over there.
All right. Yes, ma'am. I'm led by Mr. Abhishek Guho. He's on leg.
Who are you representing?
I'm from the respondent bank.
Respondent bank. Yes.
Respondent
What is
financial-
it?
Lordship, the issue is that I have been served with a 13-2 notice,
Yes.
13-4 notice, and by an order of the district magistrate. Now, what has happened is the order of the district
File din. Yes.
the order of the district magistrate has been obtained by India Bulls Private Limited.
Yes.
But they have also filed an application against me under section 25 of the Payments Systems Act, that is akin to 138 of Negotiable Instruments Act in Delhi. Now, the order has been obtained by Acre Financial Services, but the matter under 138 is being proceeded by the India Bulls. Now, your lordship, the issue is if both the matters are pertaining to the same loan. Now, what we understand is that might be the loan has been transferred to the Acre. So if the transfer is correct, therefore the proceedings under the district before the Delhi 30,000 court cannot continue in the name of India Bulls. And if the transfer is incorrect, then the Acre cannot take the order from the district magistrate. This is the limited issue before your lordship.
Show me what is under challenge. 138 is a different proceeding for dishonor of check.
Lordship.
Surface security proceeding is a different proceeding.
Lordship.
How are you mixing up two?
Lordship,
I do not understand.
Surface is
Show me over from the documents.
Lordship.
Are you the borrower?
Yes, your lordship.
Have you repaid the amount?
No, your lordship.
They have taken steps under the surface proceeding.
Your
You are aggrieved by the same.
Yes, your lordship.
Why not before
I have
the
filed
DR
a section 17 application also.
Let the section 17 you raise all your points over there. Why over here?
Lordship, the issue before the DRT cannot take up that issue of 138 being proceeded before the Delhi High Court, the Delhi Court. That is the only issue.
Then you go before the Delhi court and say that it cannot be proceeded. Can this court look into whether the Delhi court can proceed over there or not?
And lordship, there's a dichotomy in both the things. If the Delhi court is proceeding, a procedure is correctly proceeded with, then the order of the district magistrate cannot be obtained. And if the proceedings of the before the district magistrate is correct, then the order before 138 cannot be obtained. That is the only proceeded with, not obtained, but proceeded with.
Yes. So you are already before the tribunal. The tribunal will look into it.
Lordship, tribunal cannot look into the issue of the district, the matter being proceeded under section 138.
The tribunal can look into as to whether the proceeding under the Surface Act can be proceeded with or not. If the tribunal is of the opinion it can be all right, then the other proceeding, whether it goes or not, you go and approach before the Delhi Tisazari court. So what remains over here?
Lordship.
Please come. The petitioner is aggrieved. by the action taken by the respondent numbers 5 and 6. Proceeding initiated by respondent numbers 5 and 6, Acre,
Yes, Your Lordship.
under the provisions of the Surfacy Act is arbitrary and illegal. Stop paragraph. The petitioner has already approached the Debts Recovery Tribunal for relief. Stop paragraph. The instant writ petition is disposed of with the observation that it will be open for the petitioner to raise all issues before the Debts Recovery Tribunal.
May I humbly pray before Your Lordship a limited period of stay. If
Sorry,
within 7 days, if I will file.
207. You have not filed as of now.
No. I have filed the application. The
Section
issue-
17 is
I have to file another IA application before. the-
whatever you do over there.
Lordship, a 7
207.
days, window. If
No, sorry.
Obliged, Your Lordship.
Dismissed.
I appear for respondent number 9.
Please record your appearance.
This is the evidence. But here in this case, my lord, bank has taken, my lord, possession of wrong property.
Wrong property?
But I am the owner of a flat.
Yes.
I have not taken any loan.
Right.
Somebody has taken, my lord, a loan in respect of different flat number. Now, my lord, bank has taken possession of my flat.
Are you the guarantor?
No connection. My lord, just point out to your lordship, kindly turn page 17 first.
17.
17. Lord, your lordship would find, my lord, this is the deed. Dated, my lord, 27th of July 2021.
Yes.
Now, my lord, your lordship would get the schedule at page 23. Kindly turn, my lord, page 23. Page 23, my lord, your lordship would find this is, my lord, residential flat. Now, my lord, kindly turn, my lord, page 27. Page 27, my lord, is flat number 3B.
Yes.
Page 27, flat number 3B.
Third floor, 756
square feet. Now, my lord, my deed is dated, my lord, 27th of July 2021.
Right.
Now, my lord, kindly turn, my lord, page 54 once.
Yes.
Now, my lord, this is the possession letter of 28th of July 2021. The possession was given to me. Now, my lord, your lordship, my lord, kindly turn page 58.
Possession given to you.
Yes.
Where is flat number 3B?
Flat number, my lord, your lordship would get it.
Right, 55. Right, then.
Now, my lord, next, kindly turn page 58.
58.
Page 58, my lord, this is a notice issued by the, my lord, Canada Bank.
Yes.
Well, a sale notice. Now, my lord, in the property, my lord, details of the property, you will also find all the part and parcel of residential flat in the name of Anita Poddar, borrower, mortgager, Blink flat number 3D, third floor of such and such. This is, my lord, in lecture of flat number 3D. Now, so far as Anita Poddar is concerned, my lord, she had acquired this flat number 3D at Kanitan, my lord, page 61.
Yes, 61.
Page 61 is a deed, my lord.
2nd September
2021.
Yes.
Now, my lord, you will also get, my lord, schedule, my lord, at page 77. Page 77, you will also find, my lord, this is a flat number 3D, third floor.
Right.
755. Now, my lord, this is a flat, my lord. Each floor consists of two flats.
Right.
My lord, there is no third flat. 3A, 3B, 2A, 2B. These two flats are there. Now, what they have done, my property has been sold as flat number 3D, created mortgage, but bank had initiated proceeding under the Service Act. But instead of taking flat number 3D, but there is no existence of 3D. My property has been taken possession. But it's absolute fraud. But if you will not send anybody, you will not find whether the third flat is there in respect of floor or not. Only two flats are there in respect of each floor. But there must be a limit of committing fraud.
You
it's
are
excessive.
What is your name?
My name is Lord Balaji Construction.
Balaji Construction.
Balaji Construction, my lord, is a purchaser.
Purchaser.
My lord, I have my deed, and my lord, more so, my lord, had I committed, had I, my lord, mortgaged the property or created equitable mortgage, then, my lord, my property, the original deed must be with the bank. Let the bank, my lord, produce deed.
Milord, I am appearing on behalf of the bank, Milord. Milord, there is more to the story, Milord.
Yes.
Milord, my lord can understand the
Very
thing.
much
My
understand.
lord. My lord, even in their petition, it's a very subtle way they have written that they were not in actual possession. They are pushing it towards the promoter. Now, our contention is, Milord, they were in cahoots with the other. Now, there is even this, through our local investigation, Milord, we found that the proximity of the deed, Milord, of two deeds, which were produced before the bank and which were registered in their favor, Milord, my lord will say there is a proximity of around 1.5 months difference, Milord. Milord, when that registration of their deed actually happened, this is everything is, Milord, same. Now they are saying that there is a flat number B and D. That is the only difference they are showing, Milord. Milord, our contention is the mortgage was rightfully created and we have taken
Over
possession
which property?
over the property, Milord, which was produced before us, Milord.
Which deed was produced before you?
Milord, the second one, Milord.
3D.
3D, Milord. And they
Yes.
were never in possession, Milord. The
Possession
person
is different.
different, Milord.
3D. Was there any existence of 3D?
My lord, there is an existence of 3D, Milord.
Then go and take possession.
Milord, we have already taken possession. They should have challenged this. On the facts, Milord, they should have challenged this before the learned DRT. That point is always there.
Is there any existence of 3D? This is what the case of the petitioner is.
The thing is, Milord, there is an existence of 3D. The thing is, Milord, this is a courtroom, Milord. This is a flat which they are talking about. Now, there is no existence before a statutory record of 3B or 3D, Milord. Now, they can call this 3B. We can call this 3D.
You cannot call because
My lord, we cannot call this, Milord.
Right.
But actually, Milord, the possession which was, because there was a local inspection, Milord. On the basis of this possession of the flat was taken, Milord.
suppose
My lord.
your representative goes there for the local inspection. There is somebody out there who's pulling the strings from behind, identifies some other property. Your representative doesn't get to know whether this is a proper one or not.
My lord.
The documents and factually the property are different.
My lord. That is there, my lord.
This is what happened over here, and somebody deliberately did this. Right? Maybe your officers are also involved. It's not that, not maybe, I'm certain that your officers are also involved. Right? Because A's property was shown and loan was taken in respect of B's property. And then the bank goes and takes off A's property.
Milord, this is not their case, Milord.
This is my case.
They are talking about the same flat which was taken possession of, Milord.
No, he says he shows documents of B, Bhubaneswar, and you've taken D for Delhi.
D for Delhi, Milord.
So B and D are different. How could you identify B? How could you identify D? Nobody knows.
Nobody knows, Milord.
So why will he suffer?
Milord, why we are saying this? Because according to them, they were not in possession. Prima facie, Milord.
Maybe he is not in possession. The documents are with him. He has the documents. Possession is not important. This is why I mentioned about this example that your property, you are not there. Somebody else goes and identifies your property and puts it up for mortgage. What is this?
Milord, now there is one small issue also.
Yes.
The vendors are same, Milord. In both the deeds.
Yes.
Milord, the vendors are
right.
Same. That is also a confusion which has been created, Milord. The vendors are same. Milord, we have
Vendor is not the main thing. You grant loan to a particular person from, it's a total premises. It's a structure. There are so many flats. It doesn't mean the vendor will be the same for all the flats. That does not give you the right to go and take possession of any of the flats.
Millet,
You cannot
it's
do
Our
this.
case, Millet, it's our case that the possession was taken of the right flat, Millet. It's our case.
Till you can show me the document of 7D or 4D or 3D, whatever.
Millet, for that, Millet, I require instruction and affidavit, Millet. Millet, I don't have that right now, apart from their document, Millet. Millet, I can show that on the basis of which how they identified that this is the flat which belongs to.
Who identified it?
Millet, the bank personnel has to be, Millet.
You are the bank,
Millet.
but the loan was taken by somebody else.
Somebody else, Millet.
Right.
Somebody else.
Who is the loanee over here?
Milord, respondent number 7 and 8.
7 and 8 is there.
Anita, Milord,
Where
Anita
are they?
Poddar. Anita Poddar is
Not appearing.
no, served, Milord, not appearing.
I am appearing for the respondent number 5 and 6, Lordship.
5 and 6, who are they?
I was in promoter.
Now the promoter is also hand and gloves with these people.
Lordship,
What is your stand?
Lordship, I have made a transaction in favor of the petitioner, but I don't know about the subsequent transaction because there is property which is 3B and 2B is existing over there.
3D, this Delhi property doesn't exist at all.
Milord, sanction plan speaks about only 2 flat even in each floor. This is the
Each floor.
sanction plan. Now, how Milord, the 3D and 2D comes?
How could
There was a debate
you
about making submission.
grant loan in respect of a property which does not even exist? What steps have you taken against the person who went there? Which bank? You are the Canara Bank.
Canara Bank, Millet.
It's a nationalized bank.
Nationalized Bank, Millet.
How could, and this is the reason so many cases are there, NPA not being recovered. This is the reason. You go and grant loan in favor of a property which does not exist.
Millet, I have talked to the officers
Yes.
for directions, Millet. Millet, what they were saying over the phone, Millet, we have asked about this after going through the petition. They have said we have done all the due compliance. After that, we have granted
What is the
Millet,
compliance?
for that, Millet, I have to produce the documents. I have to
But
ask.
then this writ petition was served upon you when?
Long back, Milord.
Sometimes in August.
My lord.
And from August till January, you didn't take instruction?
I have taken instruction.
Where are the documents?
The documents I was supposed to be received.
Then you should have got it by now.
The brief which I have received, that was at a later date.
But this is not the way how your officers, this is also another way of delaying matters.
Millet, for that, Millet, I'll just require few days later, I'll get the documents, Millet. I'll satisfy lordship on that point, Millet.
You cannot satisfy because the property is not in existence. Please come. The petitioner claims to be the owner of a flat, of a residential flat, being flat number 3B. Stop. Allegation is that the bank took forceful possession of the said flat. Stop. There is no privity of contract between the petitioner and the bank. Petitioners away. And the bank. Stop. It is submitted that there was a loan taken by the private respondent in respect of flat number 3D. Stop. The bank, on the garb of taking possession of flat number 3D, took possession of flat number 3B. Stop. Paragraph. Specific case of the petitioners is that there is no existence of flat number 3D. Stop. Learned advocate representing the promoters, being the respondent numbers 5 and 6 submits upon instruction that flat number 3D does not exist at all. Paragraph, none represents the respondent numbers 7 and 8. Stop. Learned advocate representing the bank submits upon instruction that loan was allowed subject to compliance of all requisite formalities. Stop paragraph. Learned advocate, no, not the advocate. The bank is directed to file a report by way of affidavit, disclosing the documents relying on which loan was allowed in favor of the respondent numbers 7 and 8. Stop. Such affidavit shall be prepared and circulated by 7th February. List the matter on 24th of February.
Well, kindly restrain the bank will not from carrying any third party interest in respect of flat number 3B.
As the bank has not been able to produce any document in support of flat number 3B, Bhubaneswar. Flat number 3B, possession of which has been forcefully taken, the bank is restrained from creating any third-party encumbrance over flat number 3B until further orders.
Much obliged.
Next, private respondent, do you file your wakalatnama? Bank, wakalatnama, you filed?
In the department, my lord.
Have you filed? Please check whether wakalatnama has been filed or not.
My lord, in the department, my lord.
It has been filed? Please check. Yes. Call the next one.
209 Millard, the same matter, it is flat number 2B and 2D.
Same thing.
Same thing. I am the owner of 2B. It was projected as 2D. Absolutely same. 2B and 2D.
Subrata Babu, you are there? Same. Age 3 chilo, eta 2 hobe. BD, that's same. Yes.
Same.
Ache. Huh? Is the wakalatnama there? No wakalatnama has been filed.
I have filed in department.
When? When?
Sorry, today.
Today.
Yes.
What about you?
I'll just check it, my lord, with my clerk, my
No,
lord.
because it's not here. The system has not uploaded it, which means that you have not filed.
My lord, I'll check with
So
my
please
clerk,
do it
certainly.
in case it's not filed. Yes.
Much obliged.
Number 209, I am appealing for the state, my lord. Led by Mr. Alan.
Yes. Please record his appearance.
Lordship, I'm appealing for the petitioner, Your Lordship.
Yes.
Lordship, I'm seeking for adjournment today, Your Lordship. Lordship, I'm being led by Mr. Huda. He's on legs in court number 40.
Whoever is leading you, please, are you aware of the facts of the
No, Your
case?
Lordship, no.
The matter is pending from August.
Just one day, Lordship. Just one day, Lordship.
As it if you've got chance after 4 or 5 months and you pray for one day, it will be delayed for another year. The bank is the petitioner.
Yes, Lordship.
And this is how the bank is being represented. Chennai. An accommodation has been sought for on behalf of the petitioner. Stop. None appears for the respondents. Stop. List in the combined list of February. service in the meantime. Next. Please record your appearance.
We'll run for the state.
I'm led by Mr. Sukantagos, appearing for the petitioner. My lord, I'm praying for not today, as he
Why?
is engaged in courtroom number 37.
You cannot proceed.
But I'm not briefed in this matter.
You are not briefed in the matter. Who is the petitioner? Now, what is the relief prayed for? Restraining the bank from taking. You are the bank. Has possession been taken?
No, Your Lordship, not yet.
Why?
We have not proceeded for possession as of yet.
Why?
Lordship, that's the instruction. Your Lordship, they are claiming, they are alleging that the
They may allege a lot of things.
according to the instruction, Lordship, we have not gone for possession as of yet.
It's your choice. Same order. Service order ta thakbe na. Please enter your appearance.
Obliged, my lord.
My lord, in 212 and 200, I am for the petitioner, my lord. I am led by Mr. B.K. Singh, my lord. In this matter, he is now out of station, and I am praying for not this week.
What is your name?
Chumki Chaudhuri.
You are the advocate on record.
I am the advocate on record by
You have signed the writ petition.
Lordship.
Have you gone through the writ petition?
Lordship, but
You've gone through it. Tell me what is there. Who is your other side?
I appeal for bank.
You are the bank. Tell me what it is.
Lordship, in this matter, the petitioner is the post-poll atrocity, and he did not get the full and final compensation till date. And the respondent bank was when he get the compensation, but not full and final. The respondent bank also but get that compensation in that meantime. And petitioner is now suffering from the bank for Lordship, I have no brief.
Tell me what the facts is.
Fact is, my lord.
Why will the brief not be there with you when you are the advocate on record?
Actually, Lordship, the matter is handling by Mr. B.K. Singh, and now he.
Whoever is handling, since you are the advocate on record, a copy of the brief should be there with you. Please ensure next time when you sign a petition, you keep a copy for yourself. Otherwise, you'll never learn. Have you followed? Only signing is not enough. You need to have the feel that you are carrying a brief with you. Go through how many petitions do you sign every day? Not much. So even if there is one brief, prepare yourself in such a manner that when your senior is not available, you can place the case at least. Hold the court for some time. Did you get it? What is it?
Lordship, this is. I have claimed compensation. There was
compensation from the bank.
No, Lordship. There was a direction. Earlier, a writ petition was filed by Justice Manta, and order was passed, Your Lordship, where district magistrate has been directed to pay compensation for the post-poll atrocities, Your Lordship. Probably they are agreed that the compensation has not been.
What will the bank do?
Lordship, I am also not aware. I will again seek instruction from the bank whether there is any step has been taken or not in respect of this flat.
No, but then what is the
subject flat was in which the property was damaged. This was financed. The loan was sanctioned in respect of this flat by bank.
Are you taking any proceeding under the SRFC Act?
Lordship, I have to take instruction from the bank. This
accommodation has been sought for on behalf of the petitioner. List in the command list of February. Next one also same order. Are you prepared with the next item?
No, Lordship.
Not prepared?
Not prepared.
Yes. Dismissed.
Your ladyship, I'm
215, I appear for the bank.
214. 214.
My lord, I'm appearing on behalf of the bank, my lord. I'm being led by senior Jishnu Chaudhary. He's on legs, my lord. Just give me a short passover. I'm praying for a short passover, my lord.
Which item?
214, my lord.
214.
Yes, my lord.
Petitioner or the respondent?
Your ladyship, I appear for respondent number 1, which is RBI. I'm for the Axis Bank, my lord. Respondent number 2.
Whether the bank is the petitioner or the respondent?
Respondent, my lord.
Respondent.
Yes, my lord.
The petitioner is not here.
No, petition.
Each petition stands dismissed for default. Please enter your appearances.
Grateful, my lord.
Respondent.
In this
215, I appear for the respondent number 6, my lord, the bank.
Permit to file the appeal service. In this matter, my lord, my client taken the loan from the bank. Even if you turn to page 12 of the petition, my lord. This property was sold on 19th February 2021, my lord.
Yes.
Afterwards, can you turn to page 13? I received the notice from the executive magistrate.
Use the microphone. There is a lot of noise over here. Yes.
I received the notice from the executive magistrate on 15th March 2024, my lord. In lieu of the notice which was issued earlier 2019, my lord.
2019.
Yes, may kindly see the paragraph first with reference to the above. Subject, this is to inform you that a possession order is issued such and such dated 22/11/2019, my lord.
Which page? Which portion?
Page 13, my lord.
Page 13. Sale notice, sale certificate.
This is not sale notice. This is the position executive magistrate has given the notice.
Change of magistrate for taking possession. All right, yes.
Now come to page 12.
Page 12.
This property in question was sold, my lord. Kindly turn to page 5. Page 12, line
19th of February 2021. The sale certificate.
19 February 2099. That particular do not was executed. Subsequent order was.
No, this is 19th February 2021.
Yes, my lord. This is the property was sold out by the bank.
Yes.
And again, the executive magistrate has the issue to me. Page 13.
You are Gautam Shaw, and property stands in the name of Gautam Shaw. And
already bank has received the money, sold the property, person has been delivered to the purchaser.
so nothing remains.
Nothing remains, my lord. Notice is quest issued by the executive magistrate, page 13, my lord.
Page 13.
Yes, my lord.
Is connection. The property is the same. SP Builders. Where is your name in page 13? Your name is nowhere there.
That is the name of the executive magistrate, my lord.
Executive magistrate is all right, but
yes.
Then the description of the property, is it the same?
Yes, my same property.
How do you know? Show me.
With reference to the above mentioned, this is to inform you that possession
order.
D255, Tenching Ground Road, my lord. Here.
And page 12 is.
Page 12 is also, my lord.
Where is
and last
address?
line, premises number D255, Tenching.
OTG Road, Trenching Ground Road. And Srimati was the authorized officer to take possession of the assets as mentioned, and they said. Who is this Messrs. SP Builders?
I am the proprietor of the SP Builder, my lord.
You means Gautam Shaw?
Gautam Shaw, my lord.
The petitioner is the proprietor. Right?
Same property, are you taking steps to sell it twice, or what is it?
There's a say, so the number one, I'm taking a point of maintainability. What is challenged, if your lordship looks at the prayer, is an order passed under section 14 of the SARFACI Act. Now it is settled proposition. There are several judgments of the Supreme Court. They will
Very well.
appeal that.
Tell me one thing. Page 12.
Yes, yes.
There is a sale certificate in respect of the property D255.
My lord.
And the date is 19th of
February
February
2021.
That means sale took place. This is what is mentioned in the
Prior
first
that,
paragraph.
prior to 19th of February, the sale had taken place, my lord.
Right?
Yes, my lord, in all likelihood, I've taken instruction, my lord. In all likelihood, what has happened is that this sale has stood cancelled. I'll start from the beginning.
Cancelled.
I'll start from the beginning, my lord. They were the borrower guarantor in respect of the loan, the bank, the credit facility.
Yes.
NPA 13.2 notice issued, 13.4 notice issued, possession of the property taken from them. Then the property, my lord, was put up for sale. There was a sale certificate that was issued in respect thereto. So the moment, my lord, the auction notice or the sale notice, e-auction notice, was issued, their right of redemption comes to an end. The petitioner, his right over redemption of the property ends right there. He cannot have a locus any point beyond that period. Now the sale takes place. Now there's a sale certificate, my lord, which is 19th of February 2021. My instruction, my lord, on record is that this sale has stood cancelled because there is a subsequent sale, my lord, that has taken place on 27th. This is not there in the REIT application. That had taken place on 27th of August 2024. Pursuant to the section 14 order, my lord, that they have challenged in this writ petition. So the physical possession taken, auction sale on 27th of August 2024. There's a registration of deed of conveyance that has taken place, and there's a fresh sale certificate, my lord, that has been issued on 7th of September 2024.
Tell me, page 12, the sale certificate mentions that you've accepted the receipt of the sale price, 13 lakh and odd. What happened to the money?
I'll indicate to you. You know, this I've received from Dayashankar Shahi.
Who is there?
The auction purchaser. He's not before this court today. He doesn't have the locus to come and ask me why I have not paid the money or challenge this sale proceeding.
He doesn't say so. He says, why have you given a second notice at page 13? If his role concluded prior to the sale certificate being issued, why was notice been issued to him?
Well,
had notice not been there, he would not have come.
Because his name appears as the original borrower guarantor.
No, but then that is gone.
His dealings has been closed now. His property, the physical possession was taken pursuant to section 13. That physical possession is with the
Thereafter,
bank.
a sale took place. The sale got cancelled. Whatever things have happened, he does not have any role.
He was not made privy to the section 14 proceeding, which had taken place afresh.
Yes.
He was not.
Very well. In that case, why is this 15th March 2024 notice copy forwarded to him?
But in all
Are you aggrieved in any manner?
That he cannot be. My lord, may I just take 30 more seconds? In all likelihood, my lord, this is possibly just to keep it on record because his name appears in the roster, the records of the bank. He cannot.
Are you aggrieved by this notice?
Yes, by this notice.
Why? How?
Because all the property has been sold out.
So you are gone? You are nowhere there in the property?
No, my lord. There's no property with me.
Very well. They are not taking any steps against you.
Yes, my lord.
Recording that you are not taking any steps against him.
Cannot, my lord, the property, the physical possession. No, my lord, subject to, of course, if there is a residual sum with that's credit.
That is different.
That is different. With respect to the property, I cannot take further steps after taking physical possession.
Right, exactly. Here it is mentioned change of magistrate for taking possession of the property.
My lord.
And you address it to only to Messrs. SP Builders. Does it mean that SP Builders is still in possession? You say no.
Lord, with respect to whether they are in possession or that instruction I have to take.
You sell off the property, you take possession, and now you say the petition may be still in possession. How can that be?
No, I'm not saying that. I'm not saying that. I'm only saying this, that the sale had taken place in favor of the first auction purchaser, with the dates that my learned senior friend discloses. Subsequent to that, that sale has stood cancelled in favor of the auction purchaser. Now I have taken steps for the fresh sale. Now that second sale has fructified. There is a sale certificate that has been issued in favor.
In that case, under any circumstances, this notice could not have been forwarded to the petitioner.
No.
Could not have been.
In one specific situation, it could have been. I'll indicate why. Even though I don't have the instruction, I'm only going by the law. In a situation, because a sale today can take place on an as-is where-is basis also without taking physical possession. So hypothetically, Mala,
no, you said physical possession was taken.
There's a first section.
It is your submission that the physical possession was taken.
No, post this physical possession taken pursuant to the order that they have a sale. Original section 14 or that instruction I do not have. So the first sale could have fructified, which has got cancelled now, while they were still in possession. Second sale, no.
First sale cancelled.
But the first sale, my lord, with the instruction, the specific instruction that I do not have.
Do you have something with you?
I've not. Lordship may keep it tomorrow. I'll come back to the.
No.
I'll just.
Is the bank taking any steps against you?
Yes, my lord.
What?
Bank is not taking, but the executive magistrate is taking action against me. I am coming with.
What action the
They have given the notice, my lord.
He has given the notice.
Yes.
Only for information and information.
But so that this notice to be quest, my lord. This is my only submission before you.
One request. May I just come back tomorrow for 5 minutes? I will only give instruction with respect to the physical possession, nothing else. That is it. Lordship, kindly keep it for 5 minutes.
The petitioner is aggrieved by the.
Whether this notice is not maintainable, my lord.
Very well. Dated 15th of March 2024, issued by the District Magistrate, South 24 Parganas. To the authorized officer of the UCO Bank, with a copy marked to the petitioner regarding change of magistrate for taking possession of the property under SARFACI Act, 2002. Stop. Paragraph. The petitioner relies upon the sale certificate, not relies, but refers to the sale certificate. Dated 19th of February 2021, issued by the authorized officer of the bank, clearly mentioning about the sale of the secured asset. Stop. The petitioner specifically mentions that the sale took place in the year 2021 and on the date of issuance of the impugned notice, the petitioner was no way connected with the subject property. Paragraph. Learned advocate representing the bank seeks time to take instruction. Stop. Let written instruction be obtained. Stop. Let the matter appear in the list on 5th of February. Service is taken on record. Don't give.
Not I'm led by Mr. Sukanto Ghosh on behalf of petitioner. As I mentioned earlier, he's engaged in courtroom number 37. So my lord.
What is the matter?
This is a challenge to a section 14 order by the district magistrate. I appear for the bank. You are
for the bank?
I appear for the bank. My learned friend can also take instruction that the allegation is that we have taken possession. Only the first floor was mortgaged to us. The allegation is we have taken possession of the ground floor as well, because there is only one entrance to the entire building. Now, as per my instruction, now the situation is only the first floor is seized and there is an entrance to the ground floors. My learned friend can take instruction, whether they want to proceed with this.
It has become infructuous in that case because you have already taken possession.
I think so. Yes, we have already taken possession, but they may have a point if also the ground floor has been taken possession of. So my learned friend can take instruction on that. This is without prejudice.
An accommodation has been sought for on behalf of the petitioner. Stop. List on 10th of February.
Grateful.
Record appearances of all the respondents.
My lord, I am for the petitioner, my lord. My lord, in this case, petitioner is the one of the legal heirs of the guarantor. My lord, in the petitioner's brother took loan of rupees 2,25,000 on 9th May 2005.
Why and how
And-
are you aggrieved?
Yes, my lord, because and thereafter, due to defaulter, her brother become treated as defaulter and loan account has been treated as NPA. Thereafter, surface proceeding under section 13(2) notice was served to the borrower and guarantor, means the petitioner's mother, and subsequently 13(4) notice, possession notice issued. But in the year 2016, the guarantor, that is the petitioner's mother, was died on 2nd October 2016. Thereafter, the property died intestate, that the property now divided two shares. One is the borrower, her brother, and one co-sharer is the petitioner. But recently, that on 9th July 2024, the bank authority issued notice for vacating the mortgage property to her brother. And no notice was issued to the other legal heirs of the guarantors. That bank should ought to have sent notice to the legal heirs of the guarantor, as the guarantor of the loan was guarantor was died. Then the petitioner has right to inherit the property of her mother. And in this case, petitioner came to know when the bank authority has taken physical possession with administrative assistance, and her brother has been ousted from the house, and then her brother.
Go before the tribunal. Please come.
My lord, there is no, my lord.
The petitioner is aggrieved.
Exhausted remedy has been exhausted, my lord.
You went before the tribunal.
Because I have no served notice was not served to me.
Very well. The petitioner is aggrieved by steps taken by the bank under the SARFAESI Act. Stop. Paragraph. It will be open for the petitioner to approach the Debts Recovery Tribunal for relief if so advised.
But I have
in accordance with law, if so advised.
My lord, I have
Call the next matter.
I have not been served any notice, so how can I challenge before that, my lord?
218.
My lord, I'm for the same matter as I have mentioned earlier, engaged in courtroom number 37.
I appear for square number 1 and 2.
Accommodation sought. Adjourned. February monthly list.
My lord, I appear for the respondent bank, your lordship. Lordship, they have challenged the order. They have challenged, my lord, the order passed by the learned district magistrate, your lordship. Lordship, after this sale notice has been issued, your lordship, till date, my lord, no challenge has been thrown to the sale notice. My lord, sale is fixed on, my lord, 7th of February 2024, your lord.
My lord, I am the petitioner, my lord. I am in possession of the mortgage property, my lord. My lord, an expertise order.
You are the borrower also?
Yes, my lord. I am the borrower, my lord. My lord, an expertise order has been passed, my lord. Kindly come page 22.
By whom?
My lord,
By Chief Judicial Magistrate.
Where is the provision for giving you an opportunity of hearing?
My lord.
Where is the provision for giving you opportunity of hearing?
My lord, it's an expertise order, my lord.
Where is the provision? Is there any provision for giving you a hearing?
My lord, I am in possession.
Possession.
My lord, without taking physical possession, the 13(2) notice.
They'll come and take physical possession.
My lord,
Please come.
my lord, I am praying for my lord 1 month time, my lord. My parents are ill, my lord. Kindly give 13 days, my lord.
Approach the bank.
My lord.
What will the court do?
My lord, I already, the borrower has already went to the bank, my lord.
Chief Judicial Magistrate Birbhum.
Settlement proceeding is going on, my lord.
My lordship, there is no instruction in regard to the settlement.
Lord,
It has been paid.
Today, the borrower has come, my
Under
lord.
the provisions of the SARFAESI Act. Stop. The petitioner is aggrieved by the same. Stop. It will be open for the petitioner to approach the
My lord, I am praying for
Debts
30 days.
Recovery Tribunal in accordance with law.
Grateful to
for relief if so advised.
My lord, I am praying for liberty, my lord, to go surface to DRT, my lord. I am praying for liberty, my lord.
Yes, liberty has been given. Go
Mas-
there.
Mas obliged.
220 adjourned.
Now for the respond number 3 and 4.
I am for the petition number.
21, but Mr. Kumar theory is happening for the Union of India. Praying for not today.
Please wait. Union of India is not the very important party over here.
Yes, after the application, I am for the bank.
Yes, surface application, you are there for the bank.
This is a communication made by the bank on the representation. And
Konta?
my lord, impugned order is page 34. This is under section 13(3)(a), where no appeal lies. I have come before your lordship challenging the legality and validity of the same.
13(2).
13(2) exhausted, 13(3)(a) representation, and this is the communication made on the representation made by the petitioner. Well, your lordship kindly see. And section 13(3)(a) provides, my lord, provides to you section 13(3)(a).
Shall consider such representation come to the your representation has not been considered?
No, not properly considered.
Not properly considered is a different thing.
No.
That is something different.
No, not considered because the agreement itself has not been furnished to me in terms of RBI circular.
That
Till date,
is, in
I've
that
been
case,
judged.
This is not the.
Kindly allow me. You will get it.
No, it's okay. I'm sorry. You continue.
Malad, I cannot go anywhere challenging this order except before the lordship, because I have no right to appeal.
the reasons so communicated or the likely action of the seeker at the stage of communication of reasons shall not confer any right upon the borrower to prefer an application to the DRT under section 17.
I have also made a prayer for one-time settlement.
That is different. That is for the bank to consider one-time settlement is a different thing. For the reason, show me the reason.
Malad, show me here also. Kindly come to reasons, my lord. Page 34.
Page 34, yes.
We have received your letter dated 17th of February 2024 on 20th February 2024, which has been termed as a reply notice dated 6/9/2021 under section 13(2) of the Securitization Act. Your reply has been issued after 2 years, 5 months of the issuance of the sale notice under Subsection 2002. E-auction sale notice for sale of immovable assets under the Securitization Act read with proviso Rule 86 of the Security Interest Enforcement Rule 2002. EU on receipt of the said notice dated 6th of September 2021 under section 13(2) of the Act ought to have made representation to raise objection as alleged in your letter dated 17th of February 2024 with the statutory period from date of receipt of the notice. However, on the contrary, you have raised your objection allegation as per instruction of your aforesaid client. But I don't find how they have used that. Your client means I have been communicated after lapse of statutory periods such as which is not tenable in the app law. The allegation that you have raised do not and cannot call for a rebuttal, as the same is beyond the scope of the letters of the Act. It is very clear that the allegations that have been raised in your letter dated 17th of April 2024 are all concocted and are in contrary to the records and indicate the same to be an afterthought raised for the purpose of furthering some malafide in interest. The bank has charged the interest under the guideline of the RBI, Reserve Bank of India, bank's guidelines, and your aforesaid allegations regarding charging a higher rate of interest is baseless and false and hence denied emphatically. The sale notice dated 6th of September 2021 issued under the Securitization Act 2002 has been issued by the competent authority and has been issued by the observing all the requirement of law. Whereas 86 has been stayed by the Honorable Court. Rule 86 has been stayed. On my application, Rule 86 has been invoked. Rule 86 has been stayed by the Honorable Court. That has been stated in my representation. If your lordship kindly come, page 32.
Transfer further encumbrance has been stayed.
Yes.
Where?
Mala, kindly come to page 32.
32. 32. Is
Page
a
32, madam.
page 32 is a part of the letter.
Representation.
Yes, where is it been stayed?
K.
K. I beg to state the virus of such has been challenged, and the same has been stayed in such and such. In virus of section 14 is already on chai. You have not challenged it.
Yes. No. My client not.
Then?
The virus of the act, rules has been challenged.
Maybe somebody else has challenged.
That is sufficient, my lord.
What is sufficient?
If this rule has been stayed, stay of operation, it has been granted by this court.
It will be in between the parties.
No, my lord.
It cannot be.
When it is under virus of the rule,
yes,
that is another effect, my lord.
See, listen, the 13-2 notice was issued to you in 2021. You give reply after 2 years, 5 months.
Yes.
Does the law provide? Law provides them only 60 days time for taking action.
Yes.
Then you are delayed.
Your logicality, what I have sought for. Did you serve a copy of the application?
So you are aggrieved by the proceedings under sections 13.2 and possibly then 13.4 will come and everything. You go before DRT.
No, my lord. Kindly come to page 28. Page 28, if you logically see. This is a circular.
Yes.
The circular said copy of the agreement, loan agreement to be furnished to the borrower. Kindly see the paragraph.
No. When did you take the loan?
2007.
I took loan, my lord.
You took the loan in the year 2007. When was the loan taken?
Subject to correction, my lord. I'll just tell.
2014.
All right, in 2014. And even in 2024, you could not pay off the dues. Now the bank has initiated proceedings under the SARFAESI Act. If you are aggrieved, go before the competent forum.
I am here challenging the certain CA notice. Order.
There is nothing there which permits you.
Your logically see,
No.
they themselves have said, my lord, against your representation, we are giving reply.
Very well, please come. The petitioner was declared.
May I pray? Would your lordship kindly adjourn for some time so that my client is trying to get the matter settled at the bank. May I come back?
Always there, madam.
It is always open. If the bank accepts your proposal.
If your lordship closes the chapter, then scope will be removed.
By keeping the writ petition pending,
so
how much is the due?
My lord?
How much is the due?
My lord, my lord, your lordship kindly see, I made a prayer for a one-time settlement. If your lordship kindly come.
How much is the due?
That the bank can say.
My lord, this is not attached here, man. Nothing is there, my lord.
You cannot say you took the loan and you make payment and you do not
15 lakhs he is saying, my lord. As per his petition, he is saying 15 lakhs principal.
My
lord, it may have become more than 30 because it is too long, my lord. And my lord, may I say something, my lord? This is the application my learned friend is asking to keep this matter as pending. But my lord, there is an application of section 14 is pending there, my lord, before the DM. Now he's taking that advantage, this petition is pending, so don't proceed further. So he is taking this pendency of this petition as a stay there. You should not proceed with that, my lord. So my lord,
when did you file this application for section 14 before the DM?
My lord, that is pending, my lord. I don't have
How
the
long?
date. It's still pending, my lord. But,
When did you file?
my lord, I don't have the date right now. I have to take instruction, my lord. But
Give
it
me
is.
some
But
approximate.
this year, this year, 2024. I mean, not 25. But in 24, it is pending there. I just talked to this matter. This matter pertains to Bardhaman, my lord. So I have just took that instruction. It is still pending, and the only thing which they are going to the DM and saying that this matter is pending, so don't proceed. That is the sole purpose of filing this writ petition. And moreover, my lord, my learned friend is taking the advantage of section 13(3)(a), my lord. Lordship knows that after 60 expiry of 60 days, I don't have to even reply that. So even if it is there, not there, whatever, the question of challenging doesn't arise there. And everything, whatever is, other things are there, my lord, that is before the section 17 of SARFAESI Act. Why a writ petition should be pending, my lord? I am asking this question to myself.
It's only that he prays for a one-time settlement. I want to see whether it can be done for
But
your
that
interest.
is always there, my lord.
It
Lordship
is
may say
for
that we
your
can proceed.
interest and for the interest of the
Definitely, my lord.
petitioner.
Lordship
There
may,
is nothing more
Lordship
to
may
it.
dispose of with an observation that there is a one-time settlement. Do not proceed without disposing of that. If that is possible, my lord, bank is always only wanting the money.
Is there any communication made for one-time settlement?
Yes, sir.
Where is it?
My lord.
Moreover, nothing is annexed here, my lord. I am also feeling, my lord.
Without seeing, why are you saying all this?
No.
My lord, page 32.
32 is your representation.
Then your lordship can see.
Everything
which
is
has
stated in
already been rejected.
No,
What
my lord.
remains in 32? Nothing remains.
6 lakhs, I have made a prayer for settlement of the loan account at 6 lakhs.
It is equal to not making any a prayer at all.
My lord, the 6 lakhs is there. Page 32, last paragraph.
Please come. The account of the petitioner, the loan account of the petitioner was declared as non-performing asset by the bank, and proceeding initiated under the SARFAESI Act for recovery of the same. Stop. Paragraph. Notice under section 13(2) of the Act was issued to the petitioner in September 2021. Stop. The petitioner replied to the same in February 2024. Stop. The bank-wide communication dated 2nd March 2024 intimated the petitioner that your prayer intimated the petitioner that his prayer made in the communication made in February 2024 cannot be accepted. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that there is no provision to approach the Debts Recovery Tribunal challenging the reason so communicated to the response made by the petitioner under notice served under section 13 within bracket 2 of the Act. Stop. Paragraph. Petitioner also prays for direction upon the bank for a one-time settlement. Paragraph. The prayer of the petitioner is opposed by the learned advocate representing the bank. Stop. Paragraph. Section 13 within bracket 2 of the Act mentions that where any borrower, who is under a liability to a secured creditor under a security agreement, makes any default in repayment of secured debt and the debt is classified as non-performing asset, comma, then the secured creditor may require the borrower by notice in writing to discharge in full his liabilities within 60 days from the date of notice, failing which the secured creditor shall be entitled to exercise all or any of the rights under the Act. Stop paragraph. In the instant case, admittedly, the petitioner did not repay the loan amount within the statutory period of 60 days from the date of the notice. Stop. In fact, the petitioner replied to the notice after 2 years and 5 months of the issuance thereof. Stop paragraph. The bank, in the meantime, proceeded to take steps to recover the loan amount in accordance with the provisions of the Act. Stop paragraph. The bank, however, replied by a communication dated 2nd March 2024, rejecting the proposal of the petitioner. Stop. The said communication cannot be treated as communication of reasons, even though a communication of reasons in response to a notice under section 13 within bracket 2, as the representation to the said notice under section 13(2) was made long after the statutory time period. Stop paragraph. The bank has already taken steps under the provision of section 14 of the Act. Stop paragraph. It will be open for the parties to take steps in the matter in accordance with law if so advised. Stop. Next. It will be open for the petitioner to pray for one-time settlement before the bank. Disposed.
Lordship, my lord, if may I pray once in sir. If suppose, my lord, if Lordship, if they go to the section 17, my lord, let
They
this
can.
order not be, let this not be influenced that court. Make one observation, if so happens. That should be, it should be dealt independently. If your Lordship can add that, it will be.
The observations made herein above are only restricted to the representation, now to the reply made by the bank to the representation made by the petitioner in response to notice under section 13(2) of the Act.
No, my lord,
And-
this is reply to the section 13. It's not.
Yes.
It's not section 13(2), my lords.
It's
a reply to section 13(2).
It is your reply to his representation under section 13(2).
It's 13(3)(a).
Section 13(2) of the Act and
Act and the observations made herein above are only restricted to the instant proceeding. Stop. This observation may not influence any other proceeding initiated by any of the parties before any forum whatsoever. So both of you. Next.
I am being led by Tiwari, ma'am. Record his appearance.
No, sorry, only your appearance will be recorded. Give your name. আর একটা দুটো ডাকুন আমি দেখছি।
My lord, I appear for the petitioner, ma'am.
Yes.
I'm for the Canara Bank.
Lordship, I appear for ICICI Bank. Lordship, I am praying for a day's accommodation. Lordship,
Hi.
I have to seek instruction in this.
Let me see whether he can proceed or not.
My lord, in this matter, Your petitioner had filed an application under Section 17 of Surface Act before the learned DRT and being SA number 103 of 2010. And my lord, under the instruction of the learned DRT, the petitioner had issued 2 bank drafts in favor of respondent number 4 through respondent number 2, my lord. My lord, in the meantime, my loan account was transferred to Arshil, respondent number 3, my lord. Now, my lord, my loan account has been settled, my lord. All my dues are cleared and they have issued me no due certificate, my lord. My lord, now the respondent number 4, my lord, has no right over those 2 installed bank drafts. And now, my lord, I'm praying that let there be direction upon the respondent to return those 2 bank drafts and cancel those.
But then why did you not make this prayer before the Section 17 forum? Why in this writ petition?
My lord, that after the order, the section application under Section 17 was dismissed, my lord.
You put in the bank guarantee after the Section 17
May I
stage.
interject, my lord? May I help? My lord, he is not representing the case, my lord. I know the matter, so I'm helping him, my lord. I'm not in this matter.
But then are you authorized to do it?
My lord, actually, his senior, my lord, who is advocate on record, he told me that if he just kindly take permission and say.
If you have authorization, it is all right. I do not know.
My lord, may I say what is the case, my lord? Rest is up to him, my lord. What happened, my lord? 2 drafts of 50,000 was given to ICICI Bank. Ultimately, that account was sold to a ARC company. Ultimately, the matter was settled between the ARC and the parties. Those 2 drafts remained with ICICI Bank, which was unencashed. So, my lord, there is a prayer only to return those drafts which are unencashed after the settlement has already been done.
And the settlement took place after the Section 17 proceeding ended?
Yes, my lord. Yes, my lord. It's ended. It was settled, my lord.
My lord, may I be permitted to
Yes.
speak? My lord, these 2 drafts, one-time settlement is with ICICI. The reconstruction company is of ICICI. Now, these 2 drafts were issued by Canara Bank. Now, what happened is where these drafts are, whether they have been encashed or not, we have been repeatedly telling them that those drafts are not with us. So only thing is, if those drafts are returned back to us, then only we can revalidate or cancel and send the amount to his account. That is the only issue.
Only.
So where
are the photocopy of the drafts? Is the draft still there, or is it lost, or
My lord,
whatever?
there is a communication by the ICICI Bank. It has not been encashed.
It has not been encashed, and the ICICI Bank is.
May I come back tomorrow with proper instruction?
My lord, this is my instruction.
Please.
There only is a issuance of the draft.
The petitioner seeks return of the bank drafts, which are allegedly in the custody of ICICI Bank. Stop. Learned advocate representing ICICI Bank seeks time to take instruction. Stop. Written instruction by the Canara Bank dated 20th of September 2024 be retained with the records. Next Monday, list on 27th.
Next matter, my lord.
Next matter.
For the respondent bank. As per my instruction, my lord, apni aise stated hai. The matter got settled between the bank and the borrower, my lord. That's my instruction. My officer is present. I think petitioner is also.
Give something in writing.
But then keep it in the month of February, my lord. I'll come back with the written instruction.
I am thinking of dismissing it for default.
As per
Record your appearance. Dismiss for default. Yes. Are you there?
I am for the state.
Please record your appearance.
My lord, it can be said, my lord, that such statement may be recorded. And
No, without something in writing. Had something been there in writing, I would have recorded. But without that, I won't.
224 is also, my lord. I'm appearing for the bank.
Lord, I am appearing for the petition.
Which one?
224. The next matter, my lord.
24.
Yes.
3 or
Lord,
4.
here is my affidavit of service, my lord. I have served all the respondents, including the private respondent.
Yes.
Petitioner have a maintainability issue in this matter, my lord.
Yes.
No, you will continue.
Yes, of course.
Yes.
Always you can. But the petitioner before a lordship is against the order passed by the learned DRAT, Appellate Tribunal,
My lord, as to the
From the appellate tribunal, why to 226 jurisdiction?
my lord, I am supported.
Yes, please.
My lord, to my understanding, my lord, there is no further appellate forum under the.
Revisional court is there.
My lord, I tell your lordship. My lord, there are at least 2 Supreme Court judgments where the court has held that yes, writ petition is maintainable against the order of DRT, final order of DRT. Not the very short point is, I tell your lordship, very short point is, my lord, the application of meaning and application of Rule 9(3) of the surface enforcement rules. But the question, what happened? The petitioner before his lordship is a successful purchaser. My lord, the respondent number 3 was the borrower. He defaulted. 13(2) initiated, 13(4) initiated. Section 14 also initiated. Bank took possession. Bank put the property for auction. I was the participant in the auction. I was held the successful bidder. Then, my lord, on 13th of July 2022, my lord, the auction took place. The very next day, somehow I came to know that perhaps I am the successful bidder. So on 13th and 14th of July 2022, in 2 days, even prior to issuance of the confirmation of sale, which is a mandatory requirement under rules, even prior there to have deposited 25%. I am liable to pay 75% rest. The 75% within this statutory period or some extended period, your lordship knows, my lord, I applied for some extension. Extension was granted by the bank. I put the money in time. Now, my lord, the respondent number 3 came before the DRT with an application for, my lord, setting aside of the sale. Entire money taken by the bank, only possession has not been issued. Your lordship will kindly come to
Now
only
what happened? The sale
sale
has been,
certificate issued in my favor.
no, has the sale been cancelled by the
No, not
tribunal?
yet. I tell you, not yet. My lord, I tell you, your lordship.
Yes.
My lord,
Yes, please.
I am not disturbing you.
Do not reply to what your learned
sorry,
junior
I'm
friend
sorry, I'm
says.
sorry.
You can address the court is hearing
My lord,
you.
I am sorry. My lord, the borrower came up with an application before the Surface Act. My lord, that application was rejected. He further made an interim application there that was also rejected. Against that, he prepared an appeal before the appellate tribunal. In the appellate tribunal held that only I should have paid the 25% of the earnest money on 13th July itself or latest by 14th. Instead, I have deposited on 14th and 15th, 1 day delay, even assuming there is a delay. But the bank issued a confirmation to me on 19th of July. In my respectful submission, the date should be reckoned from 19th of July when the bank gave me the intimation, yes, you are the successful bidder. Please deposit the 25% either today itself or by tomorrow. That means either on 19th or on 20th. Even prior there to 7 days prior there to have deposited 25%. London Appellate Tribunal held, since there is a delay of 1 day, Rule 9(3) was not properly followed, gone. And
Gone
asked,
means your money has been
yes, the
forfeited.
money bank has been directed to return the money to me. Whatever the sale proceeds, to return the money to me.
And you are not interested to take the refund of the sale proceeds.
Yes, I am the successful bidder, my lord. That is why I have come before your lordship. Not the question simple, my lord, only the language. Your lordship kindly take the act 9(3) and 9(4). Kindly see the language of the section.
First, you bring those Supreme Court judgments to satisfy that the court
maintainability
is yes.
Yes.
So that we can proceed further.
Yes, my lord. My lord, that judgment is not readily with me, my lord. Kindly, in that case, kindly keep it on 5th of February because I am not in station for these days. I have served the private respondent also.
Please come.
Technically, my lord, I cannot oppose the learned friend's prayer, my lord, because the bank has put the property in auction, my lord. Now, in a technical manner, my lord, DRT has cancelled the sale. So, my lord, my respect to submission before your lordship, my lord, if learned friend is satisfied your lordship regarding the maintainability.
Yes, I shall.
I will not stand in the way.
I shall. That is the only one.
My understanding, my lord, 2024, my lord, Supreme Court passed a judgment, my lord. Perhaps my learned friend is, my lord, relying upon. Supreme Court is, my lord, clearly stated, my lord, is a self-imposing restriction of the Honorable High Court to interfere in all those matters, my lord. Now, my lord, if there is a violation of fundamental right, that my lord, court can interfere.
My lord, even it assuming such, my lord, this
Petitioner is
226
aggrieved by
application
the
itself can be converted into
order.
227 application. That is also the settled law.
You want that to be done? I'll do that.
No. Kindly keep it. I shall come with the Supreme Court judgment. My lord, I am sorry, my lord, I have not brought it today.
The petitioner is aggrieved by the order passed by the Debts Recovery Appellate Tribunal, Kolkata,
And that
on
brings you
12th
to your law.
August 2024. Paragraph. Learned advocate representing the bank raises an issue with regard to the maintainability of the writ petition. Stop. Next. The parties are directed to satisfy the court. Now, the petitioner is directed to satisfy the court with regard to the maintainability of the writ petition. When?
5th of February, my lord, I am not in station till 4. 5th, 6th, any day after 5th.
17th of February 2025.
My lord, in that case,
Let notice be served upon the non-appearing respondent intimating the next date of
my lord, in that
private
case, my lord,
respondent is appearing. my lord.
kindly put one sentence, my lord, so that the
Yeah, that's
bank,
what you
if
should.
the
So
bank
there-
returns the money to me, my lord, then I have nothing to do. That kindly record that till such time.
Is the bank
My lord,
intending
we are
to?
ready to refund back the money, my lord.
Yes.
So he is write a letter. He has write a letter to the bank. My lord, don't refund the money until the writ petition gets dismissed.
Very well.
Otherwise, we have no
My lord,
objection.
it is understood that the bank will not return
No,
the money.
let us see. I cannot say.
Very well. How 17 তারিখ?
17th February.
17th February. Okay.
This will be the last matter in the from the combined list, and then the 4 p.m. fixed matter will be called. 225.
My lord, I'm on behalf of the petitioner, and the case has been settled between both the parties. And I
Both
want
the parties means? Both the parties means?
and the respondent and the petitioner between both the
Yes, who is the respondent?
The respondent is the bank, ma'am.
What is your name?
My name is Mohul Nandi. Ma'am,
Where is the advocate on record?
Advocate record is not here.
Not here?
No, ma'am.
How do you get to know the case has been settled? Who intimated you?
She only intimated, Mr. Advocate on record has only intimated me to withdraw the case as it has been settled between both the parties.
Oh, some written communication from your client?
Yes, ma'am. No, ma'am. Today I am not having the written communication. I just kindly adjourn for the next date so that I can produce the document.
Please come. Learned advocate representing the petitioner submits that the dispute has already been settled. Stop. Paragraph. Let a communication from the petitioner be placed before this court. Stop. I'll keep it on Friday.
Yes, ma'am.
Friday, 24th.
And in this matter, I am representing state. I am led by learned AG.
Lord, I'm
Somebody is online?
My lord, I am appearing on behalf of the state. I am led by learned AG.
All right. Yes.
I appear in behalf of the guild, my lord. It's not possible for us, my lord, to give it to the
Why?
Parishad. There are 2 points on that, my lord. Your lordship has seen my lord's order first, that the writ petition doesn't lie. Secondly, my lord, on merits, his my lord, application did not say, my lord, that he was a publisher or a bookseller. My lord, we have taken a policy decision this year, my lord, that no organization, my lord, will be given a stall. My lord, we have, and I can show your lordship that I'm sure your lordship has seen it earlier. It allow. Lordship allow resolution. It is the mark. Lordship allow. And in terms of that, my lord, none of the political parties, my lord, have been given a stall.
This is not a political party.
Any
before the
organization.
court.
Any organization.
This is a publisher who is
Not a
here.
publisher. My lord,
Show me the description or definition of
Yes,
publisher.
yes.
Please come.
he has to have a registration, my lord.
Show,
under
show,
CAT.
show. Please show, please show.
No. এইটা হচ্ছে আমাদের রেজলিউশন দাও রিট পিটিশনে ওদের পাবলিশার ওই অ্যাক্টটাকে বার করো
আমি একটা কপি পাবো যে
হ্যাঁ তুমি আমার থেকে দেখেন
What are you showing? The minutes?
This is the minute.
Please
This is
show me
my
the law,
resolution.
please.
Yes. Lord, with respect to his registration, Lord, it is for him to
Show me the law, please.
Lord, it is his registration.
You show me that he does not fulfill the criteria of not being a publisher.
Kindly have a look at page 24. 24. And before that, kindly have a look at the Press and Registration of Books Act.
Yes, please.
Lord Shah, present. Lord Shah, present. And kindly have a look at section 19C. He needs a registration under the Act to become a publisher.
Where is publisher described?
Madam.
Definition?
Yes. No, Lord Shah, publisher a definition. No, it's not been, my lord, described in the Act, if I'm not mistaken.
This is an act for regulation of the printing press and the
Yes,
newspapers.
yes, ma'am.
For the
This is
preservation
this
of
is-
the copies
That
of
is
the
from
books.
where, my lord, if your lordship sees 19C, it is, my lord, with respect to, my lord, publication of a newspaper or a book. The book, my lord, your lordship will find is, my lord, defined at, my lord, section 2. Section 1 and book is defined there. Includes every volume, part or division of a volume and pamphlet in any language and every sheet of music, map, chart or plan separately printed. Now, your lordship goes into
So
this,
what
my
did
lord,
you read?
the definition of book.
Definition of book. Includes every volume, part or division of a volume, pamphlet.
My lord.
And yes.
And then public printed on books, my lord, your lordship will find there are 3. Printing presses, your lordship will find that there will be a declaration on that.
Particulars to be printed on books and papers.
Yes, my lord.
Yes.
Newspapers is section 5. This is not your lordship's, my lord, this is not where it comes from. And then, my lord, there needs to be a registration with respect to part 5.
Every
Memoranda
book or paper printed
from
with the
section
plan
8.
such. And if the book or paper will be the name of the publisher and the place of publication.
My lord.
3. And
Here, this is what it is. Now, my lord, my respectful submission is, first of all, your lordship gets into this if the writ petition is maintainable. My lord, your lordship has held in another matter.
yes, yes, I know what I have held.
Your lordship
Now-
has held that the writ petition is not maintainable.
Very well.
So if it is
You-
not maintainable for one person, it's not maintainable for the other.
Absolutely.
My lord.
But the other person
My lord.
in whose favor that was held
My lord.
did not possess this criteria of being a publisher.
No, my lord, respectfully.
Here,
Kindly
the
have a look.
petitioner adds that the petitioner is a publisher.
Respectfully, my lord, may I show your lordship what your lordship has held? Kindly have a
Yes.
look at paragraph 13 of my lord's judgment. Have a look at 13. It was never gone on into merits at all. Have a look at 13, my lord. Upon hearing the parties and upon perusal of the documents placed before this court, my lord, kindly got it, my lord?
Yes, yes.
The court is of the opinion that the guild is not performing any public duty or work. It is a private body and the writ petition against the guild will not be maintained.
Yes,
That's
but at the same time,
My lord.
it was also noted that the petitioner was unable to produce the license, the registration certificate, the catalog, everything were taken into account, and it is only
My lord,
then
your
for
lordship,
this-
respectfully, my lord, if your lordship sees, if your lordship comes back in our case at page 20, comes back to our place. He is, my lord, her. Have a look at 20. He is a society, my lord, registered under the West Bengal Society Registration Act.
Yes.
Then his publication, my lord, which your lordship was trying, my lord, finding out, my lord, 24. This is the registration. Vishwa Hindu Parishad doesn't have a registration. This is
Does not
Vishwa
have the
Hindu
registration
Bhatta.
under the Press and the Registration
my lord.
Books Act.
Doesn't have.
It doesn't have.
Doesn't have.
But it has a registration under the Vishwa Hindu Bharta has a registration.
He has not applied before us. Vishwa Hindu Bharta, my lord, has not applied before us. Number one. Number two, my lord, there was never, my lord, a complaint that Vishwa Hindu Bharta had any problem. I do not know what they have between Bartha and Purushot, my lord, but Bartha has not applied before.
They are synonymous.
No, not at all, my lord. In my respectful submission, different.
The
My lord,
petitioners claim they are synonymous.
my lord, if they can say that it's synonymous, my lord, it's for them to show. It's not for us to show.
Yes.
Whatever's come before us, my lord, we can only decide on that.
Right.
Nothing beyond that. And I am, my lord, a public, a private body.
Yes, yes.
It's not that, my lord, that I am doing something social. Nothing. The Article 12 doesn't lie upon me, my lord.
Certainly it does not.
Does not lie upon.
Right.
Number one. Number two, my lord,
Show me the list of stalls, the allottees. To whom have you allotted?
Yes.
How many are publishers over there and who
Everybody.
are not? Let us see.
Everybody.
Let me see.
You know, then we'll have to bring the entire document before your lordship. Below, there are about 1,000 who have been
1,050 or something.
allotted.
Yes, allotted.
Milord, even to the political parties and everything, Milord, it's
There is no, please do not bring
Ramakrishna
politics
Mission.
over here.
Ramakrishna Mission was not allotted, Milord. Their other
Do
part
not
was allotted.
bring politics over here. The court is not
Very well. Any
having
organization
any
was
type
never
of
given.
politics.
Milord, even an organization was not. Because that's our policy this year. Kindly have a look at the policy, Milord. We've said that we will not give it to an organization. Because we want it only with respect to
Let me see
books.
once how many, to who have you
Then Milord, I'll
committed?
bring the entire records before your lordship tomorrow morning.
Not the records. I want to see the names
I'll
of
bring a
the
chart tomorrow morning before your
publishers
lordship. I'll bring a chart tomorrow morning.
to show as to
I
who
understood
have you,
what is. I understand what's going through my
Yes.
lord's mind. I'll bring that before your lordship.
because
I'll show it before
all
your lordship.
along the impression is
My lord.
for the last 10 or 11 years, the petitioners were permitted
The
stalls,
problem is, my lord,
but now it has not been.
I bow
We
down.
can choose discrimination.
Yes. My lord, I'll bring it for your lordship's kind consideration. I'll do that. Pick and choose cannot be done by the state.
You can. Yes, I understand.
That's a different thing. My lord, I'll not even
understand.
get into that. But I will try and explain my actions before your lordship. Gives me 1 day's time. I'll bring the entire record before your lordship.
So far, the first point, your losses, I am publisher, I have to satisfy. Lord, kindly will look at page 24.
Yes, 24.
My lord, this is to certify this newspaper has been registered under the Press and Registration of Books Act 1867. Bishwa Hindu Barta, Bengali monthly. Clause 6. Publisher's name Pritarun Mukherjee. Got it? 7. Printer's name Pritarun Mukherjee. Editor's name Pritarun Mukherjee. Then your losses, last column, place of publication Bishwa Hindu Parishad, Dakshin Bongo, Bhupan Avenue, such and such. Now let's kindly have a look at the act.
Yes.
My lord, books have been defined.
Hmm.
My lord, newspaper have been defined. Now your losses kindly come to section 3.
Yes.
Every book or paper printed within India shall have printed legibly on it the name of the printer and the place of printing. And if the book or paper be published, the name of the publisher and the place of publication. So, my lord, registration relates to the book or newspaper, not to the publisher. I have to only record the publisher's name with them. As I shown to your lordships, every book every year contains the name of the publisher.
No, I didn't get, sorry, I didn't get it.
Therefore, your losses kindly.
I did not follow your submission, please.
Every book or paper printed.
Yes.
Within the India shall have printed legibly.
Yes.
On it the name of the printer, the place of the printing. I have given you losses certificate. If the book or paper be published, the name of the publisher and the place of publication. Registration certificate needs of the book or this particular. Your losses will find all of them have been recorded in the certificate, page 24. There is no definition of publisher. It's published at our instance. We are the publisher. Bishwa Hindu Parishad.
No, the book.
I'll take your losses the second sections.
Page 24 is the title of the newspaper or the book.
Book.
Whatever.
Book is registered.
Book is registered.
Registered. Kindly see the printer's name, editor's name, where this is published. Bishwa Hindu Parishad. The place of publication is my publication.
Bishwa Hindu Parishad.
This is the registered office of Bishwa Hindu Parishad.
No, this is the place.
Place, your lordship.
But the publisher's name is not that Pritarun Mukherjee has
I tell you,
applied.
lordship, that's why your lordships kindly see the book. Back side I've given to you.
The
Printer's name
application
is
was
Peter.
not made by the publisher.
No,
Publisher is the name, my lord. The my lord, the
that's
Vishwa
the
Hindu
place of publication.
Application was not made by the publisher.
No.
Publisher, my lord, I tell you, lordship, this is the one of the Karjakarta of the publisher, Vishwa Hindu Parishad. Kindly see, my lord, publisher, printer, editor, Shri Pritaran Mukherjee.
But then he did not apply. He did not apply.
My lord, he is one of the Karjakarta of Vishwa Hindu Parishad. He is applied, Vishwa Hindu Parishad. My lord, Vishwa Hindu Parishad one applied.
He is applying for Vishwa Hindu Varta.
My lord, he is not. My lord, I tell you, lordships. No, there is no law regarding definition of publisher. Act doesn't, my lord, requires that. Acts only says who publishes it.
Tell me one thing. This is an authority which does not want your publication to be there. Is there a dearth of place where you can go and publish your books? Can you not find any other place? Why are you running after them?
Who against, my lord?
Against the authority who is not permitting you to publish your
This is
books.
a book fair, international book fair.
You
Everybody should be permitted there.
You go and publish a book fair. You go and make an event.
My lord, that's there, but it is, my lord, internationally recognized fair. They cannot say that.
The state has got no role.
My lord,
to
state
play.
has a role. That's why I should tell you, lordship, I should address the Advocate General.
Yeah.
This is wrong.
Yes,
state
please
has
make
a role.
Submission. What role the state
I
has
am
got
saying,
to play
now,
over
your
here?
lordship, before lordship, kindly have a look at the other sections of the
All
act.
right. Yes, which section?
Kindly see, your lordship. Then your lordships kindly see page 5, rule 5.
Rule 5.
No newspaper shall be published in India except in conformity of the rules hereinafter laid down. Then, my lord, 1. Without prejudice to the provisions of section 3, every copy of such newspaper shall contain the names of the owner and editor thereof. My lord, the certificate shows everything.
Yes.
And printed clearly on such copy and also on the date of its publication. But this copy, your lordships, if you go through the entire section, every copy has to be deposited with the central government authorities. And under this act, state is maintaining a register of books published. That is, your lordships will be getting at section 5 onwards. Your lordships kindly, I get.
No, but this is the objection that the Barta did not apply. Neither did the publisher himself, Mr. Mukherjee,
Well,
or
according
something.
to me, publishers applied. Vishwa Hindu Parishad is publishers. Vishwa Hindu Parishad, if your lordships take the certificate altogether, Barta is a magazine.
No.
A book. Book cannot apply. I have to register the book, not the publisher. This act doesn't say the publishers has to be registered. No provision. How could my learned sense show any provision in under the law, under the state, that this is the publishers under the law? Entire act your losses kindly consider. This is to be published by someone. The Pitam Mukherjee is one of the Karjakarta. He is the editor of us. He is doing everything, looking after the magazine, and other books are there. So how your losses will find? Title of newspaper, your losses. Kindly see the clause 1. Title of newspaper, Vishwa Hindu Varta. Kindly have a look. This is registration. How could my learners say publishers? Is there any law to regulate publishers except trade license? Anandabajar Potrika cannot apply for.
So the employee of the Potrika will apply.
Obviously, he is the signing.
I don't want it. My rules are different.
There is no such rule.
This is
Your
the-
rules, advertisement doesn't say that. You
Why
can't.
did you approach the civil court for relief?
That's why. How could I, in this way of civil court of relief? That's state action. I am satisfied.
Yes, where is the state
I get your losses.
Get into all these things.
That's the point, Malad. That's why I wanted to address it.
Yes.
Malad, your losses, kindly have a look at the first page 53.
53.
I will take your losses, some of the pages.
Yes, yes.
This is, Malad, the International Book Fair. Has the losses gotten one? The International Kolkata Book Fair, one of
No. Pages are not
of
matching.
that page, probably 52 will be.
Yeah,
of the fair.
52. Yes.
The International Kolkata Book Fair, one of Asia's largest literary events. is held annually in Kolkata, drawing millions with its diverse range of books and rich cultural activities. Established in 1976, it features international publishers, authors, and a special pavilion for a guest country, promoting cross-cultural exchange. The fair includes literary discussions, book launches, and performance celebrating the region's vibrant literary heritage. This is the object of this book fair. Now, your losses, it has to be considered, my lord, in accordance with Article 19(1). Now, your losses, kindly, page 60. Now, my lord, I just read out this, the 3 paragraphs small. Has your lordship page tallies? I don't know, my lord. Page 60. Bidhan Nagar Mela ends, Central Park gets ready for book fair. Is your lordship that?
No, show me, lift your page.
I think 1 page before, if I'm not wrong. Page 7, page 59.
55, no, I don't know.
Bidhan Nagar Mela ends.
Yes. Now, kindly. The Bidhan Nagar Fair Utsav organized by the Bidhan Nagar Municipal Corporation ended on Monday. By June 9, the Publishers and Booksellers Guild is expecting to get hold of the fairground to start preparing for the Kolkata International Book Fair, which is to start from January 28. The Kolkata Metropolitan Development Authority is going to spruce up the infrastructure of the fairground. Well, who is going to do that? Well, the authorities will set up 23 ramps to connect the fairground with the peripheral roads for the convenience of people with disabilities. The fairground will be handed over to the guild within a few days, said BMSC official. The state has sanctioned funding rupees 1.7 crore to KMDA for setting up the ramps, constructing a new toilet block, rejuvenating the existing defective fire preventing system with the fairground. The toilet block inside the fairground needs to be refurbished to meet the standard of the book fair, which is an international event. The existing fire preventing system will also be revamped, said KMD officials. Well, 2 things is available. Well, this is one thing, well, the state cannot perform all the duties of its public functions. It does it through its agencies. There are 2 agencies involved here, your lordships. KMDA. Government has sanctioned 1.7 crore for this job. This is a public function they are doing.
No, but then this money is being invested, possibly, I do not know, for revamping the infrastructure.
Exactly.
So whoever comes after the book fair is over will get
this is the only book fair ground, your lordship, before the Bidhan Nagar. But all that I'm saying, kindly, Malad, this is the, for the book fair, this is down for setting up. These facilities is going revamping for the book fair.
But
this is one.
This infrastructure facility is there to stay.
Malad, this is one of the documents I'm saying state involvement. I'm showing your lordship one after another. Then your lordships collectively your lordships do it. Now 64.
You have to take the center stage now.
I thought I'm not.
I was trying to relieve you.
Yes.
Yes.
Now, Malad, the 63. Now, Malad, advertisement, statement. The guild members also highlighted. Malad, this should be 62, I think. Malad, one pagination is wrong. It goes all the time.
Yes.
The state government has sent them the official approval for renaming the venue Central Park as Boi Mela Pangon, as proposed by the Chief Minister Mamata Banerjee. It has been decided for the rest of the year, book bazaars will be frequently organized here, where anyone can buy and sell collection of books, be it first or second hand. We are confident that this will draw many youths. Now your lordship, page 67 probably would be 66. Right,
Telegram online. এটা দেখাচ্ছেন তো টেলিগ্রাম অনলাইন করছেন
Malad, it will be Malad 67. Has you also got that one?
What is it? Yes, telegraph office.
Telegraph. Fair books profit at state's cost. Mamata gives bill 50% discount on Milan Mela rent. Malad, I am told, Malad, this year totally this is waived. Totally. Go by 50%. So public exchequer is invested here. I have to show, my lord, the state participation through some agencies. Then your lordship, page 61, 71.
West Bengal plans.
Now, Central Park revamp. West Bengal plans Central Park revamp underpass for book fair visitors.
This page.
70.
Well, this probably 70. This
70, yes.
Now, your lordships, this entire for book fair, they are constructing underpass for book fair visitors. Kindly go through this. Then I will be taken to other pages. Now, 72. And this should be 71 if I am not wrong. Now, Government of West Bengal Commission for Protection of Child Rights. This is a tender issued by one of the wings of the government, inviting e-tender for construction of child-friendly corner and other related works in 48th International Kolkata Book Fair premises at Central Park Mela grounds such and such. 48th Kolkata Book Fair will be held at the Central Park Mela grounds, Salt Lake, Kolkata from such and such. Like previous year, the West Bengal Commission for Protection of Child Rights is going to launch a child-friendly corner in the aforesaid Mela premises. Accordingly, the Assistant Secretary, West Bengal Commission for Protection of Child Rights, invites proposal or bids for setting up of a child-friendly corner from a reputed competent individual, firm, cooperative societies, company, and other business entity, hereinafter referred to as the tenderer, who are experienced in conceptualizing, fabricating, setting up pandals, which will be used in the 48th International Book Fair at Central Park Mela grounds, Salt Lake, such and such. Brief concept of the proposal is illustrated in item number 2 of section C, theme concept. Your lordships will find then next, your lordship, page 77. Probably your lordships will be, my lord, page 76. Kindly see the theme. Sobujer Pathshala. So this is being done by one of the wing of the government. Then your lordships will find 87. ওই একটা পেজে রেডি করবো এটা হয়ে গেছে 87 86 would be well, this is one the West Bengal Commission for Women. Publication of tender notice of the West Bengal Commission for Women in connection with ensuing Kolkata International Book Fair. Then your losses clause 1 and 2. As the DDO functions of the commission is being acted upon by the West Bengal this commission the department in compliance with the finance department. Hence, e-tender process relating to commission in the ensuing book fair appears to be hardly possible. Hence, as suggested by the assistant financial advisor of the administrative department, will initiate the process of tender paper. The tender notice is being to the administrative with request to get it notified in the website of the department. Such notice, your lordships will find page 89 of it. 90. This should be 89. Kindly see advertisement by the Commission for Women. Tenders are invited from bona fide tenders for stall decoration and supply of necessary items for West Bengal Commission for Women. Then your lordships will find 95. Last page. Kindly see this is Bidhan Nagar Police Commissionerate. E-tender are invited by the Commissioner of Police Bidhan Nagar on behalf of such and such from benefited forms of installation of temporary West Bengal Police Pavilion in the such and such to be held on such and such as per details in the tender document to be called the quoted rate per unit inclusive of packaging, transporting, freight charges, GST, all other taxes. Now this is your lordships and kindly consider. Now this is subsequently we have got it. KMDA. Now, kindly your lordships. Another tender has been published by the this is not part of the petition. ওইটাই দিয়ে দিচ্ছি তো ওইটাই নিয়ে একটাই কপি ছিল Lord, these are the participation of the state or its wings, financially, functionally, and officially. Now your losses, if we go by this, the Mahanagari of Kolkata says, this book fair we will go to above the international level. Themes are selected by the state government. Who will be the country, of country that will also selected by the state government through the name of the book guilds. Without the participation of the state and its exchequer, it's not possible. Even revamping your lordships is done at the point of 1.7 crore from the state exchequer. Rent is totally free. Trade license we were required earlier for this book fair only by the stall participants. That has been waived totally for the book fair. So, my lord, all that I required to now submit, show your lordships following two judgments, G Telefilms and BCCI. The how this is, my lord, acquiring or partaking the character of public function or nearer to public functions. That's your lordships, our submissions. Now, judgment. My lord, kindly look at this first. I will take your lordships only the relevant paragraphs. Now, I give your lordships 2005 4 SCC, page 649. Now, this the exact point here also lordships arose. My lord, some of the paragraphs I take your lordships. Kindly come to page 44 first, your lordship.
Page 44.
Sorry, my lord,
Paragraph
44. I'm
44.
sorry.
Yes.
Read petitioners. The factors credited by the read petitioners herein which would allegedly demonstrate that the board is an authority. Well, board of cricket control board.
Yes.
Say paragraph 45.
Yes.
44 or 45, your lordship.
Mhm.
45, 44 says whether it is within the meaning of Article 12 or not. The board is an authority that would be subject to the constitutional discipline in Part 3 of the Constitution. A. It undertakes all activities in relation to cricket, including entering into contracts for awarding telecast, broadcasting rights for advertisement revenues in the stadium. I'm going to pause here for a moment. Here, the guild, watching a lot, they are distributing the stalls among the so-called publishers and booksellers. This is, my lord, for disseminating knowledge of education. Book fair is a, my lord, pithosthan of knowledge. It's not a, my lord, just fair. The team fielded by BCCI plays Indian team while playing one-day international or test match. It cannot be gainsaid that the team purports to present India as a nation. It wins are matters of national prestige. They wear a uniform that carries the national flag and are treated as sports ambassadors of India. The sports of today are professionals which devote their life to playing the game. They are paid a handsome remuneration by BCCI for their participation in the team. Thus, they are not amateurs who participate on honorary basis. Consequently, they have a right under Article 19(1)(g) to be considered for participation in the game. BCCI claims the power to debar players from playing cricket in exercise of its disciplinary powers. Obviously, it is submitted that a body that purports to exercise powers that impinge on fundamental rights of citizens would constitute at least an authority within the meaning of Article 12 of the Constitution. It can hardly contain that it has the power to arbitrarily deny players of all rights to even be considered for participation in a tournament in which they are included as a team for India. Malad, your losses then come to Malad. The rest I'm placing your losses may consider it. Then page 46. The union contains that the board is a state. In support of the said plea, an affidavit have been affirmed by the Deputy Secretary of the Government of India, Ministry of Youth and Affairs. Then, my lord, board 47. Board of Cricket Control for India is an autonomous non-profit making association limited and restricted to its members only and registered under the Tamil Nadu Society Registration Act. This will be the plea of them, my lord, the society. It is a private organization whose objects are to promote the game of cricket. Its functions are regulated and governed by its own rules and regulations, independent of any statute, and are only related to its members. The rules and regulations, respondent number 2, have neither any statutory force nor it has any statutory powers to make rules or regulations having statutory force. The working committee elected from its members in accordance with own rules controls the entire affairs and management of the respondent number 2. There is no representation of the government or any statutory body whatsoever nature by whatever form in the respondent number 2. There exists no control of the government over the function, finance, administration, management, and affairs of the respondent number 2. The respondent number 2 does not discharge or perform any public or statutory duty. Respondent number 2 receives no grant of assistance in any form or manner from the government in this context. I join an issue in the present case. Then E. Respondent number 2 organizes cricket matches and the tournaments between the teams of its members and with the teams of the members of the International Cricket Council, which is also an autonomous body, devotes any government control. F. Organizing cricket matches and the tournament between the teams of the respondent number 2 and with the co-members of the International Cricket Council cannot be said to be a facet of public functions or government in character. I am giving these broad lines, Your Lordship. Now kindly come to paragraph 135. I will be taking Your Lordships to the what I feel, my lord, to be placed before Your Lordships. Paragraph 135. The right of Indian players and having regard to the observations made in Greek is comparable to their constitutional right contained in Article 19(1)(g) of the Constitution, which would include a right to work and a right to pursue one's occupation. Visualize the publisher's right, because I'm proceeding as it's a publisher's. Then Your Lordships 137 to 138. 148, it's very long, but I will be taking Your Lordship on the relevant portion. Public law is a term of art with definite legal consequences. The concept of public law function is yet to be crystallized. Considerately, however, the power of judicial review can be exercised by this court under Article 32 and by the High Courts under Article 226 of the Constitution only in a case where dispute involves a public law element as contradistinguished from a private law dispute. Now, paragraph 39. Your Lordships, I will place it in entirety, then I will take Your Lordships the relevant portions of other paragraph. General view, however, is that the state or an instrumentality of the state is involved, it will be regarded as an issue within the meaning of public law. Consider, my lord, my annexures. Involvement of the, my lord, instrumentality of the state, KMD, all that. Where individuals are at loggerheads, the remedy therefore has to be resorted to private law field. Situation, however, changes with the advancement of the state function, particularly when it enters in the field of commerce, industry, business, as a result whereof either private bodies take up public functions and duties or they are allowed to do so. The distinction has narrowed down, but again considerably, such a distinction still exists. Drawing inspiration from the decisions of this court as also other court, it may be safely inferred that when essential governmental functions are placed or allowed to be performed by a private body, they must be held to have undertaken a public duty or public functions. Now, Your Lordships will come to paragraph 143. The governmental functions are multifacial. There cannot be a single test for defining public functions. Such functions are performed by a variety of means. Furthermore, even when public duties are expressly conferred by statute, the power and duties do not thereunder limit the ambit of a statute, as there are instances when the conferment of powers involves the imposition of duty to exercise it or to perform some other incidental act, such as obedience to the principle of natural justice. Many public duties are implied by the courts rather than commanded by the legislature. Some can even be said to be assumed voluntarily. Some statutory public duties are prescriptive pattern of conduct, in the sense that they are treated as duties to act reasonably, so that the prescription in these cases is indeed provided by the courts, not merely recognized by them. Then, my lord, paragraph 148. The functions of the board, thus having regard to its nature and character of functions, would be public functions. Then 149. All public and statutory authorities are authorities, but an authority in its etymological sense need not to be a statutory or public authority. Public authorities have public duties to perform. Then, Your Lordship, 151. There, however, exists a distinction between a statutory authority and a public authority. A writ not only lies against statutory authority, it will also be maintainable against any person or a body discharging public functions which is performing duties under a statute. A body discharging public functions, exercising monopoly power, would also be an authority, and thus writ may also lie against it. We must place it the guild, what they are functioning today. A book fair which partakes the character of public functions in course of time. It disseminates the knowledge. It may be by a body, it may be by a body without any officers of the state. But state extends all its infrastructural facilities, functionally and financially, from public exchequer to them. As I narrated, Your Lordships, in broad line, rent-free, everything Your Lordships will find. Then Your Lordships will find paragraph 152. Judicial review forms the basic structure of the Constitution. It is inalienable. Public law remedy by of a judicial review is available both under Articles 32 and 226 of the Constitution. They do not operate in different fields. Article 226 operates only on a broadened horizon. Then Your Lordships will find paragraph 167. The traditional test which had impelled this court to lay down test for determining the question as to whether a body comes within the purview of other authorities in Ajoy Hasya International R. 9. It may also be a relevant factor whether the corporation enjoys monopoly status, which is state conferred or state protected. Well, it's a state protected fair. State conferred protected fair. If the functions of the corporation are of public importance, well, nobody can probably gainsay it. This has now taken the take the character of international book fair. It wants to put it even the first book fair held in German above that. It claims that. And closely related to the governmental functions. It would be a relevant factor in classifying the corporation as an instrumentality and agency of the government. The 6 states laid down there are not exhaustive. Then Your Lordships, 172. In our view, the complex problem has to be resolved keeping in view the following further test. When a body acts as public authority and has a public duty to perform. 2. When it is bound to protect human rights. 3. When it regulates a profession or vocation of a citizen, which is otherwise a fundamental right under a statute or its own rule. Well, a book fair goes to that extent. When it regulates the right of a citizen contained in Article 119A, well, a right of expression you were taking out by this, by not giving us the stall which we are getting for the last 11 years. Available to the general public and viewers of the game of cricket in particular. When it exercises a de facto or a de jure monopoly. When the state outsources its legislative power in its favor, you are giving concession and free of everything. When it has a positive obligation of public nature, but it has a wide implication. These states as such had not been considered independently in any other decision of this court. We thus would have to proceed to determine the knotty issues, my lord, involved therein on a clean state. Then Your Lordships will find, I have taken all Your Lordships, paragraph 177. It is true that regulatory measures applicable to all persons similarly situated, in terms of the provisions of a statute, would by itself not make an organization a state in all circumstances. Conversely, in a case of this nature, non-interference in the functioning of an autonomous body by the government itself may also not be a determinant factor, as the government may not consider any need therefore, despite the fact that the body or organization had been discharging essentially a public function. Such non-interference would not make the public body a private body. This is one of my submissions, Your Lordships. Is discharge the public functions fair. Disseminating of books available of, sometimes we go there only from the catalog. What are the books available on this subject? But we do not buy it from here. We go to the college street and get it, because there we will get 20 to 25 concession percent. Here I will get 10%. We often use it, the book fair, for such. This is a public function. Now, Your Lordships will find 205. The board is in a position to expend crores of rupees from its own earnings. Kindly have a look at this. The tender in question would show that what sort of amount is involved in distributing its telecasting right for a period of 4 years, in as much as both the first petitioner and the fifth respondent offered $1 million therefore. Board has that much of capability, but the guild do not have. With state with tax state support. A monopoly status need not always be created by a law within the meaning of clauses 2 to 6 of Article 19 of the Constitution of India. Kindly see paragraph 207. A body which carries the monopolistic function of selecting team to represent the nation and whose core function is to promote a sport that has to become a symbol of national identity and a medium of expression of national pride must be held to be carrying out government functions. Each of the words meaning are fulfilled over here. Visualize this is a sport. Here we are with education. Book fair is a part of educational activities. It takes us to the national pride, Your Lordships. Bengal feels pride for that. Now, a highly arbitrary or capricious action on the part of such a powerful body would attract the wrath of Article 14 of the Constitution of India. The board itself acted as a representative of the government of India before the international community. All the high dignitaries of the ministry says we will take it up at the international level. We have said these amendments in the rate petitions. It makes representations to the effect that it was entitled to select a team which represents the nation as a cricket playing country, and thus the same would, without anything more, make its action as a state action. For the said purpose, actual control of the board or issuing any direction in that behalf by the government of India is not of much significance, but the question as to whether the government, considering the facts and circumstances, should control the action of the board as long as it purports to select a team to represent India would be a matter of great significance. The guidelines issued by the Union of India clearly demonstrate its concern with the fall in standard of Indian teams in sports in important international sport events. It would not be correct to draw a comparison between an event of international sports such as significant as cricket with beauty pageants and other such events as the state of necessary to be evolved in this behalf. It is the qualitative test and not the quantitative state. The quality and character of a sport recognized as a measure of education and nation building cannot be confused with an event that may be a form of entertainment. Cricket, as noticed herein above, has a special place in the hearts of the citizen of India. Number 2008. The monopoly status of the board is undisputed. The monopoly enjoyed by the board need not to be a statutory one, so as to perform to the states contained in clause 6 of Article 19 of the Constitution. It can be a de facto monopoly which has overtly or covertly received the blessings of the Union of India. The de facto monopoly of the board is manifest as it, as a member of ICC, even if it is technically possible to float any other association, can send an Indian team abroad and invite a foreign team to India. In absence of recognition from ICC, it would not be possible for any other body, including the Union of India, to represent in India in the international cricket events featuring competitive cricket. So would be the position of domestic cricket. The board, in view of enormity of powers, is bound to follow the doctrine of fairness and good faith in all activities. Let's give here 1 second. This book fair, if I am not wrong, my learned friends will correct me. At least 11 to 12 foreign countries, my lord, are participating. So it gives, my lord, a national importance to this fair. 11 to 12. I can give you lordships from the website, the names of the state. They are participating. So this is not merely, my lord, a function, my lord, organized by a private body, a guild. Now, my lord, then you will see 217. It is accepted by the Union of India that board is an autonomous organization and the government does not hold any cricket match, series as it's the function of the board. But that is all the more reason as to why it has its own responsibilities towards officials, players, umpires, coaches, administrators, above all the cricket-loving public. My lord, all facts cannot be, my lord, mathematically, my lord, same. Visualize here, your lordship. All foreign countries, my lord, almost 10 to 12 are participating. They are the guest of the state now. It's not the guest of the guild. Now, one of the public function, the inauguration date is done by the Malad. In this year, I think the state of German. Yeah. Every year, Malad, this is selected by the state. Malad, then your losses will find 223. While considering the status of the board vis-a-vis Article 12 of the Constitution, the central government's reluctance to interfere with day-to-day affairs or allowing it to work as an autonomous body, non-assistant in terms of money or the administrative control thereover may not be of much relevance, as it was not only given de facto recognition, but also it is aided, facilitated, supported in all other respects by it. But kindly take note of this, your lordship. This is aided, facilitated, and supported by the state of West Bengal. Then your lordship 224. It would not be correct to contain that a monopoly status upon a body must be conferred either by a statute or by the state by issuing an appropriate order in that behalf. The question as regards exercise of monopoly power by the board must be determined having regard to the ground realities. It not only represents the country, but also controls and regulates the entire field of competitive cricket. Then your losses will find paragraph 273. Well, that's conclusion, your lordships. All other paragraphs are very vital. Well, I am saying according to me. We are considered view. The writ petition under Article 32 of the Constitution is maintainable and it is ordered accordingly. Well, on this aspect, I will show another judgment. अच्छा ये मतलब 2015 3SCC page 251 251 मतलब paragraphs your lordships 20.1 what I'll be citing before lordships मतलब we have heard the counsel for the parties at
paragraph
20.1 मतलब main paragraph 20
yes.
We have heard the counsels for the parties. Then you know whether the respondent board of control for cricket in India is state within the meaning of Article 12, and if it is not, whether it is amenable to the jurisdiction of the High Court under Article 226 of the Constitution of India. Now, your lordships, paragraph 22 to 35. I'll just your lordships some of the relevant portion I will show. Manal, your lordships will find paragraph 22. Now, my lord, from the bottom, Malad, 6 to 8 line, Malad, it is unnecessary. His loss is getting that after skip over.
Yes, yes.
First, it is unnecessary to refer to all such decisions pronounced over the past few decades, not only because the law is by now fairly well settled by the Constitution bench decision of this court, and also because the question whether or not BCCI is a state within the meaning of Article 12 may not make any material difference to the case at hand, In view of the admitted position, the respondent BCCI does discharge several important public functions which make it amenable to the jurisdiction of the High Court under Article 226 of the Constitution of India. We may all the same refer to a few landmarks on the judicial landscape only as a reminder as to what settled and binding upon us. Well, the very next paragraph, your losses will find the last few lines. A constitution bench of this court answered the question in the affirmative by majority in his concurrence to hold that even when a corporation is privately performing a public function, it is bound by constitutional standard applicable to all state actions. Then paragraph 24, the last two lines. The US Supreme Court upheld the contention and declared the administration of public bodies like a town through private entities was tantamounting to carrying out the function of public body. Private right of the corporation could therefore be exercised only within constitutional limitations. Then your losses will find paragraph 26. The last few lines your losses will be the same paragraph. While holding that there is no cut and dried formula that can be provide an answer, the court referred to the American decision such and such and to declare that if the functions of the corporation are of public importance and closely related to governmental functions, it would be a relevant factor in satisfying the corporation as an instrumentality or agency of the state. Here your losses, my submission, I just written. What gets the character of public importance and governmental functions? In course of days, it's really, gradually changing. What was not public importance yesterday, today it becomes public importance and governmental functions. In our extreme school days, we didn't have any fear. When we crossed the hurdle up to school life, we got this fear. Now this fear, therefore, gradually it has got the public importance and it amounts to governmental functions. Now your losses will find paragraph 27. This is Ajay Hashiya losses referred to. The last the 4 lines, middle portion. But any such contrivance of carrying on such activities cannot declare this court exonerate from the government of its basic obligation to respect the fundamental rights of citizens. For otherwise, it would be the easiest thing for any government to assign to a plurality of corporations almost every state business and thereby cheat the people of this country of the fundamental rights guaranteed to them under the Constitution. The court went on to enunciate certain tests applicable for determining whether entity is an instrumentality or not. Now, paragraph 28, I just, Pradeep Kumar Biswas, we all have your losses. Kindly see the last 2 lines of paragraph 28 of this page. The question in each individual case, declared this case, would be whether on fact the body is financially, functionally, and administratively dominated and or by or under the control of the government. Such control must be particular to the body in question, must be pervasive to make such body state within the meaning of Article 12. Mere regulatory control, whether under statute, would not be sufficient. Each of the annexure I take your losses will show your losses. Financially aided, functionally controlled by, administratively controlled by the state by giving all infrastructures, even if the total police help. Otherwise, they cannot control this function. They cannot hold this function. 27 lakhs lok last year visited this book fair. So this is not a function of just by the guild. This has partakes the character of public interests and government functions. Then your lordships, the
up to 35.
I'm referring up to 35, but showing your losses to cut short the issue, the only relevant portion. But kindly have a look at your losses, paragraph 32. Having said this court, having said that this court recognized the fact that the board was discharging some duties, like the selection of Indian cricket team, controlling the activities of the players, which activities are akin to public duties, or state functions, so that if there is any breach of constitutional or statutory obligation of the rights of other citizens, the aggrieved party should be entitled to seek redress under the ordinary law or by writ petition under Article 226 of the Constitution of India. Then, Malad, paragraph 33. The majority view thus favors the view that the BCCI is amenable to the jurisdiction of the High Court under Article 226, even when it is not a state within the meaning of Article 12. The national underlying this view, if we may say with utmost respect, lies in the nature of duties and functions which BCCI performs. It is common ground that the respondent board has a complete sway over the game of cricket in the country. It regulates and controls the game to the exclusion of all others. It formulates rules, regulation, norms, standards covering all aspects of the game. It enjoys the power of choosing the members of national team and the umpires. It exercises the power of disqualifying players, which may at times put an end to the sporting career of a person. It spends crores of rupees on building and maintaining infrastructure like stadia, running of cricket, academics, and sporting state auctions. It frames pension schemes, all that. Malad, pause here for a moment. May I, Malad, compare it? Now, today, you are selecting this will be publisher, will be allowed. Is organization publisher? You will not be allowed. Publisher, but organization, it's not be published. Malad, this takes Malad violation of Article 14. Because I tell you, I have a right to expression. I can circulate the books in the international field. This is not a Malad book fair in any club or Malad local area. It has an international impact. So I can, Malad, even if your loss is I have the religious books, religious tenets, it can, Malad, percolate throughout the world through this or Malad Mala. So you have the entire control. State says, I have nothing to do with it. Now, what you are doing, Gil, you are selecting the persons you can do, you cannot do. Even we are the publishers. We have the books of all. Then your lordships kindly consider Malad, the last Malad, a few lines of paragraph 33 at page 282. I don't know, Malad, it will tell you or not. Any organization or entity, has you also got that one?
Yes.
That has such pervasive control over the game and its affairs and such powers as can make dreams end up in smoke and come true cannot be said to be undertaking any private activity. You are putting end to my Malad publishers Malad functioning. I can't Malad percolate my ideas, my tenets, my thoughts, maybe on religious education. It's a societal and religious education. I run the schools, I run some other. That's not material. Material, what I am giving to this. This percolates the idea of Malad. We sell Malad Gita in all version. We sell all books of Swami Vivekananda. We sell all books of any Malad of Netaji Subhash Chandra Bose. This we percolates our thoughts, exchange of views. One can say the Hindu is not a good religion. That's another aspect. Not because it's a non-Malad religious organization, religious and social organizations. Because our name shows Vishwa Hindu Bharta. So I am clear, Malad. In our consensus is clear. So only one can Malad ask and question when it has happened. Some people comes and Malad interrogate us. What's your thought? We have to answer it in that book fair, in that stall. So this is the book fair. These are disseminating expression of view. You are throttling it by this action. So this is the power of the state. Initially, the state could not think over it when it was started in 1976. Now this is being done. So this is the way that's nearer to public function, akin to public functions. Now, then your lordships, the paragraph 34, the functions of the board are clearly public functions, which till such time the state intervenes to take over the same, remain in the nature of public function, no matter discharged by society registered under the Registration of Societies Act. Suffice to say that if the government not only allows an autonomous or private body to discharge functions which it could in law take over or regulate, but even lends its assistance to such a non-government body to undertake such functions, which by their very nature are public functions. It cannot be said that the functions are not public functions or that the entity discharging the same is not answerable on the standards generally applicable to the judicial review of the state. Then Your Lordship, paragraph 39, 35, it's answered in the affirmative. Lord, I think, my Lord, these are the best two decisions where it determines whether a private body, admittedly a private body, functions in the nature, public functions or akin to public functions, which can be served by the government, Your Lordships. My Lord, then, Your Lordships, my Lord, it comes within the purview or sweep of Article 12 of the Constitution. They have the selecting power. These have the, my Lord, other judgments, my Lord, because state has, my Lord, the authorities has not gone into that. That's why I'm not saying it. Well, these are my submissions in regard to this.
This is with regard to maintainability issue. And you contend that you are a publisher.
Publishers. If Your Lordship, section once, my Lord, since Your Lordship is taking me kindly, because this was the all throughout. This year, this is organization. As a publisher since evening, because the publishers and book sellers, that their contention in the earlier writ petition, which was Your Lordship was pleased to dismiss, that was the contention. Kindly see paragraph 24 and the Act section 3(5) of
Paragraph 24 of
page 24.
Page 24.
Read. Plus, the book is under this act, the book is registered. This certificate contains the printer's name, publication, place of publication, everything. This Pritam Mukherjee, Your Lordships, will find, at least keep one book, Your Lordships, all throughout on the basis of this, they, so long they have allowed it. It's in the, on behalf of the Vishwa Hindu Petition. It's a religious societal organization. Somebody has entrusted his duties. Do it. Because it's a voluntary act. It's a voluntary act. So, my Lord, as a body like others, my Lord, we cannot. We cannot, because I am personally involved. That's what I'm saying. Some duties have to be assigned to me. And, my Lord, absolutely pro bono. So, this person is doing his job. He is doing something, my Lord, somewhere service. The rest of the time he is doing. So, he has been entrusted with this for Vishwa Hindu Petition. The entire thing, Your Lordships, will find. The book is registered. My Lord, Your Lordships, section. This is the title of the newspaper. Your Lordships, any, suppose Your Lordships, my Lord, Ananda Mela. It's a Patrika name, my Lord, the magazine's name. This is, my Lord, done by Ananda Baja Patrika group of companies. Any book, Your Lordships. Your Lordships, that is clear from section 33(5). Everywhere Your Lordships will find this, and giving Your Lordship. Now, Your Lordships will find section 9 of this Act. Section 9 says copies of books printed after commencement of Act to be delivered gratis to the government. If Your Lordships, I am not taking to the entire section, Your Lordships will find this has to be given not only to the central government but to the state government for protection, keeping its copy and register. Every year, this has to be done. Your Lordships will find this in this section. Gratis to the government. Without free of cost. Because government has to keep its record. That's why this act. It's not the publishers. Your Lordships will not find anywhere the publisher's details has to be furnished, except section 3 that you have to record. That's why, my Lord, I have shown the book. I have a next, my Lord, referred to these books, that this is the publishers. Entire thing is done by them. It's an organization does it. Now, Your Lordships will find one of now, Your Lordship. My Lord, 19C. Kindly see. My learned friend referred to this. On receiving from the magistrate under section 6 a copy of the declaration in respect of a newspaper, and on the publication of such newspaper, the press register shall, as soon as practicable thereafter, issue a certificate of registration in respect of that newspaper. Clear to Your Lordships? Kindly have a look. This has been issued by the Register of Newspaper for India, page 24. So this is registration is given to that publication, newspaper, book, not the publisher. All publishers are like Tom, Dick, and Harry. Only the book, because some responsibility some has to taken. Editor has to be given. So this is the object of the act. It's not given to the publishers. So this is your losses will find all throughout, and all throughout your losses will find what is their mode of First they say in the letterhead, I applied. The documents I say your loss English version, Bengal version, I catalog. Last 11 years I have submitted the catalogs. This year also. These are not such technical persons that one for you could have asked it. So they vary their arguments one by one. If you also currently remember the first they say sensitive. They went back and thought this is very vulnerable area. Now today's a prevailing situation. I don't know how my learned friend will stay, learned advocate general will prevail, because what my learned friend wants to do the prevalent situation is not good. So that's why they cannot. It's not that. This was submitted. So this is the way they, and your losses can see publishers and guilds. I have seen, this is my that best I can show your losses. These are my humble submissions.
Maintainability issue. I was trying to avoid it.
Yes. But your lordship cannot avoid it because
Can't help. It's already
yes.
5:22.
We can come back tomorrow. It's for almost 5:30. কবে আছে তোমার লাস্ট কালকে করলে
শুরু হবে 28
আজকে দেরি আছে তো tomorrow. Or I can address your lordship here and
The
now.
judgment has to be prepared because the way the submission are being forwarded,
Yes.
then a judgment has to be there.
Right,
So
right.
you have to give some time to the court also
Right, right.
to prepare the judgment.
But if your lordship desires, I can address here and now. Or if your lordship wants to defer it till tomorrow, I don't think anybody has any difficulty. Tomorrow, say.
And if the court is prima facie of the opinion that something may happen if the fair is stalled, then it will be something.
They will, whatever falls from my lordship, will.
I do not know. This is the thing that I have to make up my mind.
My lord, tomorrow morning keeps it below.
And the entire list gets stalled.
No, please keep it made in the second half so that first half your lordship can take up some matters.
I tell you also keep it in the first half, take up in the second half some, because it's an importance.
I hear it. Whether I hear it in the first half or the second half, judgment will come later on. I cannot deliver it immediately. Right? So,
to answer Mr.
not in piecemeal. Not in piecemeal. I will hear at a go.
I'll take 15 minutes of my lord's time.
Then kindly keep it in the morning, well, half an hour for me, 15 minutes for him, and no reply for Mr. I told him I have advised him not to. I have advised him on behalf of the court not to take up any pro bono matters. This is see what happens.
4 o'clock tomorrow, 4 or 3. I do not know whether they will be early rising or not.
Three,
very difficult. 3:30.
अरे 45 मिनट तो लागবে তো
3:30 হয়ে গেলে প্রবলেম
তাহলে তো
So
তখন
it will
থেকে
continue. This is the reason.
হয়ে গেছে সকালে
This is the idea that it will continue, irrespective of whether there is an early rising or not.
Very good.
Do you get it? Tomorrow at 3 o'clock in that case.
Very good.
Heard submissions made by the petitioner. Is for further hearing tomorrow at 3 p.m.
এই কালকে আর প্লিজ জাজমেন্ট ফাজমেন্ট এনে ঝামেলা করবো না
ফাইলটা পাঠাবে
শেষ হবে নাকি
ফাইলটা পাঠাবে
পেছনে একটা লোক বসিয়ে রেখেছো কাকে একটা বসিয়ে রেখেছো কি সেই লোকটা কামান জল কামান
Tomorrow I will require a list of the allottees who are the other countries
who have come in.
y'all are inviting and how they are treated, the state facility. Yes, the state facility granted to them.
Telling your lordship, all this is done at their own expense.
Own means the countries.
Neither us nor the state. Nobody's involved. We said
Y'all are sending out invitations.
and sending invitations. That's about it. That's from our part. The state has
Yes.
got nothing to do with it.
Yes.
He decided. There's that board miller who decides which company or which country has to go, and it goes there. The state has got nothing to do. And your lordship will find very importantly at page 24, there's a publisher's name given. He is saying that my premises is being used, that's why I've become a publisher. No, the publisher's name has been given there. And it's our requirement, my lord, in our rules, that it's only the publisher. So if Pritam would have come in, then my lord, we would have had to, my lord, decide, keeping in mind Pritam. But Pritam,
Whoever it is.
So the publisher, my lord, is not Bisho Hindu Parishad. My learned senior friend very clearly admits that. He says that Pictorud is doing it for VH.
But
So
that's
my
the
lord, any
previous book.
employee cannot become, my lord, a publisher. An employee of a publisher is not a publisher.
This is not an employee. He's an authorized Karmakarta of the Vishwa Hindu Parishad.
Where is that said in the petition? May I ask this question?
That's your lordships will find from the book itself on behalf of the Vishwa Hindu
Corners
Parishad.
of the writ petition of the pleadings, not a line to that. Not a line to that.
Master 7.
You will address it in your own way.
3 o'clock tomorrow.
3 o'clock tomorrow.
I'll